As most of you know,
This meeting is being recorded.
as most of you know, April is Fair Housing Month, and this year marks the 54th anniversary of the passage of the Fair Housing Act. 54 years later, the Fair Housing Act still serves as a powerful tool and catalyst for ensuring equality, equity, and in our housing system. It guarantees that people have the right to obtain housing regardless of their race, color, gender, national origin, familial status, disability status, or sex. This month's Fair Housing Month theme, fair housing more than just words, is especially fitting, especially as we adjust to this new normal as a result of the pandemic, which exacerbated our nation's already severe housing crisis. As we try to build, as our country tries to build back our financial and public health systems as a result of the pandemic, the current administration has made delivering housing relief a top priority. So I cannot overly stress the importance of all of us taking the Housing Act. I'm sorry, can you guys hear me? I just heard some background noise. I apologize for that if that were an issue on my end. So speaking of action and a call to action, I want to commend the Greenville Human Relations Commissions for its efforts in advancing equity in housing. As I was preparing for today's opening remarks, I noticed that the Human Relations Commission collaborated with the Greenville County Redevelopment Authority, the City of Greenville, the Greenville Housing Authority, and the Greer Housing Authority to collectively prepare the 2020-2024 analysis of impediments to fair housing choice. I am always especially impressed when jurisdictions and local organizations opt to partner to submit fair housing planning documents like the analysis of impediments, because it typically indicates that the parties that are collaborating are taking a very thoughtful approach to identifying and addressing fair housing issues. Fair housing issues and problems and situations, they cross jurisdictional lines. So when you conduct a regional analysis and an analysis that includes the perspectives of neighboring jurisdictions, the input and feedback of local organizations, you have a more accurate assessment as to what the gaps are, and you can collaborate to develop a regional approach to addressing those gaps. You can not only collaborate, but you can also combine resources. So I want to take this time to applaud the Human Relations Commissions and all of the partner agencies that work together to develop the most current analysis of impediments to fair housing choice. So thank you all for that effort. While we often think that housing discrimination is something that is racially driven or mostly racially driven, it's not a surprise that most of the housing complaints filed in our region are disability related. Disabled Americans especially also face significant fair housing challenges. Most of the complaints filed between 2019 to date nationwide were based on disability, and complaints in South Carolina also aligned with the national trend. When I looked at the numbers for the last 3 years, over 56 of the complaints filed within the state of South Carolina were filed on the basis of disability. So I say all that to say that although we've made very significant strides as it relates to combating housing discrimination, whether it be racial, familial status, disabled, we still have a lot of work to do. Disparities in home ownership still exist. Discriminatory housing appraisals still exist. Systemic discrimination still exists, even in 2022. So as we commemorate the 54th anniversary of the passage of the Fair Housing Act, I challenge all of you to continue to strengthen your efforts in creating strong, sustainable, inclusive communities and affordable housing. I look forward to addressing any comments that you have, any questions that you have, and the Q&A session later today. And I just realized I did not properly introduce myself. I am Ashley Lowe. I am physically located in Jackson, Mississippi, but I am the Programs and Compliance Director, Fair Housing Director that overstates over Mississippi, South Carolina, and Tennessee. So we handle not just fair housing complaints, but we make sure that the jurisdictions and the PHAs, the public housing authorities that receive federal funds, are compliant with not just the Fair Housing Act, but all the civil rights authorities enforced by our Office of Fair Housing and Equal Opportunity. And those authorities include Title VI, they include Section 504 of the Rehabilitation Act, they include Section 109. It's a gamut of other civil rights and authorities that we enforce and maintain and ensure compliance. So I say all that to say it has been an absolute honor to give opening remarks this morning on behalf of our department and our assistant secretary. We always welcome the opportunity to have some face-to-face interaction, even if virtual, with the organizations that have their feet on the ground, so to speak, and serve the populations and the constituents that we serve, our clients, the public. So again, thank you, Dr. Duckett and the Greenville Human Relations Commission for inviting me this morning. It has been an absolute honor, and I look forward to speaking with you guys later on. Thank you.
If you have questions, virtual visitors, if you have questions, make certain that you type your questions in the Q&A section. I think it's located at the top side of your phone or your laptop or your whatever you're using. So make certain that you type your questions in the Q&A. Those of you who are in person, we're going to ask that you hold your questions to the end of the speaker's topic. And then if you have a question, you can raise your hand. We have microphones here in the center, and we also can bring the microphone to you if you're not able, if you don't really want to come and to the front of the room. We're asking that all of you, I see all of you have cell phones. We're asking that you download the CVent app on your phone. The reason, because we are going to ask you to complete a survey. And the only surveys that we can accept would be the ones that are online. So there are instructions on the tables here. So if you would please, ma'am, and please, sir, if you have not downloaded the app, go ahead and do that now, because we also have an activity at 11:30 where you're going to need your phone. So you can go ahead and do that now, and we'll be more than happy. If any of you are having problems doing that, we have my staff here. They will be able to assist you with that. Let's see what else I have here. Make certain that your phones are muted, please, ma'am, and please, sir, so that it won't disturb our audio systems. I'd like to recognize my staff. They're recognizable, as you can see, if you all would just wave your hands. I'd also like to recognize our commissioners. If we have any commissioners here, would you please stand or just wave your hand? Thank you for coming this morning. Okay, I think that's all of the, if you need to use the restrooms, and you go out this door to the left and to the left again, you will find restrooms for men and for women. Okay, I don't think I've forgotten anything, but if I have, I'll be back. Okay.
Okay. Oh, there we go. Just screamed into the mic. Hey, everybody. My name is Tina Belgian with the Greenville Housing Fund. First, let's give a big thank you to Ms. Lowe, who spoke just before. Let me give her a hand. And we are going to jump into our first session today. So I'm first going to introduce our speaker, Adam Prothero. Adam attended law school at the University of South Carolina, where he served as a board member of the Pro Bono program and as a member of the Public Interest Law Society. He received the Outstanding Pro Bono Service Award in 2008. From 2007 until 2010, he worked with the South Carolina Department of Consumer Affairs, focusing on issues related to mortgage lending and mortgage fraud. From 2011 until 2018, Adam worked with South Carolina Legal Services as a staff attorney and ultimately as head of the housing unit, where he handled civil litigation matters for low-income clients. He was named the Ellen Hines Smith South Carolina Legal Services Attorney of the Year in 2016. He joined the South Carolina Appleseed Legal Justice Center in 2018 and directs Appleseed's impact litigation efforts on behalf of low-income South Carolinians. Before I bring Adam up to the stage, just a few reminders. So Dr. Duckett mentioned the evaluation that's going to be on the attendee hub that you can fill out post-session. Also, if you could hold your questions until the end of this presentation for question time, and if you'd submit in the Q&A section again, not the chat section, we will be monitoring for those, both online for those attending virtually, and if you will raise your hand if you're here in person when we get to the Q&A session, if you have a question. Thank you so much. And further ado, here's Adam.
Thanks, Tina. I'm afraid that bio is probably the most impressive thing that you're going to hear about me today, or that's going to come out of my mouth. I apologize for that. I'm going to have to downplay one of these days. So as Tina said, I work for South Carolina Appleseed. Appleseed is an advocacy organization for low-income families. And we do work that kind of runs the gamut. It includes housing work, but it also includes things like working on child welfare issues, utility rates, kind of all over the map. So but it does include fair housing work, and my work is as Appleseed's litigation attorney. So I focus on our impact litigation, which includes fair housing cases. Shortest lawyer disclaimer ever. This is not legal advice. I'm a lawyer. I'm not your lawyer. We understand? We all good? Okay, moving on. So I want to start first with a little history of the Fair Housing Act. It's a little history lesson. It's the history of fair housing is kind of tied up with some of the most formative events in our nation's history. And it really begins post-Civil War. The 1866 Civil Rights Act was the first promise of fair housing in our nation's history. Passed in the wake of the Civil War, it says everybody that's born in the United States are citizens regardless of race, color, or previous condition of slavery. And it prohibits discrimination in work and in housing based on race, among other things. So discrimination is over, right? Maybe not. This is one of my favorite common law judges, Justice Learned Hand, and he had a way of saying, basically, liberty is not just a matter of laws. Liberty lies in the hearts of men and women, and when it dies there, no constitution, no law, no court can save it. No constitution, no law, no court can even do much to help it. Resistance to equality was fierce and often violent. Retrenchment after the end of Reconstruction was a big theme that we saw, particularly in the South. Post-Civil War constitutional amendments, including the 13th, 14th, and 15th Amendment, which ended slavery, guaranteed equal protection, and guaranteed voting rights, were in many respects just words on a page for a very, very long time, and to some extent continuing to this day. The next real chapter in that history of fair housing really starts to take place in the Great Depression. The reason this is so is because this marks the first real federal response to an economic crisis and federal government involvement in the housing system to a degree that was never before seen. The Great Depression was, triggered by a number of factors, including a stock market crash in 1929, Dust Bowl, economic inequality, and other factors. Home ownership rates in the wake of the Great Depression reached their lowest level of the 20th or the 21st century. It was around 44%. Last I looked, it's around 63% or so currently. So in the wake of the Great Depression, the federal government gets involved with what's best known as the New Deal. The feds enacted policies to help because essentially banks weren't lending. The money supply had essentially dried up. Down payments were often required of somewhere in the range of 50 to 80% for a house. People just couldn't get homes. So the feds step in, begin to insure new mortgages. They buy up existing mortgages and refinance those mortgages when they're already in default. That sounds like a familiar story because we saw not exactly the same thing, but some similar sorts of efforts here recently. And it worked in a way. That money supply that had dried up in the wake of the Great Depression really things started to flow again. Down payments again fell back to that 20% range that we're relatively familiar with here lately, although we see 0% as well. But there was a problem with that. The assistance was not provided on an equal basis with respect to race, particularly with respect to race. The HOLC and FHA essentially were the mechanisms that were used to provide the financing in the mortgage assistance. And they essentially said that the presence of African Americans in a community would cause property values to decline. That was kind of the presumption that they made, despite the lack of evidence of that. And this is really structural racism at work, because that presumption got built into the systems that lifted some boats and not others. So because the government didn't put money into these communities, home values declined. Without subsidized loans, African-American families paid more for housing. They had less money for repairs. There was overcrowding in these areas, and infrastructure tended to decline. These policies perpetuated segregation where it existed, but it also created it where it didn't exist through a policy known as redlining. And this is one of the redline maps of the Homeowners Loan Corporation from, I think this is 1935 in any event. And this was a process of essentially creating segregation where it didn't. And this was an express policy of the federal government. So this is from the an underwriting manual that was used for FHA mortgages. Naturally or artificially established barriers will prove effective in protecting neighborhoods and locations within it from adverse influences, which include, among other things, inharmonious racial groups. And this wasn't just a policy that was expressed in writing, it was expressed in concrete. This is what's known as Detroit's segregation wall. It was erected as part of FHA financing of a neighborhood. It was required by the FHA before they would finance the neighborhood, essentially, to segregate African-American neighborhoods from white neighborhoods. So after the Great Depression, I'm glossing over a whole lot of history here, but essentially controversy continues. Then things really start to come to a head in the beginning and throughout the middle of the Civil Rights Movement. In the 1960s, communities had been excluded from a lot of the post-World War II economic boom that had lifted so many families up, and families that now still benefit from the wealth that they generated largely through their homes. 1967, there were riots in Detroit, Newark, Minneapolis, Milwaukee. Cities essentially were burning. This followed a long history of racial unrest, but things were really coming to a head in the late 60s. And in response to that, the Johnson administration commissioned the Kerner Commission and issued a report that essentially found that, there's a couple of quotes from the Kerner Commission report, that our nation is moving towards two societies, one white, one black, separate and unequal, and that white society is deeply implicated in this. The Fair Housing Act is something that had been tried before. There had been efforts to enact legislation to enshrine the right to be free from discrimination in the housing market before. As we saw, as early as 1866, there had been attempts to make that happen. On April 4, 1968, Dr. Martin Luther King Jr. was assassinated. By April 11th, the Fair Housing Act was enacted. This is a large part of Dr. King's legacy and something that he had pushed for. Past 7 days after his assassination, 102 years and 2 days after the 1866 Civil Rights Act that was supposed to guarantee at least some of the basics of what the Fair Housing Act ultimately guaranteed. And it prohibits discrimination based on the categories listed there. Race, color, national origin, and religion were part of the original act. Gender was added in 1974, and then disability and familial status were added by amendments in 1988. When we use the term familial status, that refers to having someone under the age of 18 living with you. So basically having kids living with you. They don't necessarily have to be your kids biologically, but that's what familial status means. And it prohibits a variety of different types of discrimination. Now, these that I've got listed here focus on rental housing. There are other kinds of types of discrimination that deal with mortgage lending and insurance that I'm not going to focus on so much here because we are focused on, I think, primarily rental housing in this presentation. But it includes things like refusing to rent, denying or making a dwelling unavailable, discriminating in the terms or conditions of a lease, basically giving one person different or better terms because of race. Discriminatory evictions, making any statements or advertisements that suggest a preference, or refusing to make reasonable accommodations for a person with a disability. These are just the statutes that these come from. I think this presentation will probably be made available to y'all. I'm going to breeze through some of these slides because we got a fair amount of stuff to cover. So there are several different mechanisms of enforcement, of private enforcement and public enforcement. HUD has some enforcement authority when it comes to enforcing the anti-discrimination provisions of the Fair Housing Act. The South Carolina Human Affairs Commission also has some enforcement authority. And there is a private cause of action. Individuals can bring a lawsuit if they feel that they have been discriminated against or have suffered as a result of discrimination. And these are just, I mean, you have, since from the time of discrimination, an individual can bring a complaint with HUD. You can bring a complaint with the Human Affairs Commission. There's slightly different timelines for each. And there's a different timeline entirely for filing a lawsuit. So here's the question. And I know Dr. Duckett said at the beginning that it does still matter. And let's take a look at that. It's let's take a look and see what whether it still matters looks like. So sometimes folks argue that when you see neighborhoods that seem segregated based on race, you see black neighborhoods and white neighborhoods, people are just making a decision to live around folks that look like them. Well, let's dig into that just a little bit. If every place was as good as every other place, then maybe that might make some sense. Here's a map of City of Columbia. The darker blue areas are greater percentage African American. The darker green areas are greater percentage white. If you're familiar with Columbia, you understand this dynamic. You've probably seen this dynamic in the city. Let's take a deeper look at this. And so this map's a little hard to read, so I'll do a little explaining. The darker the background, the better the schools. This is a measure, I think, at fourth grade level proficiency in reading and math. So we're looking at how well younger kids are performing in schools. Darker the background, better the schools. The green dots represent population density of African American families. Orange dots, population density of white families. So green is black, orange is white, dark is good, light is bad. If all that makes sense, you can see that there's a concentration of white families in better schools and a concentration of African-American families in worse schools, all else being equal. So just looking at place, not all places are equal. And you can see where those concentrations based on race overlay with school quality. This is another interesting thing that I ran across here recently. 29203 zip code in Columbia, and you'll forgive me for focusing on Columbia, that's kind of where our office is based, but you'll see these same kind of patterns in other places. There's a good article in The State about diabetic amputation rates by zip code. And hopefully, looking at the previous map, you can see that 29203, that's basically the darker African-American, more heavily concentrated triangle that we're looking at earlier. And it is the highest, I believe, if I remember it right, it's the highest diabetic amputation rate of any zip code in the South with 39,000 or more residents, so relatively high population density. So there's a health connection here too. So we're talking education, we're talking health. Here's Atlanta. Atlanta's this is kind of a jumble of a map, but you can kind of see towards the center where everything gets really dense. That's basically downtown. South Atlanta, North Atlanta. You can see the same pattern with school quality and with with the racial composition of different neighborhoods. And that ain't just a Southern thing. This is Bridgeport, Connecticut. That pattern is pretty stark. So you see worse schools towards the center. You see a bit more, I can't remember, the blue dots are Hispanic or Asia. I can't remember which it is, but in any event, you do see the pattern of essentially leftover white flight and school quality and school investments being in areas where minorities don't live. And it's not a new thing. So these two maps, again, this kind of jumble of colors. So bottom right is the red line map for Detroit. This is 1934, 1935. These are the neighborhoods. The red neighborhoods are the ones the FHA said, we're not going to lend there. Above on the left is the same map comparing education, comparing racial composition. And you see a pretty solid similarity between the two. Disinvestment that started happening in the 1930s is reflected in patterns today. So this is nothing new. So let's talk a little bit about the Fair Housing Act, what it prohibits, and identifying different types of violations of the Fair Housing Act. So covered housing is almost anything, honestly. It includes, the definition of a dwelling under the Fair Housing Act is pretty broad. Includes vacation homes, residential hotels, migrant housing, dormitories, nursing homes, group homes, homeless shelters, as long as somebody's living there for quite a while. It covers quite a lot of housing. There are relatively few exceptions to what kind of structures are covered. Now, there are some exceptions to that, and there are some situations where a structure that might otherwise be covered is treated a little differently because of who owns it or how that ownership is held. So if a private property owner does not own more than 3 single-family homes, so if you don't own more than 3, you're not strictly covered by a lot of the provisions of the Fair Housing Act. There's also what we call the Miss Murphy exception, which is basically a quadruplex where little old Miss Murphy owns the building, lives in one of the units, rents out the other 3. Those things aren't strictly covered, but there's one big exception to the exception, which is if you make a statement or advertisement that indicates a preference, no kids, no Muslims, no Black people, something like that, it doesn't matter. These exceptions don't apply. So if little Miss Murphy puts out an advertisement for one of the units in her building that has any kind of a discriminatory statement or indicates a preference, little Miss Murphy is going to be covered by the Fair Housing Act. There are a couple of different ways to prove discrimination under the Fair Housing Act. And the first one is a little bit more intuitive than the second, but the second is probably currently a lot more important than the first, at least it is to folks who litigate in this area. Disparate treatment is basically an action that on its face treats someone in a protected class differently from someone who is not in a protected class. There's an example, well, I don't use that one, that's complicated, but basically saying no kids. You're treating somebody differently because they have kids and versus somebody who doesn't have kids. That is a protected class. That's familial status under the Fair Housing Act. Disparate treatment is pretty clear. Disparate impact is a lot trickier, but in a way it's a lot more important because it's designed to get at discrimination with a smile, discrimination that is effective but unintentional. And it's important to know that the Fair Housing Act does cover discrimination that's unintentional. If you have discriminatory effects, you can potentially be liable under the Fair Housing Act. So I talked a second ago about examples of disparate treatment: apartment for rent, no, Black people, kids, women, Muslims, et cetera, whatever. Clearly disparate treatment. We don't offer mortgage loans in Black communities, disparate treatment. We don't offer renter's insurance to people with mental illness, disparate treatment, disability. Disparate impact, and we'll talk probably a lot more about disparate impact than disparate treatment because it's a trickier subject. We reject all applicants who have been arrested in the last 5 years. Let's think for a second, why would that be disparate impact? Well, there's a pretty significant racial disproportionality in interaction with law enforcement. And so I'll get into a little bit more of this later, as long as I left myself enough time. Why arrested is an important word in that context, because arrested really doesn't give you much of anything useful. It's not proof that somebody did something wrong. Convicted can get a little bit more complicated, but I use arrested because arrested doesn't tell you anything, and you're going to disproportionately screen out more African Americans, more minorities if you have this rule than if you don't. There are ways to use criminal records that are probably legitimate, but going too broadly can be a problem. If the police are called to your house more than 3 times, you'll be evicted. Well, who might that discriminate against? One good example is someone who's a victim of domestic violence, who are disproportionately women. And so having this rule may have a discriminatory effect. Now, I'll get in a second, just having a discriminatory effect isn't enough. There's a little bit of more of a back and forth, which I'll touch on in a second. But just think about for a second, what does it take to have that discriminatory effect? And it's kind of a 2-step process. You have a rule that doesn't expressly say, I'm going to treat this group differently, but it has the effect of doing so. And so those are things to be careful about. A 9 p.m. curfew for all children under 18. That potentially, again, could have a disparate effect or discriminatory effect against people who have kids living with them. This is the back and forth, though, that we get into with disparate impact liability, because just showing that there's a discriminatory effect, if I bring suit under the Fair Housing Act and I show a discriminatory effect, that's not enough. I have to show that there is a link between the policy I'm complaining about and the effect that I'm complaining about. So let's say an apartment complex screens out more Black people than white people. I have to point to the policy, define the policy, and show how that policy is causing that effect. That's step 1. And that's a big step for a plaintiff or somebody who's bringing one of these cases to take. But it's a very important first step. The second step, though, is the defendant, the landlord, the property owner, can show that there is a valid interest that's served by what they're doing. So just having a discriminatory effect isn't enough. If there's a valid reason for doing what they're doing, that might be enough to escape liability. Because I think the law recognizes that not all discriminatory effects are, or at least will be considered illegal. It gives room for policies that are necessary to serve some kind of legitimate business purpose. So for the criminal records example is a good one. If you're excluding people who've been convicted of arson 17 times in the last 5 years, okay, maybe there's a legitimate business reason why you're doing that, and you could justify based on some legitimate concerns in those situations. If you're excluding everybody who's been arrested for anything in their life ever, that justification starts to get a lot harder to hold up. The last step of this thing, though, is the plaintiff can come back and say, look, I understand that you have a legitimate interest in doing this, like your criminal records policy. Somebody excluding everybody who got arrested, they're saying, well, we have a legitimate justification because this is community safety. We're trying to keep people who are dangerous out of the property. The plaintiff can come back and prove that you could have done that in a less discriminatory way. So your all arrests policy, maybe that needed to be felonies in the last 3 years, or only certain offenses that we really care about. We're not concerned about your speeding ticket in California. We're concerned about, did you burn down your last rental house? That kind of thing. So was there a less discriminatory way that you could have done this? If a plaintiff shows that, then a landlord or a property owner may still be liable for a fair housing violation. There's a back and forth to this. Reasonable accommodations. 1 second. This is always a good topic and one that often gets some interest because there's a lot of misunderstanding around certain types of disabilities, particularly behavioral health disabilities. But reasonable accommodations are essentially designed to allow someone who suffers from some kind of disability an equal opportunity to use and enjoy housing the same way that someone without a disability would. And so what is a reasonable accommodation? It is a change in a rule, policy, practice, or service that may be necessary to allow a person with a disability an equal opportunity to use and enjoy a dwelling. That's pretty much what I just said. There are 3 components to that. I'm going to come back to these. I'm going to define each one of them in term too. So we have, you can break this down into 3 different things. You need a disability. We need to know what that is. That's a term that's not necessarily intuitive. You need, some folks use necessity. I kind of like nexus as a term because you need a connection between the disability and accommodation. An accommodation that just has nothing at all to do with the disability isn't necessarily going to be a reasonable accommodation under fair housing law. So you need a nexus, you need some glue between those 2 things. And then finally, that accommodation, whatever it is, has to be reasonable. And we'll touch on each of these in turn. So what is a disability? A physical or mental impairment that substantially limits one or more major life activities. Y'all get that, right? I mean, that's 100% clear, isn't it? Maybe not. So here's basically, this is stuff that's pulled either from the regulations or from some DOJ guidance on what disability is. The left are some examples. That is not an exclusive list, but is some examples of things that could be considered disabilities. Blindness, hearing impairment, mobility impairment, HIV infection, this is developmental delay, head injuries, mental illness, among others. Really, that list could be almost anything. I like to focus on major life activity a little bit more because whether something is a disability has a little bit more to do with whether whatever it is affects a major life activity than it does whether it appears in the DSM-5 or what it's called on an insurance billing form. So seeing, hearing, walking, breathing, performing manual tasks, caring for oneself, learning, speaking, working. It's again, another pretty broad list. I encourage folks to be open-minded when they think about disability and what its effects are, because in a lot of cases, ultimately, things come down to whether the accommodation is reasonable. But sometimes I've run into landlords or housing providers that want to fight over whether something is a disability. And from a legal perspective, that's a hard fight most of the time, because more and more things have become recognized to have physiological components that are really medical disabilities that may not have been considered such some time ago. That's a hard hill to fight on over whether something is a disability. So here's the nexus question. We'll get to more about what accommodation is reasonable here in a minute. The nexus question, it means there has to be some glue between the disability and the accommodation, whatever the changes folks are asking for. So the accommodation could free someone from a rule or policy that interferes with their right to use a dwelling, enhance their quality of life, or enable them to satisfy essential requirements of tenancy in the same way that a non-disabled person can. I'm not sure that's really that helpful either. So I'm going to do some examples here in a bit so we can kind of get some, I like concrete stuff, and we'll get to a little bit more of that in a minute. So reasonable accommodation. So is it reasonable is the third question. And it is, the answer is yes, unless. An accommodation is sort of presumed reasonable unless the landlord or the housing provider can show that there's something else going on here that's more than meets the eye, or the burden would be really substantial. So if it is an undue financial or administrative burden, remember that word undue. Just the fact that it is a bit of a financial burden or an administrative burden doesn't mean it's not a reasonable accommodation. Some burden is kind of expected, some give and take is expected. It would fundamentally alter the nature of the business or program. So the example I use is a tenant who has a mobility impairment. There's a grocery store fairly close by, but she can't get there. It would be really great, landlord, if you could set up a little bus service or something to give her a ride there. Now that might be a financial burden too, but it could also be a fundamental alteration in your program if you just don't provide that. We don't have that. We don't have that infrastructure. That's not what we are. We would have to fundamentally alter what our business is. That could be a good example of a fundamental alteration. A direct threat. So if granting the accommodation would cause a direct threat to the health or safety or others, or substantial damage or substantial physical damage to the property of others. It's another example of a situation where an accommodation may not be reasonable. So here's some examples. Changing the rent due date for someone who receives Social Security disability benefits or SSI. And these are examples from case law. So somebody, and I think I'll walk through that example in a little bit more detail in a second, but this is, and kind of like why it's disability nexus reasonableness, while all those boxes are checked. Sending copies of letters or notices to a tenant's family member who can help them in handling their affairs, somebody who can't read or is blind or needs some assistance understanding the notices they're getting from their landlord. Allowing an emotional support animal or other kind of service animal in a complex that has a no pets policy, or withdrawing a termination notice or eviction notice for someone whose conduct was the result of mental illness. Those all could be reasonable accommodations. You have to kind of analyze each case by case, but those are all possibilities. How does somebody ask for one of these? There's no set format. There's no form. HUD doesn't require a form, and landlords really, I don't think, can't require a form either in all cases. I mean, you can have a form, that's great, but the law doesn't really let you narrow it down to that if you didn't check the proper box, it's not a reasonable accommodation. They don't have to use magic words. Saying reasonable accommodation doesn't do it. I mean, I put it in my letters, but you don't have to say it. It doesn't have to be in writing. It can be made at any time. It can be made by a third party. And I think this is probably one of the more important points I'm going to talk about when it comes to reasonable accommodations, is that anything that looks like a reasonable accommodation should trigger or could trigger an interactive process. I always tell landlords, the answer can be no, but it should never be no, period. Maybe you can't do exactly what they're asking for, but maybe there's some other way to make it work, right? That interactive process. In fact, there have been courts that have found that where a landlord just said no, period, didn't engage in any interactive process, didn't open the door to any discussions, that by itself is liability under the Fair Housing Act. So keep the door open, be willing to have that conversation, because there are all sorts of ways to address these different issues that people are running into. Something I also get questions about is how do you verify a disability? I've run into situations where landlords ask for medical records or a doctor's statement or things like that. And those will do, but they're typically not required, and you typically can't require them. The person only needs to disclose what is necessary to show that they have a disability, as we've defined it, defined really broadly, right? They don't need to say, I have PTSD. They need to say or show that they have something going on that interferes with a major life activity, and that there's something you can do to address that, or that something you can change or tweak that would help them enjoy the housing the same as somebody else. Don't need medical records. The disability could be obvious. Somebody who's in a wheelchair comes in and says, I'm mobility impaired. Okay, I get that, that's clear. Another example is someone who receives Social Security disability income or SSI. That can in some cases be enough to show, well, they have some kind of disability. Now we may get into a question of, does that disability relate to the accommodation they're asking for? And that's a little bit of a different question. But if you're looking at this in terms of those three boxes, disability, nexus, reasonableness, check the first box, because we've got a disability of some kind. Then move on to the next question. Information from a doctor, a therapist, a peer support group, non-medical service provider, other reliable third party with knowledge, all that stuff could be enough. I had a number of cases when I was at Legal Aid involving behavioral health issues, mental health disabilities, and a letter from a therapist that basically says, you know, this person suffers from these kinds of symptoms. I don't have to tell you exactly what the diagnosis is, what their medical history is, when they were diagnosed, how long they've been suffering, what medications they're taking. They just suffer from anxiety. And when the maintenance man shows up without giving notice prior to, which is a problem for other reasons as well, but when the maintenance man shows up without giving notice prior to, it really freaks this person out. And could you please stop doing that? Aside from violating other law, that's also potentially a reasonable accommodation situation. So I think this is where we start to get into more practical stuff. Yeah, this is some examples. And hopefully this is maybe a little bit more helpful than just sort of the abstract concept. So this is that rent due date example I mentioned earlier of why potentially this could be a reasonable accommodation. So tenant is disabled. They get Social Security disability benefits on the 15th of each month. Rent's due on the 1st. And the landlord charges a late fee after the 10th. Landlord files for eviction because the tenant's rent is late. Again, landlord refuses to change tenant's due date. Is that okay? So let's look at, I mean, if the tenant sort of approaches this from a reasonable accommodation perspective, do we have a disability? They receive Social Security disability income, so that's probably enough evidence to say, oh, we got some kind of disability, right? Interestingly, in this example, like the exact type of disability or the features of their disability aren't really relevant to the accommodation, because it is just the fact that they are disabled is the reason they receive SSD income. That's why the check comes on the 15th of the month. So you don't need to know exactly really anything much more about that, because the connection is made just by the fact that they receive a disability check. The real question comes to, is this reasonable? Is it an undue financial or administrative burden for the landlord to say, okay, your rent's due on the 17th? That's probably a case-by-case question, but that would be a difficult hill to fight on in most cases. To make that small change, to make that small accommodation, you would have to show a pretty significant burden to survive a fair housing challenge on that. So, and there are cases on situations just like that where a landlord refused to change rent due date and liability has been found in those cases. And here's another example. So landlord files for eviction, alleging tenant's been getting into verbal arguments with other residents, calling the police, generally bothering others. Tenants saying basically other residents are persecuting them. Tenant comes to I've got a hearing there. Maybe it's an eviction hearing. Okay. Yeah, they filed for eviction. All right. It comes to the hearing and says she's recently been diagnosed with paranoid schizophrenia and started receiving treatment for it. Landlord still wants her out. Is this maybe a reasonable accommodation situation? I know they said keep questions to the end. Usually I do a little bit more audience interaction with this, but I'll just kind of walk through this and we can do Q&A later. I think there's going to be another panel session on that. So first question, do they have a disability? Well, yeah, I mean, we have a paranoid schizophrenia. That is something that does affect major life activities. Is there a nexus? Is there a tie between what they're asking for and the disability? Well, the behavior that they're saying that the landlord is complaining about is something that is a feature of the disability. Paranoia concerning persecution and things like that are pretty common with that diagnosis. And the question is really, again, what it comes down to is the accommodation reasonable? Are we talking about an undue financial burden? Not really asking about finances here. We're not talking about property damage necessarily. At least from these facts, we're not talking about all the other tenants in the apartment complex moving out. So this example really doesn't implicate finances. Administrative burden, probably not really. Just dismiss the eviction case. I think it's kind of what they're looking for, and kind of give the person some leeway. I mean, they have said that they've started receiving treatment for it. Direct threat. What about that? Let's see. No, I didn't. So I thought I explained it in the next slide. Anyway, question about direct threat. Well, you need, for direct threat, you would need threat of physical harm or substantial property damage of property belonging to other folks. And that really hasn't quite been triggered here on these facts. I mean, you're talking about behavior that's irritating, probably, takes up some time, is probably annoying to some folks. But the way I wrote this, I mean, we're not quite approaching that level of property damage or harm to other people, physical harm or anything like that. So I would say on these facts, you're probably in a reasonable accommodation situation, particularly given, I think one of the mitigating factors for this is the fact that they've recently been diagnosed and they're starting to receive treatment for it. There are cases, and I pull a lot of these facts from actual cases, either ones that I've worked on or ones from other places. And that can be an important factor. in showing that, well, at least there's some chance that this isn't going to really be happening again, right? So it may not be required, but it certainly is kind of icing on the cake in some respects. So let's see, here's another one. Landlord files for eviction, says tenant was involved in criminal activity, offers as evidence that a tenant was arrested for burglary, but nothing else. Tenant's criminal case hasn't come to trial. He denies he's guilty. Landlord says it's their policy to evict if a tenant is arrested for a serious crime. I touched on arrests and things like that a little bit earlier. I think I gotta, well, okay. Well, let's go ahead and go to that one then. Here's why. This is a disparate impact example, not a reasonable accommodation example. So the question in a disparate impact case is first, is there going to be a discriminatory effect from that policy? Right? Remember, the policy is anybody who's been arrested for a serious crime, you're out. Don't care. Don't want to hear anything about it. You're out. Here's where the disparate impact comes from. And this is just some information about how many people in the United, like a third of people in the United States have some kind of a criminal record. We imprison a lot of people compared to the rest of the world. And somewhere around 650,000 individuals are released annually from federal and state prisons. We got a lot of people involved in the criminal justice system, just to begin with. So if you have a policy that is that restrictive, that applies to a whole lot of people. Nationally, the arrest rate for African Americans are more than double their proportion of the general population. I think that's a little higher in Greenville. And often in many places in the South, it's a little bit higher. So that's where the disproportionality based on race comes from, is when you're talking about interaction with the criminal justice system. If you're taking adverse action because of some interaction, whether it's an arrest or whether it's a conviction, you probably are going to have that disproportionate racial impact. So you start from that position of, yes, there is a disparate impact. We'll go back to the example. This is from a Supreme Court opinion in 1957. An arrest by itself is not considered competent evidence at either a criminal or civil trial to prove that a person did certain prohibited acts. An arrest is based on probable cause, meaning an officer thought, probably, you know, it's not enough. It's really not evidence, essentially, to prove that somebody did anything wrong. And so if you're in the context of an eviction case, I have always argued, I haven't always won, but I always thought I always should win. An arrest just doesn't come in. Arrest is not useful information. A charge, honestly, is not useful information because it's based on the same standard. It's not enough for even civil proof, much less criminal proof. So it's not useful evidence in a criminal case. This is from 2016 guidance from HUD. Housing provider with a policy or practice of excluding individuals because of one or more prior arrests without any conviction cannot satisfy its burden of showing that its policy is necessary to achieve a substantial, legitimate, non-discriminatory interest. Basically, HUD says you lose a fair housing case if you have a policy that excludes based on arrests. You don't even get to the third step of that thing. So that, I mean, step one is, do you have a discriminatory impact? Step two, can you justify it? HUD says you lose there. That's it. You cannot justify a policy that has that basis because an arrest doesn't tell you anything. So here's, I think this is like a reasonable accommodation example. Let's talk through this one. Landlord files for eviction because tenant refuses to get rid of her dog. They have a no pets policy. Tenant says she's got severe anxiety. Having the dog around helps limit the number and time of her anxiety attacks. Tenant's mental health counselor has written a letter confirming that the person suffers from anxiety and that the dog seems to help. Is that a reasonable accommodation? Perhaps. Well, let's go through maybe some more concrete examples. Can the landlord evict because the tenant won't get rid of the dog? Probably not. You know, do you have a disability? Yeah. Anxiety affecting major life activities. Is there a connection between the two? Well, the therapist has said, yeah, the dog seems to help, right? So you have evidence of that. Is it reasonable? Is there going to be an undue financial burden, undue administrative burden? Maybe if the dog's tearing everything up, but you know, those facts aren't here. So based on these facts, you're probably in a reasonable accommodation situation. You can't evict because the tenant won't get rid of the dog. Can you charge a pet deposit? Or evict if they won't pay the pet deposit? No. A reasonable, basically, service animal or an emotional support animal, something that's granted as a reasonable accommodation, is not considered a pet. Basically, if you charge that fee, you would be charging a disability surcharge in effect. And so the Fair Housing Act wouldn't allow that. Can the landlord ask if the dog is trained or certified? This is a common confusion, actually. And the answer under Fair Housing Act is no. There is no training or certification required of any kind of service animal or any kind of emotional support animal. Where that confusion comes from is under the ADA in public accommodations, like going into stores. This is why on the grocery store, sometimes you see, service animals only, no pets. They can require certification under the ADA, and that's in public accommodations. But the Fair Housing Act is different. It applies to one's own home, private housing. Even though you're renting it from somebody else, it's your home. And the doors are more open there when it comes to service or assistance animals. So no certification is required. Can a landlord refuse to allow the dog because it's over 25 pounds or because it's a particular breed? Well, unless you're in a direct threat situation, or unless for some reason this particular dog is going to cause an undue financial or administrative burden, having that kind of a blanket policy is basically a blanket denial of reasonable accommodations. And so, no. Can the landlord refuse to allow the dog because it's bitten two other residents, injuring them badly? Absolutely. Yes, direct threat. So, there are limits to this stuff. They're out there, but you have to be really careful about knowing, what are those red lines? And there's a lot of leeway before you actually reach those red lines. Let's talk a little bit about sexual harassment too, because this is implicated in the Fair Housing Act because, well, typically most victims of sexual harassment or sexual violence are women. And so if you are doing things that negatively affect folks who are victims of things like sexual harassment or domestic violence, those policies can again have that disparate impact on certain people who are members of that protected class. And there are two types of sexual harassment that are recognized under the Fair Housing Act. Again, the first one is a little bit more straightforward than the second, kind of like disparate impact and disparate treatment. Quid pro quo, landlord seeks sexual favors in exchange for rent to prevent eviction or as a condition of other housing rights or benefits. That's pretty straightforward. That is a clear type of sexual harassment. Hostile environment, though, and this stuff is similar in employment law. Hostile environment is a little trickier because there may be situations where it's not a sex for rent situation, but it's sexual advances that basically interfere with the tenant's right to enjoy the home. They become so pervasive or so horrible that they just can't enjoy their house. And the hostile environment sexual harassment is a little trickier for a landlord too, because it doesn't necessarily have to be the landlord that's engaging in the conduct that is sexual harassment, right? There's a fairly recent case from Maryland, which is within our federal circuit, that acknowledges that there may be situations where if it's tenant versus tenant sexual harassment, a landlord who just says, we're not gonna do anything about it. No. Under circumstances where they could potentially be liable under the Fair Housing Act. I want to say I had the facts in that case were a little bit more complicated. The tenant was actually an employee of the landlord and was also living there. And the landlord was doing things like, there was another tenant that lived above them that there was some really disgusting behavior, sexual harassment stuff. The landlord was refusing to do anything about it, was making the tenant/employee go in and do inspections of this guy's apartment and things like that. So there's some pretty strong facts, although there's no reason to think that just that employment relationship was what triggered potential liability. So it could be a situation where you just have straight tenant versus tenant sexual harassment. There may be some obligation on the part of the landlord to do something about that. That possibility is out there under circumstances where you have that tool available. And this is some information about domestic violence and disparate impact. Roughly 85% of victims of domestic violence are women. I think we've kind of talked through this. policies, may have a disproportionate impact, and if they have to be substantially justified to pass muster under the Fair Housing Act. And again, if there's a less discriminatory way to do it, there may still be liability. So here's sort of common hypothetical facts that I'd seen a number of times when I was at Legal Aid. Jill ends an abusive relationship. Jill's abuser comes over to apartment one night, demands to be let in. She refuses. He tries to kick the door in. Jill calls the cops. The abuser runs away. But he's done pretty substantial damage to the door. Can the landlord charge Jill for the cost of replacing the door? I would say no, for a couple reasons. One is the fact that they had a previous relationship doesn't make this guy her guest or someone who's under her control. It's really little different than if some stranger showed up and tried to kick the door in. Saying that she's responsible for it is kind of like saying she was asking for it. So, the connection between these two people is pretty attenuated at this stage. So I would say, no, you can't do it. The answer in any kind of subsidized housing is 100% clear. Absolutely not. You cannot do that. I think it's pretty clear anyway. But in subsidized housing, there's a different law called the Violence Against Women Act that applies and makes some of these things a little bit more crystal clear. The other question is, can the landlord evict Jill over this for the same reasons? No. The landlord is a victim of that crime in much the same way that she is. And the previous relationship doesn't really change that situation. So it came to the end here. I don't know what you want to do. Do you want to do any Q&A stuff now or just hold all that stuff for the end? Okay. If you all have questions.
Could you go back one frame? Because I want to get a picture of that.
Is it this one? Yeah,
Yeah.
sure. So happy to talk questions or hypotheticals or anything. Please go ahead. Do you mind coming up to the, I'm assuming you'll want questions through that. Yeah. Oh, there we go. Perfect.
Can you go back to the very last one?
Are you finished, ma'am? Got it.
Oh, I'm sorry.
No, it's okay. This one?
Number one,
Yeah.
can the landlord charge Jill for the cost of replacing the door? And I think you said no, absolutely not in Section 8 housing.
Yeah.
But if the person was arrested, can't you charge that person
The guy
that actually did the damage?
Oh, sure.
Okay.
Yeah, absolutely. Yeah, I mean, that's both a civil and criminal kind of situation. Yes. Yeah. And in that situation, what the Fair Housing Act recognizes is that he's the wrongdoer for kicking the door in and being an abuser. She's not a wrongdoer for being abused. Yes, ma'am.
On the arrest slot that you had.
Like
that you
arrest versus
couldn't
convictions and all
couldn't
that.
Yeah,
Yeah.
because it didn't say conviction.
Mhm.
But if you read in the newspaper that this person killed somebody or was
Mhm.
charged with killing somebody 2 weeks ago,
Mhm.
because they haven't been convicted yet,
Mhm.
I think you'd still have enough concern that you could not rent to them.
Well, what's the newspaper telling you that the fact that they have been arrested or charged isn't? Like, is that any new information?
Well, that's what I'm asking. You said you can discriminate if they've been charged or if they've been
Mhm.
convicted, rather, is what you use the word convicted. And we know in the court system today, it takes years sometimes before you get a conviction.
Sure.
So if they're out on bail, but you know that they're still capable, of doing
Mhm.
that,
Yeah.
I mean, where does the landlord go from there?
Right. If all the information you have is the arrest or the charge, that's what the Supreme Court case that I pointed out and the guides from HUD that I pointed out says, if that's all the information you have, you don't have actionable information. You don't have something that you can act on. If you saw him kill him and they haven't been convicted yet, but you saw it, that's a whole different story. But the fact of an arrest or charge, or that you read about somebody being arrested or charged in the newspaper, I think what this recognizes is that doesn't give you enough to work from. If you had testimony from a police officer who saw it happen, you're right that the criminal justice system, the wheels can turn kind of slowly. If you had other evidence of the crime that you could use in an eviction case, or that through your own investigation you find out, that's a different story. But in the hypotheticals I'm using, all you know is the arrest. And that's often what happens, not once somebody has become a tenant, but in the screening phase. And that's where, not to say it's more important there, but the facts are a little more stark. Because at the screening phase, often all you have is an arrest or a charge. And at the screening phase, if that's all you have, you don't really have anything. You don't really have a basis on which to act. You know, if you have somebody who's living with you and who's living at your apartment complex, and you can investigate that and find out more information that you could potentially use in court, that may be a different story. But I understand where that concern is coming from. Is there anybody else? Yes, sir.
So going back to the schizophrenia scenario,
Mhm.
What would be examples of reasonable accommodations that the landlord can make in that situation?
So, I mean, I'll give examples from cases I've worked on. Basically dismiss the eviction case. You know, it's kind of straightforward, but you know, in that scenario, you had somebody whose behavior was the grounds for the eviction case, newly diagnosed, now going under treatment. I draft these hypotheticals in a way that make it easy to explain, so they work for me, because the real world can be a little bit more complicated. But in that situation, most likely what I would ask for is say, hey, dismiss this case and just kind of hang in. You know, if there's concerns in the future, maybe we can kind of address that as time goes on. I've worked out other kinds of agreements where, I mean, in one really extreme case, I worked out an agreement where the person who was being treated had to make sure that they continued going to treatment. And that if they didn't, the landlord had the right to ask occasionally if they were still compliant with treatment, because this was a person that was just great when they were being treated. When they decompensated or when they were out of treatment, their behavior could be pretty bizarre. And honestly, you know, I could see where the landlord's concern was coming from. So, you know, under those circumstances, and this is an example of the interactive process, right? Is the landlord's got legitimate concerns, but maybe there's a way to deal with that. And we find a way to allay the landlord's concerns by making sure that they understand that this person is still going to treatment. They're still trying, they're still working on it, and we're good. But in that simple case, I would say just, hey, dismiss the eviction case and let's see where things go. If you have concerns in the future, maybe we need to deal with that piecemeal. But yeah. Yes.
So first, just to remind people, if you're attending virtually, you have to go under all day event, 54th Fair Housing Training, and that's where the live Q&A is. So our first question from a virtual attendee is, can the landlord require a support animal to be spayed or neutered?
I've never had that one before. That's interesting. I would, as a blanket policy, I would say no, that would be risky. It would be risky to have a blanket policy like that, because what you would need to show is that not having this particular animal spayed or neutered, undue financial burden, undue administrative burden, or direct threat. And I don't know that you really get to any of those things. I mean, you know, I understand spaying and neutering pets I'm good with, right? I think it's a good idea. But in terms of, you know, whether that checks any of those boxes, I think it would be a stretch. I can't think of a scenario where, like, you would, you know, if it, emotional support cat, the cat's breeding all over the neighborhood, it's becoming an undue financial burden to take care of all these kittens that this cat is producing. Maybe, but that would be a kind of a strange scenario. I'm always worried about blanket policies that just say absolutely not. And that's why usually what I tell folks is the answer is can be no, but not no, period. And I think that's one of those situations. Mm-hmm. Mm-hmm. Well, is there consequence to the landlord for having a tenant that doesn't have a spayed or neutered animal? Probably not. I mean, the way most city ordinances are written, it would be you know, potentially a fine or a ticket to the tenant, not to the landlord. So what I would say is that's probably not. I mean, I understand where it's coming from, but that's probably not something the landlord has concern about directly.
I have a statement. While I respect fair housing and all of their rules and guidelines, unfortunately, it appears that the pendulum swings so much on the side of the housing clients than it does the landlords. And I don't know just how just that is. You know, as landlords, we absorb a lot of cost at the expense of housing clients, but then we're expected to be able to have safe and affordable housing, which becomes very difficult for us to do when I'm absorbing, because your boyfriend broke in the door, I have to pay for it. And so I wonder if there will ever be where the pendulum swings a little more evenly on both sides. You know, like I look at like the pay in advance. So you were talking about the person with Social Security who gets their check on the 15th.
Mhm.
Why can't we ask them to pay rent in advance? You know, make sure the rent is paid. You know, when you get your check on the 15th, you're paying for the first of the month coming up. Why do we always have to adjust
Right.
our rules? I mean,
What I would, if I can answer that
Okay.
question briefly, that's a disability tax in effect, because you're asking someone, because they are disabled, to do something that a non-disabled person doesn't have to do, which is pay in advance.
exactly,
Right.
because that's what we have all of our housing
Sure.
clients do. We said, you know, pay your rent on time.
Mhm,
And
Sure,
if that means you get paid on the 6th and you have until the 5th, then you need to make sure you
Right.
made arrangements from that previous paycheck to pay your rent that is due on the
Sure.
1st.
and for
It's like-
someone, if I can let me address the questions as they come up. For someone who is non-disabled and is paid on the 6th, but the rent is due on the 5th, them having to move ahead is not tied to a disability, and disability is what the Fair Housing Act protects. So someone whose disability is the reason that their rent, that their check comes in later, that's where the connection to the Fair Housing Act comes in. And there is the protection that I've talked about for landlords, and it's not expected that there is no financial burden, right? I mean, you've talked about the financial burden that landlords have to take on. There's protection against undue financial burden. Now, what does undue mean? Who knows? It's case by case, right? Small landlords may be able to bear a lot less financial burden than a large landlord who potentially has a little bit more wiggle room in their budget. But having to bear these costs, the Fair Housing Act does recognize that some accommodations are too far, right? Some burdens are undue, and that protection is baked into the law.
One last thing. So there, 3 kids in Rock Hill were killed on Tuesday. 3 were killed and 1 was wounded. 1 that was killed and 1 wounded are children of one of our household clients in Rock Hill. And those boys had been associated with gang violence. There was a lot of trouble, you know, coming from the home as a result of those boys. And we couldn't do anything to them because we had no direct proof. And for some of the things, again, they hadn't gone to court or anything.
Yeah.
But as a result of their actions and gang activity on the property, 2 days ago, 3 are dead and 1 is severely injured in the hospital, which put 20 other housing clients at risk. But again, there's nothing we can do. And I hate that they've lost their lives, but these kids were involved in gang violence and bringing guns onto the properties, and there was nothing we could do.
If
Because
that's
again-
true, the second part of your statement is not true, right? So if you knew, if you had evidence, if you could prove it, there's nothing we can do is incorrect. So I mean, and that's what I point, and I'm not trying to pick on you about that or anything, but and I understand the conundrum that a lot of times landlords are in that situation, particularly with pressures towards something we call third-party policing. So shifting policing duties onto housing providers, that's something that started to happen in a lot of communities, things like crime-free housing ordinances. I hate those things because it takes the job of policing and puts it on to people who don't have the training, don't have the resources, don't have the experience to take care of it. So that's what the distinction that I was trying to make in the Fair Housing Act situation is when somebody has very limited information about what's going on, relying on things that don't tell you anything meaningful about the situation. But if you saw the guy pull up and open the trunk and there's a trunk load of assault weapons in there and gang member, I mean, if you have direct evidence and stuff, there is something you can do. The harder situations are when you suspect and can't prove. And that's hard for everybody. I don't know that there's anything in the law that really firmly addresses that. But those are the harder examples, and they are real world examples.
My criminal mind is at work over here.
Oh, dear.
Let's go back to the service animal and the spay and neutering.
Okay.
There are people with criminal minds who
Mhm.
say, okay, I have a dog breed that's my service animal. I know a friend who has a female or a male
Mhm.
that I could breed my service animal with, get the puppies and sell them.
Mhm.
In my situation where I'm living with my service animal, how do you handle a situation like that?
Well, what's the harm to the landlord?
You got maybe 10 puppies in the apartment
Mhm.
until they are of age to distribute.
Right. Are they causing damage? And
Could be,
could be.
maybe
Yeah.
stench, if nothing
Mhm.
else.
I mean, I would say that, in that situation, you've gone beyond the reasonable accommodation. I mean, the accommodation
Yes.
is, I have this animal in my home to take care of something involving a disability. Unless they could show that somehow having the 16 puppies or breeding the animal was somehow connected to the disability, which I have a really hard time imagining how that would be. The accommodation is having the animal. You've gone over here now. And if
Mhm.
what you have in this scenario is a violation of the lease, is a violation of tenants' obligations, you're probably outside of the Fair Housing Act protection at that point. So,
Okay. Whoa.
Back because I was just curious about something that was in the much earlier slides about who the fair housing laws pertain to,
Mhm.
specifically small landlords, right? So you
Yeah.
own less than 3 single-family homes
Right.
under ownership. Does that make you exempt from fair housing, or are you allowed to discriminate because you only own 2
Sure.
plus maybe your primary and you don't
Yeah.
live there? But so I'm just curious why
thing-
that's in place and how it works.
right, so things like disparate impact liability, the things that I've been talking about, having policies that have disparate impact, but aren't discriminatory on their face, or don't say things like no blacks, no Muslims, no women. Yeah, there's an exemption for that, essentially, for very small landlords. The trick, not the trick so much as the exception to the exception, is making a advertisement or a statement that expresses discrimination or a preference. So you put an ad in the paper, if you make a statement to somebody that says, I really don't want any black people living here. That's where things start to go over the line. But what it exempts is smaller landlords, I would say primarily from this disparate impact issue of you have a criminal record screening policy that can't be justified and it has a discriminatory effect. You could potentially be exempt as long as you don't make advertisements or statements that express those preferences, if that makes sense. Good. Sure.
So I just had a quick question regarding evictions.
Mhm.
As it stands right now, we're helping a lot of clients who are dealing with rental arrears due to the pandemic.
Yeah.
And what we're finding is United Housing Connections. What we're finding is we have some landlords who, after receiving payments, are still proceeding with evictions.
Yeah.
What recommendations do you have for clients in that scenario?
So, I mean, in a situation where the rental assistance clears up the arrears, I at least would argue, if I were arguing for the client in court, I'd argue, well, the landlord's made whole in that situation. And it's not, the law around evictions is not as clear as it should be, but there's room for equity considerations, which basically means it ain't fair. And you can basically make it ain't fair arguments in eviction court. And that's kind of where it goes for me is But, you know, if you're in the eviction case, you kind of have to make that argument in court that they've received payment. Now, if it's a situation where they received payment late, which is probably true, that gets more difficult because strictly the way the law is written is if a tenant is behind at the time the eviction case is filed, it doesn't matter if they catch up. The way our law is written is that your only chance to cure a rent non-payment comes before the eviction case gets filed. We don't have post-filing right to cure. One second. Sorry. So, I mean, strictly from a legal perspective, that's a difficult situation. I think you can still make arguments around it ain't fair if they're going to take thousands of dollars of taxpayer money that was designed to keep people in their homes and not displaced and still displace somebody. But it's a tough situation, honestly. It really is. I wish I had a better answer because I know that's a common issue.
In the state of South Carolina anyway, that you can accept that rent and still evict?
Yes. Yeah, I think that's what I was trying to say. And if I wasn't clear, that's correct. It's something that trips a lot of tenants up. I mean, so many cases are settled, and any landlords in here, which I gather a number are, so many eviction cases are settled after the case is filed, tenant gets caught up, landlord dismisses the case, maybe they charge for the cost of filing and everybody's good. We go on about our way. Legally speaking though, once the eviction case is filed, if you had a right to evict at the time, that right continues regardless of what the tenant did after the fact. And that trips a lot of tenants up too, because they think, well, we paid, and then all of a sudden the eviction order comes out, which is kind of an automatic process with the court. Sure. Yes, ma'am. Your Honor. Apologize.
That also the tenant has already occupied the unit for what the rent was due,
Mhm.
the arrearage, so therefore they already owed the money.
Right.
So going forward, as they were stating, that the landlord does not have to accept, he can accept or deny the payment either way. Once the eviction is filed, he can move forward with the eviction, which most of them try to do anyhow, because they're thinking that the tenant is not able to sustain the payments along the way.
Mhm.
So that's why they fell into arrearage in the first place.
Right.
But they do have a right to accept or deny, and that is the law, and that's what we provide to them, and we have to tell them it is the law.
Yeah, it is. And it's, and I think what Judge Duckett pointed out is what the law recognizes is the fact that by the time the eviction case is filed, that money has come due and that money is late. And that is what gives grounds for eviction, as harsh as it may be. That is what the law is. We good? All right. Thank y'all very much.
For Adam, but please make certain that you join us at 3 o'clock and we can continue this discussion. Next, we're going to have, it's your property, but they're home. Okay.
I want to thank Adam for that wonderful and concise presentation. I feel like it was incredibly informative. I'm James Cooley. I'm a financial counselor with the Human Relations Commission. I am up here to introduce our next speaker, Don Frierson. Don is a 1983 graduate of the University of South Carolina with a major in journalism. He began his employment at the South Carolina Human Affairs Commission as a public information officer. In that capacity, he edited the agency newsletter and served as a photographer. In 1989, with the passage of South Carolina Human Affairs Law, Don served as the agency's first fair housing intake officer. As the agency's fair housing intake officer, Don drafted all the fair housing complaints received by the agency, investigated fair housing complaints, conducted workshops and outreach efforts throughout the state of South Carolina. Don also served as a presenter at various fair housing conferences across South Carolina and throughout the southeastern region. Don's currently a fair housing investigator in the Commission's Fair Housing Division. I just want to remind everyone before he comes up that there's going to be an evaluation afterwards of this session that can be found in the attendees hub. And once again, to hold off on questions until the end of the session. Don?
I'm gonna get my orange juice because I'm thirsty. You know, it's very interesting listening to the last presenter here because some of the cases he talked about, some of the questions he asked, are questions and cases that I have in my office right now. It's very interesting to hear that. Maintaining good relationships with your tenants, how to avoid a discrimination complaint is what I'm going to be talking about. Everything I say to you, I have actually witnessed. I used to work in public housing, and what I present today are things that I have seen and things that I've learned from one of my supervisors while working in public housing is Ms. Beverly Malone. So with that, first slide. One of the first things in terms of how to prevent discrimination complaints and how to stay out of trouble is don't have bad days. Don't bring your problems to work. I'm serious. Martin is a tenant of mine. He comes to the office. I just have a very bad day because I had an argument with my supervisor, Ms. Duckett, before I left work yesterday. So I'm still having a bad day. Martin comes in, Mr. Frierson, I need to ask you a question about, well, what do you want? Why are you up here bothering me? Well, Mr. Frierson, I don't want to hear any questions you have to ask. Come back at 3 o'clock. Better yet, call, because I might not even be here at 3 o'clock. What happens there? Martin has a bad opinion of me. Martin thinks I don't care about him. Martin thinks that I'm just an object. Now, the problem you get into with something like this, as you can see, Martin is African-American, right? Martin is male. Martin observed Ms. Duckett's niece, a female tenant coming into the office prior to him coming in the office, and I treated her very nice. So what is Martin going to think? Martin might think that, hey, he's treating me differently because I'm a male and she's a female. And I've actually seen this happen. We've actually had cases like this. So that's why you want to treat everybody the same. You don't want to have a bad day. Somebody comes to the office, greet them very warmly, show that you care, and smile. Don't frown. What is that saying? A frown is a smile turned upside down or something like that. But that's the most important rule to start off your day with. Do not have bad days. When I worked for the Housing Authority in Columbia, my supervisor would not allow us to address tenants by their first name or last name. It was always Mr. or Miss. Why is that? Anybody want to? Respect. This is exactly. Because they're not children, they're tenants, and you want to show that you respect them. And you know, one of the things I found out is, and a lot of times, tenants would actually think that, especially tenants who live in public housing, and I know this because I've heard it, they will think that the people in the office kind of look down on them because they're in public housing. Anybody ever experienced that? And that's a real thing. It really is. And so by showing them a modicum of respect, what you are saying is, I don't care where you live or what you do, you're no better than me, and I'm no better than you. So that's very important. If you have a question, just ask them, how would you like to be addressed? Number 3, don't argue. Please don't do that. Because you aren't going to get it in place. And you might wind up fighting on the property. I'm serious, I'm dead serious. When your tenant is angry, do not argue with them. What you do is you listen to them. Martin comes in the office, he's cursing me out. I stand up there and listen. You let them talk because something is going on with them and they have a problem. And they might be right about their problem, but they just don't know how to address it. So you have to really listen to what they're saying. And come on in, have a seat. We're gonna talk about this. We're gonna get it straight. Just have a seat. And I'm gonna listen to what you say, and you're gonna listen to what I say, and together we're gonna work this problem out. Don't brush them off. Well, Martin, you know what? I really don't even care. Just going back to your house, I'm gonna evict you. Don't brush them off because they have real concerns. And a lot of times some of the tenants think that landlords are above them because they're in public housing and what have you. So you got to let them know that you care. In a calming voice, let them know you understand. I have a friend who, she actually works for the Smithsonian in Washington, D.C. at the African American Museum. She has the most calming voice I have ever heard. I believe she could calm a tiger. I mean, that's her voice is like that. She just has a very calming voice. So when people come to the office or approach you angrily, in the calmest voice that you have, let them know you understand. Now don't escalate your voice up to their level because you're doing what when you do that? Getting in an argument, right? So don't do that. Point out the reasons which led them to your office. Make sure you understand why they're up there in the first place. Okay, I see you have a problem because you were locked out last night and the maintenance man didn't come to this morning. That's a big problem. Whatever the reasons they're up there, make sure you understand them. Make sure you go over those reasons with them. Make sure that you are able to work out some type of solution to prevent the problem from occurring again. Don't change the slide yet. Document the meeting. Document it. I'm telling you, when people come to your office and complain, document it and document what happens. Because if a complaint is filed against you, one of the things the investigators want to see is, have you documented anything? So Martin comes to my office, mad, we have a meeting. I have my calm voice, I let him know that I understand it. Go over the reasons, we work out a solution. I want to document it. So when Martin comes back and accuses me and say I never did anything in the first place, which happens, here's the document. Now, before we move on, this is very important. You don't have to let anybody run over you. Now I'm serious. We have a thing in our office. If somebody calls up, and when my supervisor's out, I'm in charge. And we get calls from people, and we know people call, they're upset because they're about to lose their house, they're in dire straits and things like that. We understand that. So we know when people call, they're going to be angry, they're going to be upset. That's fine, I can deal with that. But when somebody calls and just literally curses you, and we've had this, literally curses you out, talk about your mother, your father, your brother, your sister, your aunt, nephew, whoever. You don't have to take that. I mean, you really don't. Because what I say to them is, sir, ma'am, I'll talk to you about anything you want to talk about. I'll stay on this phone all day if necessary for you to get your problem out. But you can't talk to me like that. Now, if we can have a civil conversation, we can continue. But if the conversation is going to go on like this, if you're going to continue cursing me out, I'm gonna have to hang up the phone. And we actually tell them that. You better not hang up this phone, or whatever. Ma'am, sir, thank you for your call. I'm going to hang up. You better not. Ma'am, I'm going to hang up the phone. Thank you for calling. When you get in a better frame of mind, call us back or whatever. Bam. Because you don't have to let anybody treat you like a dog now. I'm not saying that. What I am saying is when people come to your office, don't argue with them, sit down and try to work the problem out. But don't let anybody run over you. All right. Somebody just came to sign a new lease. What do? Walk, don't run. What I mean by that? You want to sit down with them and explain that lease to them, the important things in the lease. Don't just throw the lease on the table. Sign here, sign there, sign there. I got somewhere to go. Hurry up. Explain to them the important. Now, I've seen some leases. It will literally take you all day to explain. And I'm like, and I know some people who will sit there and read the whole thing and won't move until they have read all 100 pages. I had a friend who asked me to take her to the grocery store one day, and I did. And she's one of these people who read labels. We were in the store all day, man. She would pick up a can of soup and read the label. And you know, I'm getting tired, man. I'm like, man, don't ask me to bring you to the store no more. But you have a job to do. You make sure that they understand the lease. You make sure they understand when rent is due, when rent is late. You make sure that they understand the maintenance procedures, the number to call, what have you. You make sure that they understand your rules and policies about getting in trouble. In other words, if you're on the property fighting, that's going to be a lease violation. If you're on the property fighting again, that's another lease violation. If we catch you the third time, lease about fourth time you're gone. You make sure they understand what can lead to a lease violation or what can lead to other infractions. Then after you go through all that, you understand, okay, well, I got to go now. You allow them to ask questions. And then keep in mind that you always are courteous. One of the things we used to do at the Housing Authority, when at least in the particular building that I worked in, and I don't know if it's practical for all of you, we used to have monthly meetings with the tenants. And that way you can really gauge your tenants and what's going on. And they were very productive. They were very productive. In some cases, you might want to create a newsletter to keep your tenants informed in terms of what's going on. I don't know if any of you have suggestion boxes you can put in the lobby or what have you, so tenants can come in to have suggestions. And always have an open door policy. Now, you know, if you're a landlord, you really have work to do. And a lot of times you can't do your work if people in and out of your office 4 or 5 times a day. So what you could do is have a situation. My door is open for between 3 and 5, 12 and 2 or what have you. But have an open door policy so people can come in, tenants can come in and talk to you about the problems they might be having. They might want to come in and give you a compliment. So have an open door policy. This is one of the things that perplexes a lot of tenants, work orders. Because if a tenant calls in a work order, they want it done that day, right? That hour. They don't understand all the dynamics and complexities that go into a work order. You might have to order parts. They don't want to hear that. My air conditioner broke. Well, there's nothing you can do. You're gonna have to wait. Have a system for the reporting of work orders. Everybody have a system for reporting work orders? Or does the person just catch whoever's on the property and say, I need this fixed? I'm gonna tell you why that's a bad idea if that happens. Yeah, right, that's a real bad idea. Try to have a minimum time for the execution of all work orders. What's the minimum time you all have? 24 hours, wow, that's good. If it's an emergency. Yeah. Now, you know, a lot of people think, and this is one of the things that I never could understand, your air conditioner breaks down. Is that an emergency? Medical condition, exactly. In a lot of places you go, your air conditioner break down, that's not an emergency. Now that's hard for me to understand because my air conditioner is broken down and it was a real emergency for me. Because I mean, I was sweating, and you're gonna tell me this is not an emergency? You got to be losing your mind. But it's not, And you have to explain that to the tenant. And in a lot of cases, they'll bring a fan over something to keep it cool. And in a lot of situations, depending on what's wrong with the AC unit, it'll take days to get it fixed because you might have to order parts and all that. But whenever something like that happens, you need to explain that to them. Don't have them sitting in the house waiting, and they don't know what's going on. Well, Ms. Duckett, the problem is this. Your air conditioner has experienced this. We're going to have to order parts. So because we have to order parts, it's going to take next year to get it. No, it won't take that long. It's going to take 10 days, whatever, to get it fixed. But you make sure they understand what the problem is and why it's not being worked on right away. Don't do favors for anyone. Tell your maintenance man, please don't do that. Now I'm gonna tell you why. This is actually a true story. We actually had a case like this. There was this woman who lived in this apartment. Somebody broke into her apartment. I mean, you know, she knew everybody out there, knew the maintenance man. Maintenance man knew somebody broke into her apartment. They see each other one day. Can you put a lock on my door? Because I don't want anybody breaking my apartment again. Maintenance man, sure, yeah. He goes up and put a lock on this lady's door. True story. Lady goes and tells her neighbor down the hall, who's a man, hey, guess what? The maintenance man just put a lock on my door. The guy goes to the same maintenance man and says, I want a lock on my door. I want you to put a lock on my door. Maintenance man says no. Maintenance man says, well, somebody broke into her apartment. She's a female. She's staying there by herself. So I put a lock on her door. But I'm not going to put a lock on your door. He filed a fair housing complaint. Yep. And guess what? Not only did he get a lock on his door, they had to go through training. And I think there was some fine for doing that. So you always want to go by your work order system. Don't do any favors for anybody. Next slide. One of the things that is a problem, and I've actually seen this happen with maintenance men and tenants and some employees, they get involved with the tenants on the property. You should never, ever do that. Don't flirt with tenants. When I was working at the Housing Authority, we had this guy, he thought he was God's gift to women. I mean, seriously. We had this female tenant who stayed out there, true story. She thought that she was God's gift to men. She thought she was, now I'm serious, I'm not making this up. She thought she was perhaps one of the most beautiful women in all the land. And I'm not gonna tell you no lie, she was pretty. She was, I mean, I'll leave it at that, but anyway. This guy, this maintenance guy who thought he was God's gift to women, started flirting with her. And they got into a relationship. She wanted to call it off, he didn't. She reported him for sexual harassment. He got fired. If you want to get involved with a tenant, quit your job and then do that. But getting involved with your clients and your tenants, that could lead to a whole lot of problems. Don't flirt with the tenants. Hey, girl, what's going on? Hey. Now, I actually have a friend, this is a true story. She told me one time, she was a good looking girl too. She told me one time when she walks down the street and men flirt with her, knock 3 times, nobody else is door. What do you do next? Anybody. Open the door, maintenance, 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 and you get 4. Maintenance. And then you enter the room. Now, I see cases where maybe it's done. Speaks around the corner. She wants to do this. Yeah, that we're trying to get back. Of course, it's the latest statement that you use for that. Don't just walk in the top. And as a matter of fact, I've seen situations. Do not touch, embrace, or say anything suggestive to anyone. Now, you know, I've actually, you know, there are some tenants who, and this is just a way of expressing themselves. They'll call you baby, hey, honey, this kind of thing. That's just, say what? No, go ahead. No, they aren't gonna stop, but you can't start, if you understand what I'm saying. Hey, baby, hey, honey. Hey, sugar, what's going on? No, you don't want to do that. Yes, ma'am. No, ma'am. Because that's just the way they talk. That's the way they express themselves. But always keep it professional. Don't touch anyone, embrace anyone, or say anything suggestive. Get involved. If possible, have programs for your tenants or their children. When I was at the Housing Authority, we had a summer feeding program. We had a little room where kids could come in and play on computers. And what a lot of people don't know is I also host a radio program every day, 12 to 1. And what I would do is get the company van and take some of the kids to the radio station with me. And they really enjoyed that. So have things for the children to do, or have programs for your tenants. We did that all the time when I worked in the particular building I worked in Atlanta. We had a spring festival, and sometimes we would have to work late at night, but it was really enjoyable. Walk your property. Don't stay in the office all day. Why is it good to walk your property? You walk your property and you see tenants out there, they'll tell you things that you don't know. My supervisor, she walked her property all the time. Where's Miss Falonde? She out on the property. And so I used to get out and walk on the property too. And people would stop me. You ought to know, you don't know what's going on next door. Really? What's going on next door? They will tell you things. And not only will they tell you things, they're glad to see you out there walking the property because they know that you're concerned about the property. And then you get to see who is not taking care of the property, who's throwing litter outside the door and things like that. And then you get to know your tenants. One of the things I found out by working in the Housing Authority is when you really get to know your tenants, you can really have a meaningful relationship with them. I still see, I left the Housing Authority, Columbia Housing Authority about 8 years ago. I still see tenants who live out there and they always come up and talk to me because I will walk the property. They'll be sitting on the steps. I'll stop and sit on the steps too. And we have a little conversation and they'll tell me what's going on. And I say, thank you. And I'll get up and leave. And it's really enjoyable. Treat everyone the same. Don't play favorites. What's good for the goose is good for the gander. Now, that's the end of my presentation, but I just want to say some other things also. In listening to the previous presenter, which was really good. I enjoyed his presentation. Working in fair housing, there was a lady who raised a question about fair housing seems to be so much against the landlords. And I've heard that too. One of the things is when we investigate cases, we let everybody know up front, we're not for the complainant, we're not for the respondent. We're only coming for the facts. That's all. I've had complainants who told their landlords that I got a lawyer now. Well, who's the lawyer? Don Fryer. What? And I'm serious. And being a landlord is hard, but there are rules that everybody should follow. And really, the thing is, if you just document, that'll keep you out of a lot of trouble. It will keep you out of a lot of trouble. But it can be a rewarding job. And, the previous presenter, and I was thinking about this when he was talking, the lady mentioned something about Rock Hill, 3 people being murdered. We had a situation where these parents had this son who was always getting into trouble, and we knew something bad was going to happen. I mean, we just knew it. And if you walk your property and talk to their tenants, they knew it too. We just knew something was going to happen. We would bring him in, talk to the parents. Look, you really need to, because, you know, the son is going to get in trouble. Everybody knew it. I went on a trip to Tennessee, get back to my house. 2 houses up from me, a guy was murdered. True story. The guy who committed the crime was the same person we had talked to his parents about. And I don't know back then, and perhaps the lawyer can talk about this, but I know at one time HUD had this no strike policy, 3 strikes you're out, or whatever the policy was. And because this guy killed this other guy 2 houses up from me, there was a serious attempt to put the parents out. And that happens. I mean, we've had tenants. There was one lady, she had these 3 children. And we kept telling her, look, your children are breaking into, we didn't have any proof, but everybody around them knew what was going on. Ma'am, you need to talk to your children because your children are doing this. And my children don't do this. Nobody thinks that their children are doing anything, right? You talk to somebody who thinks that their children sit on the right hand of God, then you know you got a problem. Because I have not met a child yet who won't push the envelope if you don't step in and stop. And that was true with me, because I did some stuff. I'm not going to tell you about it. But when I was growing up, and people will look at me when I tell them, what, you? But I mean, you know, children do that. You think your child is not going to do anything? You don't know what first of all, you don't know what your child is going to do if you're not around. You might have a good idea, but you really don't know. And so we would try to counsel parents, but a lot of times parents just didn't want to listen. And what happens is this child was caught breaking into somebody's house at the apartments. And he went to jail. And she almost lost her apartment because people were trying to tell her that this was going to happen. Finally, before I sit down and take questions, one of the problems we really, speaking of children, you put somebody above somebody and the children are running around and you get noise. How do you all handle that? I'm staying on the 2nd floor with 3 kids. Ms. Duckett is staying on the 1st floor and the kids, and Ms. Duckett is complaining that the kids upstairs are making too much noise. How do y'all handle that?
I've had that kind of situation. And basically,
I actually went to the apartment and we did a noise study where we took a little recorder to just listen. We had our maintenance guy just run up and down upstairs and then do it softly. Talk with both of the residents to try to help them understand that if the children or whoever upstairs would walk a little softer, then it would not be as loud downstairs. We even let them come down to listen. So you try to do things that show that, you know, you want this to stop, but if it doesn't, then you gotta, you know.
What happens if the kids running around at 12 o'clock at night?
You mean inside?
Ms. Duckett is complaining, well, they run around and I can hear them at 12 o'clock at night. You're not there, nobody's there. What do you do there?
I'm not sure.
I'm not either.
Well, I see,
But no,
but it wasn't a time limit kind of thing. You know, when we had the situation, it wasn't that they were doing it 1, 2 o'clock in the morning or 3 or 4 o'clock in the afternoon. It was just that it was happening. So
Now, the reason I raised that is because A lot of times we get complaints about that very same thing. People will file under familiar status. You're doing this because I have children. Now, let me tell you something. I have a friend, she stayed in an apartment. And you know, she would call, man, these people upstairs are making, and she actually had a sleep disorder. And I said, well, you know, I said, no, you need to come over here and listen to this. It's always at night. I get over there at 12 o'clock one night just to go over. You would think a marching band is upstairs. But the landlord wouldn't do anything. She had a sleep disorder. I said, what you need to do is put the landlord on notice that you have a sleep disorder, and it was a disability, and let her know that you affect what's going on upstairs. It's affecting my disability. And that's what she did. They actually moved the person upstairs to another apartment and it became somebody else's problem. The reason I raised that is because those kind of situations are really hard to deal with, because people think that children, and I get this all the time, you're just picking on me because I have children. My children don't run. Let me tell you something. I have 2 kids and 1, 2, 3, 4, 5 grandchildren. They always ran when they were small. When I was small, me and my brother would run through the house. Boy, didn't I tell you not to run through this house? Get that all the time. So in a lot of cases, when you go over and try to talk to the neighbors, the one parent is upset because my kids don't do that. My kids are quiet. My kids this, my kids that. My kids are angels, they're in heaven or flying around or somewhere. The only thing you can do in a situation like that is document it. And if it really gets to be a problem, what you do is good. What you did in that situation is very good. You try to determine if it really is happening. But if it really gets to problem, you need to document it. But whatever you do, when people come and get your office, they want to rent a unit and they have children, don't just put them on the first floor because you're afraid if you put them on the second floor, they'll be made. That's discrimination. So don't do that. With that, I'm finished. Any questions? All right. Thank you. No questions. I must be all right.
And we'd like to thank you for that informative information that you just gave us. And I hope that the landlords and everyone that's present here will adhere to some of the suggestions that you made. I think it was wonderful. Okay, next we're a little ahead of schedule, which is good. We're going to have an exercise, test your knowledge. Please make certain that you all have downloaded the app on your phones. If you have not, the directions are in the center of the table. If you need help, just raise your hands and we will have one of our employees to help you to do that. So since we're ahead, I guess we can continue. Are there any lingering questions that you have for any of the past speakers before we get started on this section? Okay, if not, Martin.
Good morning. I know I got this mic, but I talk pretty loud anyway. Is everybody having a great time? Good. Wasn't the speakers great? Let's give them a big hand. All right, that's what I want to see. Okay. All right, so the speakers talked a lot about different things, and we're going to take a poll right now to see what did you learn, okay? I'm going to ask you a few questions, and you're going to answer it on the app. Good? Everybody's good? All right. First question. Oh, we're not ready yet? Tell me when you're ready. We got time. We're ahead of schedule. That's a great thing. Go right ahead. We'll give you time. We're ahead of schedule, so we're doing great. We're way ahead of schedule. Take as long as you need. Hmm? Yeah, as it actually is supposed to happen at 11:30. Yeah, yeah. But I'm gonna ask the questions anyway. Yeah, you will, because I'm gonna do it live. Yeah, just go ahead and get it, everybody get it up anyway. And then, because we are on a virtual versus in person, which is a hybrid, it's totally different than what we're used to. We're used to being in person or either virtual. So now that we're doing two, we have everything scheduled to happen at a certain time, and it doesn't kick off until that time actually is put in. So our poll questions are supposed to happen at 11:30, so that won't even pop up on there until 11:30. But with that being said, think about, you guys need a break? All right, tell you what, to get back on schedule, could you guys take about a 10-minute break and be back on time? Can everybody do that? All right. I know you've been through two presentations, and we definitely want to make sure that you're relaxed and taking care of everything. So if you want to take a break for about 10 minutes. I might get my hand popped, but hey. Who's Dr. Tucker?
Excuse me, may I have your attention? I was trying not to use the mic, I'm sorry. What we're going to do, the lunch is ready. So if you would count to 20, it's all laid outside. We're gonna ask people from this side to just go out and get your food and then come back in, and then we'll get ready for our next segment. Okay.
Okay, I'm back. Y'all back? Everybody good? Everybody's feeling their bellies? All right. You know, it's really good looking at people when they're eating because they seem so happy. All right, so we're going to start with the poll questions. As I stated, we need to make sure that you answer the poll questions on the attendee hub, okay? So the first question you should have, it should be, what year was Fair Housing Act signed? Now, all these questions already been through this, so you should have them. But the first question is, what year was the Fair Housing Act signed? And I'm gonna go through all of them, okay? And then we're gonna go back to the answers, okay? Next question. Let's see it. Y'all see it? Okay. All right. So, close. Everybody's got it. So we're gonna close that question. Okay. Oh, sorry. It's kind of hard when you have a finger trying to do what do you need a mouse for. All right. Second question. What month is Fair Housing celebrated? And if y'all get this wrong, I'll tell you. Display the questions. All right, you got it? All right. Next question. A landlord can deny an applicant an apartment due to a disability? That should be a true or false question, right? Everybody's got it? Okay. How we looking? Good? All right. Next question. Is it illegal for a landlord to solicit sex in exchange for rent? Here we go. Everybody else seeing it? All right. Okay. All right. Okay. Okay. I'm gonna have to run through because it's gonna shut down in about 1 minute. All right. Next question. Can a transient, let's see. I'm sorry. Is it illegal for a landlord to evict a tenant without going through the courts? Y'all see that question? There you go. There you go. Are y'all seeing that one? All right. The next one is, I'm sending them out. I'm sorry. Can a transgender couple be denied apartment rental due to their sexual orientation? And the last one, and I want to, even though we're going to do it on the thing, I want everybody to answer it out loud. What two animals are considered service animals? How many say dog and a cat? squirrel, snake. All of those are service animals. I didn't say emotional support, I said service. All right. It's actually, how many, what's the actual choice? All right. The two that can be is the dog and miniature pony. Okay. The first answer was 1968. The second answer was April, the one I told you cannot miss. The third, false, cannot deny. A landlord can deny an applicant due to this. A landlord can deny an applicant an apartment due to disability. That's false. It is illegal for a landlord to solicit sex for exchange of rent. That's false. No, it's legal. Sorry about that. All right. It is legal for a landlord to evict a tenant without going through the courts. That's false. Can a transgender couple be denied apartment rental due to sexual orientation? False. And the two animals are? Somebody said cat. All right. Miniature horse, miniature pony, yeah. Okay, thank you very much. That would be the next, who's going, we're going to go into our round table. Okay, are you going to do that? Okay. Thank you very much. Have a good day. I'll be here all day.
Are there any questions? I was monitoring the poll to see how many 100%. And unfortunately, not all of them were 100% correct. So I hope that after he had given you the correct answers, I hope that you will soak that in and remember that and take it back to your offices and remember the fair housing rules. Okay, next we have a roundtable discussion. And we're a little ahead of time, but I think this panel is going to take a little bit of time because I'm certain after you hear what they have to say and their suggestions, you're going to have a lot of questions. So please remember to save your questions to the end. Virtual participants, please make certain that you type your questions in the Q&A section and we will identify them. Okay, Ms. Sheila, you're up.
Hello, everybody. Everybody enjoying their lunch? Well, I'm gonna have to piggyback off what Martin said. He said he liked to watch people eat because they be happy. But he forgot to add one thing. After eating, we get what? Sleepy. So since we're ahead of time, Dr. Duckett has given me the authority to ask you guys to stand up, hold up, and run in place for the next 15 minutes. You guys can do it. I can't do it. But again, I hope that you guys are enjoying this workshop today. I mean, I'm new to housing. My name is Sheila Dogan. And I work with an organization here in Greenville called Beyond Housing. We provide housing to seniors, people with disabilities, veterans, and low to moderate income families. We have been in existence for 30 years. So you guys come and see me, 310 Mills Avenue. We have property, we have senior duplex, but I am new to housing. And we do have a property management company. And a lot of times the tenants will not go to the property management company, they'll come to me. I'm not a property management. And still new in this business, being new in this business, it's a lot that I don't know. But this part of the workshop is to give the property management, the landlords, the opportunity to come up and educate us on some of the issues, roadblocks, everything that it consists of in their daily lives. We also gonna have Adam, who has been with us all day. You wanna, well, you know who Adam is. And guys, I have to tell you, his last name is P-R-O-T-H-E-R-O-E. So when we got here, I said, I told Dr. Duckett last night, I said, we got to find him. I said, is it protuterus or protectorus, protectoro? So we're going to go with prothero. Can y'all work with that? Somebody help me. So we have Adam. Adam is with the South Carolina Appleseed Legal Justice. So we're going to have that. He's going to be a part of this panel. Dr. Duckett, do you want him to come up and sit here? We also going to have Miss Vicki Campbell. She's with Reedy Property Group. Are you here? Oh, there you go, darling. I'm sure you have quite a few accolades, but nobody gave them to me. But you have enough, you in property management. We also have Lawrence Allman. Mr. Allman is in property management as well. And we have Judge Jackie Duckett. Oh, I didn't know you were a judge when I was over there interrupting your conversation. I'm sorry. I'm glad I'm a law and abiding citizen. From the Gantz Summary Court. So this is our panel. Again, we want to encourage all the virtual attendees to ask questions. And we're also going to do the round table. Well, we're doing the round table and hold all your questions until the end. I thank you guys. Now I'm gonna go over here and try to take a nap.
All right, that was hard to follow up. I'm not that funny. Let me grab my water. Okay, so we've got about 10 minutes. And as Martin told us right before we started the quiz, because we're doing a virtual and an in-person session, we need to kind of stay on track so that the people who are online are able to log in at their appointed time. So it is 11:50. And as much as I would have loved Ms. Sheila to stay up here and fill that time, I'm going to try to do it just a little bit. And one of the things that I want to do, and then we'll at 12 o'clock, we'll revisit, is I'd like everyone to give those accolades who is up here on the panel, just so we know who we're talking to, who we're dealing with, what their area of expertise is. And as you formulate questions, you know who those, questions would be best directed to. We are going to have a little bit of extra time for Q&A because just when Adam was up just a minute ago, there was still a lot of questions out in the room. And now we have a whole panel of people to help answer those questions. So we're going to try to keep it on time. But since we've got an extra 10 minutes or so, we'll start with this part instead of wasting the Q&A time with, well, not that it's a waste to hear your accolades, because that's not wasteful, but we'll get it out of the way now. So I'll start with Judge Duckett, please, ma'am. Just introduce yourself. Tell us a little about you.
Good afternoon, everybody. I'm Judge Jackie Duckett. I work at Gantz Summary Court, 1103 White Horse Road. We specifically deal with civil matters and definitely evictions. And I always remind everybody, landlords have responsibilities and tenants have rights. That's one of my mottos. So I'll just pass it on to Mr. Lawrence Allman. I know Lawrence personally. He visits me quite often at my office. So that's just a small introduction to myself, and I'm here and available, and I'm glad to be here today.
Hello, everybody. I'm Lawrence Allman. I am a Greenville native. I've been in property management for the last 20 years. I manage currently a portfolio, which is currently family owned, about 65 units in the 29605 area. Mostly these units are, how you say, affordable housing, Section 8. We work United Ministries and some other nonprofit organizations.
Hi, I'm Vicki Campbell. I've been property management for 6 years now. I work with Reedy Property Group. I'm the director of property management operations with them. I've only had to see you once. So yeah, but if you ask Judge Fisher, it's a different story, but unfortunately. So we have an office in Greenville right over here on Pendleton Street, as well as in Spartanburg. We have well over 2,000 properties now that span all over the upstate. We have single family homes, duplexes, multifamily, you name it, we have it. And a lot of faces in here. I deal with y'all on a regular basis. We love helping out fair housing and anyone's Section 8, anything in any way that we possibly can. So come see us.
Thanks. So my name is Adam Prothero. I am a litigation attorney with South Carolina Appleseed, and there I work on our impact litigation work, which tends to be things like class actions, systemic change kind of litigation. But my background is most of the time as a housing lawyer. I worked for South Carolina Legal Services for about 8 years and was the head of their housing practice group for 3 or 4 of those years, I think. Done a lot of work in the private landlord-tenant area, but also a lot of work in public housing, Section 8, HUD, or USDA, LIHTC, all that stuff too. And some work at Legal Services in the fair housing realm, some work at Appleseed in the fair housing realm too. So look forward to your questions. Thanks.
Right. Well, that wasted exactly 2 minutes of the 10. So that gives us something. I'll introduce myself. So my name is Chantel Smith. I have been chosen by our beautiful Dr. Duckett. I call her Double D. Double D chose me to moderate this panel today, which was my great honor. I started off at Greenville County Human Relations Commission as an AmeriCorps Vista, Volunteer in Service to America, 7 years ago. I was 25. Well, I was however old I was that many years ago. And I came in, I was a full-time student at Greenville Tech, and I was working at the County Detention Center at that time. I learned a lot about Greenville County. I'm originally from Denver, Colorado. I learned a lot about Greenville County working at the detention center, all types of things that I said, oh, I have to get involved somewhere because this is not, I'm on one side of it and would like to be on the other. So Dr. Duckett offered me an opportunity to volunteer for her. I started out helping out with the first time homeownership class. And through that class, I was able, on my $13,000 a year AmeriCorps budget, I was able to purchase a home through a program, a USDA program. At that time, they had a program for low income, not necessarily single, but definitely low income under $20,000, where they exempted you from paying your rent for the first 6 months. If after those 6 months, you were able to show that you had efficient income to pay your rent. Well, after my time with Dr. Duckett, I got a job with Floor. So I was able to pay my rent, or I was able to pay my mortgage after that time. Floor led me to a stint in Afghanistan. So I worked for Floor as a procurement officer. I did 3 years in Afghanistan, saved every penny, came back, and I am now the proud owner of 7 rental units. So now I'm a full-time landlord. Thank you. So that's the journey, right? When you learn better, you do better. When you're given the opportunity to grow and you dive in head first, right? This all started with a first-time homeownership class. I just wanted to own a house. I just wanted to be a part of, as Toby, one of our other commissioners just said, chipping away at the wealth gap. And the only way I could think to do that was by owning a little bit of land. And now I'm in a position where I have at least one tenant who hopefully in the next 3 or 4 years will be in a position to buy the duplex that she lives in, and her herself will be able to chip away at that wealth gap. So this is, as you can imagine, very near and dear to my heart. And I've been a part of the housing fair, gosh, 6 or 7 years. She keeps dragging me back. She won't let me get away. And this year I actually became one of her commissioners. So it's completely full circle at this point, and I'm really proud of that, and I'm happy to be here. And that's all there is about me, because now we're going to talk to these good people. Did I waste the time? 4 more minutes. Okay. Let's see. Let me see if I can ask one question that we can just kind of get out of the way and get us started. And as people start logging on, they'll be able to sort of pick up what we're putting down. How about that? So I already asked what your role in the affordable housing system was and how long you've been there. Let's do this. Does anybody have a question that they want to make sure gets answered? Does anybody have any questions they want to make sure gets asked and answered while I go through this? Just because we've got a couple of minutes, and just raise your hand from your seat and just let me know, and I'll throw it on my list. Anybody, based on the credentials that have been given by the panelists, do you have any questions you want to make sure get answered in this process? Yes, ma'am. Perfect. Thank you, ma'am. We'll add that to the list and we will get to that. Anybody else have anything they want to make sure gets asked and answered during this panel? Yes, Mr. Toby. Yes. We already have one of those, so that's perfect. Oh, no, this is just for us. I'm just adding this into the questions just because I'm trying to waste those few minutes. Not waste. No minute asked question is a waste. This is helpful. We're utilizing those few minutes. So we'll ask how does fair housing apply to short-term housing? And we'll ask about dynamic shifts since COVID. Anybody else have anything they want to make sure gets asked? And just for my own edification, let's just do a tally of who's in the room. How many people in the room are landlords? They own the properties that are being rented. How many landlords in the room? Okay, so a few, definitely. How many are property managers? So they manage property where tenants reside. Okay. How many people do not work in housing at all and just came to hang out? Nobody? Okay, at least one. Can somebody just shout out for me so we have an idea of where everybody else works, just out of curiosity, what other organizations are represented? Just shout out. Yes, sir. Veterans Affairs, perfect. City of Spartanburg, United Ministries. Who else is in the room? Community Development, Spartanburg County. So we're all over the upstate. Yes, ma'am. GCRA. Greenville County Redevelopment Authority. Thank you. United Housing Connection. Habitat for Humanity. Awesome. Thank you. Yes, sir. Relentless Church. There we go. We knew you were in here somewhere. Nicholtown Neighborhood Association. Thank you, ma'am. Did we get everybody? Did anybody not hear their self-represented? Look at that, 11:59. They tell me I can't fill a room. All right, here we go. Take this off mute. That works. And we'll get into it now. So if you're just joining us online, I want to thank you all for seeing us during this lunch and learn session, for giving us your time during this lunch and learn. We have a distinguished panelist. We have a distinguished group of panelists today. We're going to be answering some questions about fair housing, landlording, prosecution, and convictions related to eviction processes. We've got some stuff in there about Airbnb, and we're going to talk a little bit about post-pandemic world and what that means for the fair housing sector. And with that being said, we've already introduced our panelists. So if you're just showing up, you're late and too bad for you. But hopefully as they get the microphone, they'll just quickly reintroduce themselves before they start answering whatever questions we have next. So we'll actually start right with Judge Duckett, since she's right here. We'll start right there. And this question is for all of the panelists, and it's because Adam has touched on this, and this seems to be a hot topic. We're going to talk about evictions. So the question, I'll give you this. Okay.
Thank you.
So the first part, we kind of already know the answer to, but I'm going to ask it anyway because I wrote it down. Have you ever been a part of the eviction or other legal processes involving tenants and landlord? What's the most common and most prevalent thing that you see in your court, or as a landlord or a tenant or attorney? What's the most prevalent and common thing that you see during that process and during the eviction process?
The most common thing that I see are returning litigants. They come and go, but then they're back again because basically they can't sustain the rent. And the most common thing I try to tell them is not have a place that's unaffordable, because they're stressing themselves out on a regular monthly basis, trying to keep up with the Joneses, as they say, when they could just find something more affordable and be at peace. So that's what I see most common, the same people, recidivism, as it's called, coming back and forth. And a lot of times the landlords have no choice to evict because they're bouncing around, developing a resume for evictions. And when I say a resume, every time they get into arrears, anyhow, the landlord will refile, and of course it builds up on the public record. And there is no way to alleviate that from the public record, I tell them. Once it's filed and sustained, it's there. You cannot, there is no remedy to remove evictions at this time by the state legislature. Criminal matters are different. You have expungements and things of that nature. Civil matters, the people that continuously go into a rearage stage and come back and forth, they just build a resume and it just builds, and there's no remedy to relieve that. So that's the most common thing I see, are the same litigants returning over and over.
Thank you, Judge Jackett. You can
Yes,
pass
ma'am.
that mic right on down and we'll hear from everyone on this question.
Okay, Lawrence Altman with Real Property Management. I guess I'm about to piggyback off what you said. Evictions on my side, things hasn't changed that much. So it was bad before the pandemic, and kind of bad after the pandemic. I would have to say out of the 65 tenants that I manage is about maybe 20% we had to evict. I guess since COVID, like a lot of other people with inflation, tenants having a hard time to save money. On a landlord side, the cost for repairs, property insurance, because the property is going up in value, we have to pay more in taxes and insurance. And it's been hard for us landlords as well in the regards to keeping rents low or moderate. But that's all I got to say with that.
Vicki Campbell with Reedy Property Group. Just like what y'all are saying, when it comes to evictions, the most time-consuming part is that it tends to be the same tenants over and over that we're having to go back for. The biggest thing I can say in regards to that is that so many tenants, though, if they would just communicate, I know a lot of them are afraid or they get nervous. They think that a property management or landlord is a big bad wolf or something, and we're not. We are here to help you too. We put you in this home for a reason. We wanted to give you a chance. So communicate with us. Let us try to work out payment plans or something with you so that we don't have to get to that level, so that we don't have to go to court and see you. That's the biggest thing, is just keeping that open line of communication so you can avoid it. Unfortunately, yes, people do get in bad situations. COVID luckily did not hurt us too bad overall. We worked very closely with a lot of agencies that are in here. We held events to where they could come and meet our tenants and talk with them to help them through these hard times. And we are forever grateful to all those agencies. And I know our tenants are as well, but that helped us tremendously. Evictions right now, they're honestly very few and far between. We're not seeing as many anymore. And we're just making sure that whoever gets, it's a matter of screening them up front, that you're putting the right people that can afford it, and, you know, giving them a chance that they can do it. So.
Thanks. Adam Prothero with South Carolina Appleseed. I would second the thing about talking with your landlord. From my experience, and my role in the process has been really exclusively as a tenants lawyer. The process is already broken down a good bit, oftentimes by the time you get to eviction court. And some landlords, in my experience, are really difficult to deal with and unreasonable. I think that's the exception and not the rule. And more often than not, it's helpful to at least approach somebody and have a reasonable conversation on the front end. And I find when that's happened, things are a lot less toxic, even if it does get to the point of going to eviction court. The other thing I would say is, landlords, get your notices right, please. Probably the most common reason when I was at Legal Aid that we got an eviction case dismissed was because of a bad notice. And that's not a lot of fun as a lawyer. You know, it's not like your Perry Mason moment. You had this really epic case. It's just like, well, that says 3 days and you have to give 5. And, you know, you have to start over. So get the notices right. When it comes to things like lease violations, be clear. make sure you give that opportunity to cure. Don't just say, hey, you broke the rules, you got to go. It's, hey, you broke the rules, you got to fix it. If you don't fix it, you got to go. There's an extra step in there. They're very, at least, strictly read, the law doesn't give a whole lot of opportunity to fix things, particularly non-payment. And so every single time a tenant's lawyer with any sense is going to jump on that and trying to make sure that the person gets what the law entitles them to. So, get those right. I guess those are the couple biggest things I can think of.
I was gonna ask you.
Yes, and to piggyback off of what Adam said about the leases, I've had experiences with a lot of leases developed by the landlords that you can put almost anything you want on the lease, but make sure it's legal. And when I say that, folks, just to let you know, I had a case one time, a landlord that actually put in his lease that the tenant could not own a firearm. And I told him he's violating his Second Amendment right to bear arms. That's a constitutional right. And the landlord actually told me, I've been in other courts and they sided with me. I don't know how that came about because the law is the law. And those are my exact words all the time. So make sure landlords, when you put things into place, that they're legal. You can't override the local, state, or federal government. And I have dismissed cases on that notion. So we have to do it by legalities, and we expect you to abide by that as well. Thank you.
I'll pass this on just to Mr. Alman. What advice would you give to a landlord who's trying to construct a lease? What resources are available to smaller landlords or property managers to properly construct a lease? And do you advise a consultant attorney, or just how do you all go about that as property managers and owners?
I want to say the South Carolina state lease agreement seems to be fair and already been, I guess, approved by the county.
Okay.
I want to say something else about evictions. At our company, we go back, you can't have an eviction within the last 5 years. Other companies, they go back 10 years, some are even longer than that. So I guess our eviction rate might be higher because we do try to give people a chance, as the other companies don't. So I just want to add that in there.
Just your opinion on constructing a lease and what you would recommend.
Constructing a lease, definitely get legal counsel if you can. It is forever changing. And in property management, something is different every single day, which is what I love about the job. Something is different every day and you see a different angle. So we are constantly looking through our lease, rewriting it, seeing we can make it better for mainly the tenant and of course the landlord, just protecting everybody. But we always go back and consult legal counsel.
Yeah, second that. I think the form that, sorry, I can't remember your name right now. Is it? Yeah, Lawrence, that Lawrence mentioned, maybe the Realtors Association lease. I've run into that a number of times and it seems to cover the bases. It could be better and it could be more particular to your situation. The thing about the lease, being clear is so important. So many things, so many of the fights that folks get into are when expectations are not made clear on the front end. You know, when are you going to show up to do inspections? How long is it going to take to do a work order? Those kinds of things. And a lot of that clarity can be expressed in the lease. I'm not a big fan of legalese, even though I end up writing some of it here and there, like plain language. You can explain this stuff in plain language, and a good lawyer can help you do that. Yeah, that's.
But to be honest, concerning the lease, most tenants don't read the lease. They don't read the lease. I try my best to disclose specific things I want to express in my lease because I know most tenants don't read the lease. I've had someone to create a tenant orientation video. Maybe they might watch the video. I've went to Vistaprint to list my 10 most lease violations on a sticker that I can put on the refrigerator. But I think I was on YouTube and I was, doing some research, and I remember a lady was saying that it doesn't matter what you put in your lease. You can have it 20 or 100 page. If a tenant is a bad tenant, it's irrelevant. But because tenants don't read lease, I said the best thing to do is do the, I guess, how you say, landlord verification. Check with the current and previous landlord would help you out better. You can just have a one-page lease, because a bad tenant is a bad tenant. If they don't read it, you know, it doesn't matter what you have in it.
Mr. Almond, that takes us right into another one of the questions I have here. What is your tenant verification process? And from a legal perspective, what things can legally be verified? Not what have you all seen, the attorney and the judge specifically, what have you seen that is just completely out of the realm? No, you can't call my grandmother's best friend from 10 years ago to ask her if I took her dog. Like what those kind of things that would be illegal or considered invasive. And at the same time for the landlord property manager, what is your actual tenant screening process and what resources do you use to get that done?
Okay, one of my first of all, qualifications, we ask for minimum credit score of at least 580. You can't have no evictions filed, you know, within the last 5 years. And landlord verification, you had to have a favorable, you know, rental history. But those are the main, like top three, you know, qualifications. For verifying these things, we know we do a credit report through a TransUnion Smart Move. We go to Greenville County public website. I can see judgments, evictions, but I tell most tenants 90% of my decision is based on your rental history. You know, that's about it.
Perfect.
So with us, we use a program named Appfolio, and all of our credit checks, background checks run through that program. With us, we do not look for a certain credit score number. The reason being for that is that credit scores can kind of, everyone knows, they can be different. So pretty much we're looking to see who you owe and how long you've owed. We understand everyone pretty much has a student debt somewhere along the line, and you have a medical bill. So we do not look at those. We look at everything else, more of day-to-day things. And then from there, we'll work with you. Of course, if you have a felony, that typically will put you out of the running for a home, just because we're trying to keep everybody safe. Now, granted, if somebody has something from long ago and, you know, it's been settled or whatnot, and we can kind of talk through it. And we see that, you know, when we're dealing, not calling you out, Cody, but when we're dealing with HUD VASH or something like that. And we'll definitely listen to you. And, you know, we want to be that person that also gives you a second chance. We want to help you out. Landlord reference, we do ask for them, but from one landlord to another, a lot of times we don't fill them out or get them. Yeah, y'all are all smiling. We don't fill them out or get them back. And to be honest, obviously in landlord reference, all you can really ask are yes or no questions. You can't get details. And some landlords aren't always honest on them, because you're also trying to get that tenant out of your unit. Yeah, I see y'all smiling. You're trying to get that tenant out of your unit. So we don't focus on landlord reference as much, because it can be very skewed. So we try to look at just your history, who you owe, how long you've owed, reach out to any references that of course you have put on. We cannot reach out to a reference unless you put them on your sheet or on your application. And of course you filled out the form that we can reach out to them. I can't just reach out to your neighbor because they or someone I've met in the line at the grocery store because they said they know you. I can't talk to them about you. So you have to give us authorization. But that would be the gist of pretty much how we run them. Mm-hmm.
Thank you.
Well, I don't do background checks, but I guess a couple of things that come to mind. And part of this harkens back to the question about COVID that you were asking before and pandemic effects. One of the things that we're concerned about in the world of housing advocates or tenants advocates is the sheer number of evictions that will have been filed because somebody fell behind because of the pandemic. And so when you're trying to find who are the bad tenants, there's going to be a large number of eviction filings that are not necessarily going to be indicative of that. It's going to be somebody who was working in food service and the restaurant closed down because nobody was going to restaurants. And so that's a real concern going forward, is how meaningful are these eviction records going to be? Because, you know, an eviction record through our court system doesn't actually tell you whether somebody was evicted. I call them not eviction records. Because if you actually, even if it says writ of ejectment, when you look at it, that doesn't mean they actually got removed, because all that process happens through law enforcement. So there's that concern. And the other thing too is back to a little bit of what I was talking about earlier with criminal records. There are three main areas, and HUD pointed this stuff out in some guidance in 2016, just some things to be aware of in criminal record screening. One is the issue with arrests. And I talked about that earlier. Arrest really isn't evidence. It doesn't tell you anything. And so using that, either an arrest or a charge, I think, could potentially be problematic. The other thing is not having some kind of a reasonable look back period, looking back forever, because all the research out there indicates that the longer somebody has gone without reoffending, the less likely they are to do so in the future. The older somebody gets, the less likely they are to reoffend. And so having policies like no felony ever, that kind of stuff has led to fair housing liability in the past. So it's something just to be concerned about. How you can, look within a reasonable amount of time. Most research I've seen says somewhere in the range of like 5 to 7 years is what, after that, somebody's risk of reoffending really starts to fall off. And then the last one is looking at offenses that really have nothing to do with housing, stuff that's either very minor or, like speeding ticket in California was my example earlier, but things that just really aren't housing related. Those kinds of things could be problematic for folks who are doing criminal background screenings.
Thank you. Judge Duckett, did you have anything you want to add? Okay, perfect. Let's see. So we'll get a little bit more into the COVID thing. Yes, sir. Can you come up to the mic for us, please, so the people online can hear? Thank you.
My name is Mark Fessler. I'm an attorney with South Carolina Legal Services, and I'll have the pleasure to talk to y'all in just a little bit. But I had a question to follow up on the screening part, because I get asked by my clients who are tenants all the time, about an eviction going on their record. And I explain to them, well, the best we can do is either have the case marked as dismissed or have it marked as settled. But my question is, what effect does the actual filing of an eviction? So if an eviction gets filed and it's, say, dismissed or settled, do y'all treat that as not an eviction, or does that still count as an eviction? Because I tell them, I don't really know how a landlord's going to look at that. The mere fact that it got filed may be the problem, but the best we can do, after it's been filed is sort of get an outcome that's not writ of ejectment. So how do y'all look at that disposition?
Yeah, and that's a great question. So when it comes to evictions, when I'm looking at your overall rental history that pops up, if I see that it is settled or disposed, to me, that does not count as eviction because you cleared that up. That's just like you had a parking ticket, you paid it, you did what you were supposed to do. So you did fulfill your obligation. The biggest thing when I'm looking at evictions is to see if you left owing a balance or if it is habitual. At the same, if I see that you have had 10 evictions and they're all settled, well then in my mind, I'm like, well, they probably have a problem with when payments due or something. So maybe that's the issue there versus if I see 10 evictions and they're all, non-settled or went to writ of ejectment, that's a bigger red flag. So, and that's where following back up with the courts and as a landlord and making sure that it's marked as settled or disposed or whatnot, that is your biggest thing in helping your tenants going forward. Because a lot of people forget to go back and do that.
Yeah, that does matter. If a landlord had to go and file an eviction, I know that's, I guess that could be kind of confusing because the landlord had to file doesn't necessarily mean that the tenant was evicted. But looking at the whole picture, usually if a landlord had to file, generally I see the credit score is low too, even though I said we try to look at a minimum credit score of 580. We still, each case is different. If they fall below our standards, and it seemed like they got things back on track, we would generally just request a higher security deposit. We try to work with many clients as much as possible because, to be honest with you, when it comes to affordable housing, it's just tough all the way around when you're on that, I guess, type of client that just have low income. You just have to, those are the barriers that they face. We have to take it all in consideration and try to weigh our risk. And like I said, we try to work with many people as much as we can. And on the way around that, just like I say, just getting a higher security deposit and maybe a shorter term lease, maybe we might do a lease for 3 months and then we make it conditional, might go a year after that. You know, but each case is different. But the main thing is making sure that they have enough income to afford the rent in the first place.
Thank you. And just as a FYI, this is an interactive lunch and learn, so you don't have to wait to the end to have your question heard. But I do ask that you raise your hand and ask for a mic, which I think I have up here. So you have to come up to the mic stand and ask the question. And as there's a break in the conversation, I'll get to people. So don't feel like you have to hold to the end for just this one particular thing, because Dr. Duckett has been clear, everyone else needs to wait until the end. But just to keep the conversation flowing and make sure we don't move past things that people might want to talk about right then and there. Do you have a question, sir? Yes, please, so that the people online can hear. So we ask that you come up to the mic so that the people online can hear the question.
While
Ma'am, you had
he's-
something else to
But I say,
add?
while he's
Yes,
walking up
please.
here, one more thing I want to add about evictions and how it shows on your record. One thing that never hurts, because like I said, sometimes courts don't always go back and mark them settled or whatnot. It happens, especially during COVID. There's a lot of stuff going through. It never hurts for a tenant, and we accept them all the time, if a prior landlord writes a letter to us telling us this was settled, it just hasn't hit their record yet or whatnot. Always be open to things like that. That'd be another thing I would say.
Thank you. Yes, sir.
My question is, as I was speaking to Judge Duckett a few minutes ago, is about the eviction, civil versus criminal. And I understand that the civil remains there. The criminal can be expunged. We were talking about a few minutes ago is how do you get that civil action off of your record? It has to be the legislation that does that, or what?
Adam can explain as well, but what I was telling them, because the state legislature has not put that into play yet, we have to go by the law. And there is no remedy at this time to remove civil actions off your record. Now, like we were talking, the criminal actions can be removed, some of them with an expungement, but civil just remains. And we've had people come through and say, how do I get this eviction from 5 years ago, as Mr. Almond was taking off my record? I'm like, it remains unless they change the law. And right now, the law states civil remains.
So what I'm understanding is that as you all are looking at someone who is, you're considering for tenancy, and you see that eviction on their record, that doesn't necessarily keep them from getting a place to live. That's what I'm understanding. It doesn't necessarily hinders them.
Right, it will cause them to have to pay a higher security deposit. It had to be some kind of compensating factor because it is a higher risk. But I guess some companies are just flat out, you don't have a chance. They just no. I guess it seemed like more bigger companies and more corporate. Like I said, I heard companies go back 20 years because somebody had an eviction file. I didn't know that. Wow, but.
And you all mentioned a few minutes ago about it being settled. I was under the impression when we were talking is that if the eviction's on the record and they're trying to get a place to live, that's going to hinder them. You said if it's settled. I'm thinking also if they file the eviction papers, and because I'm from Relentless Church, and our pastor Karen's that we get people all the time says, I'm going to be evicted. And I'm learning a lot here today because they say I need $2,000 to catch my rent up. The eviction notice has been sent into the court system. But if I'm understanding what you're saying is that if the landlord agrees to catch that rent up, they can still stay there, but that eviction that they filed will still be on the record.
It'll still be on the record, but it could be marked as settled or disposed.
And to piggyback off of that, Mr. Robert, what she was saying, the settled means there's some kind of satisfactory agreement was made, but it doesn't state what the agreement was. They could have paid it or they could have moved out in advance, things of that nature.
Okay.
But like you say, it's up to the individual property manager to determine if they wish to have that have that person as a tenant. Some property managers overlook all that. I've heard them say it. They don't bother them. They're just seeking a tenant. And some of them take it, like you say, Mr. Almond, more serious, like we looking at certain criteria just to have them as a tenant. So it's really up to each individual property manager. Because everybody's different, what they're looking for and what they'll accept them.
Okay, thank you very much.
Did you have something to add? Yes, please, Mr. Adam.
Sure, no problem. No, I wanted to chime in real quick on the issue of eviction records and sealing them or removing them. And Judge Juckett is right that there's no specific legislative remedy for doing that. There is in some states and some localities. I've been able to get it done in a couple of cases. And what the argument that I've made is essentially that courts have the authority to control their own records, including sealing their own records. And there's case law that supports that. There's a court rule that deals with record sealing and under what circumstances that can happen. I will say that of the 6 or 8 times I've tried to do it, I've only managed to do it twice. And those were very special circumstances with judges who, well, ultimately agreed with me, honestly. And it was where both parties, both the landlord and the tenant, were asking for that relief. The last time I got it done, it was our client was a tenant in a youth in transition program, and the property manager filed an eviction against this tenant. The directors of the program were very unhappy about that. They didn't want that to happen. The property manager basically went off reservation and did something her bosses didn't want her to do. And it was, in fact, the director, basically the landlord, reached out to us to see if we could help get that off her record, and wrote an affidavit in support of it, came to the hearing, took like an hour and a half to convince the judge that he could do this. So it's possible, but very difficult is I think my answer to that. And it's something that we as Appleseed are trying to advocate for more through the court system is, and particularly in light of what I mentioned before with eviction records and COVID, there are going to be so many of these records that not really necessarily indicative of a bad tenant or a chronic non-rent paying tenant. It's kind of one-off circumstances, but that record is going to be there. And if the record, if the landlord is using a third-party screening company, they're not supposed to use that record beyond 7 years, but it's still going to be there beyond 7 years. And if the landlord looks it up, it's still going to be there beyond 7 years. And so you got some folks looking back 20, whether that says anything about your tenant nowadays, I have a whole lot of questions. But anyway, I just wanted to mention that unicorn situation where removing an eviction record is possible, but really, really cumbersome and unusual.
Thank you.
Yeah.
All right, moving into not necessarily indicative of things. Let's talk about Section 8. So everybody kind of made a face, but we want to talk about it because we do have some folks on both sides of that aisle here today. And we want to, that's kind of the meat and potatoes of why we're here today. I myself as a landlord, I do have housing choice tenants. I have 3. They're my sometimes only tenants who pay their rent on time. God bless them. But they also are not responsible for paying me their rent. So I am very curious to hear from the property manager and the other landlord, and also from our judicial officials on the stereotypes that surround those things. What barriers do you see from people who may come in for the eviction process who don't want to rent to people with housing choice vouchers? And just your opinion on the program and how the programs are utilized, especially now when rent is becoming kind of unfeasible for a lot of people. So whoever would like to start, good luck.
Well, I have the mic, so I'll kind of start off here. The perspective that I see it from, obviously, as a tenants advocate and as an advocate for lower income tenants, is the real harm that folks face when they wait 5 years on a voucher waiting list and then can't find anywhere to use it. And at the end of that time period, it vanishes and they start back over. I see a lot of stereotyping and misperceptions about tenants who are receiving vouchers. And a lot of times these tenants are the same tenants that would be renting from you without the voucher. They would just be paying 70% of their income as opposed to 30% of their income under the voucher rules. Working with low-income families for a lot of years now, their struggles are everybody's struggles. And I think a lot of that stereotyping is unfortunately it exists, but it's not really well supported. I'll start with that and then hand it off to see what the other experiences are.
No problem. Section 8, I love it. I do, not gonna lie. He's looking at me over there. It is a great company to work with, whether it be Section 8, HUD-VASH, whatever department of it. It does come with some challenges. Typically, I'm not filing eviction on a Section 8 because of non-payment. It is, those go more towards of a lease violation. That's the bigger factor that you're dealing with in a Section 8. A lot of it comes down to when we are doing inspections or when they're doing their yearly inspections. They come in and, do the inspection and they say, this carpet's very dirty. You need to replace this carpet. And I'm like, well, okay, I can get it cleaned, but I can't replace the whole thing. They're like, no, it has to be replaced. And that's the part where it kind of gets tricky and it makes it harder on the landlord. Because it's not that you're shaking, because it's not something that we're not willing to do. But I just feel it needs to be looked at both ways. The tenant should also be responsible for keeping that carpet clean and whatnot. And that's where it puts the landlord in a tough position. As far as, do I fix it, or, is it a lease violation somewhere along the lines and we have to go that route? The overall program, the people that you deal with, the people that you're helping, it is a great program. We like to help out. We like to be known as the company that gives you that second chance, that can help you, or even if it's possibly your third chance. We want to be able to help you. So we focus heavily. We have great relationships with a lot of different caseworkers. They have us on speed dial, and we have them on speed dial, and we help in every way possible. But if they could just work out the whole inspection part of it, it would make things a lot easier.
Well, Section 8 is not my friend right now. My first, again, 20 years of affordable housing at 29605 area, my first tenant was a Section 8 tenant. And I was always for Section 8. During the pandemic, I started a Facebook group to have a place to where voucher holders could come and talk about the problems, the issues they might have with being a Section 8 tenant. Also offered up to landlords to join that group to post properties they might have for, for Section 8. Right now, there's about 317 people in that group. I guess since the pandemic, I guess the administration changed at the Housing Authority, and the inspections got more rigorous. They got more, I guess, picky. So during the pandemic, they weren't doing inspections. So I guess there was a lot of delayed maintenance with properties. So post-pandemic, they started doing inspections again. And I know they've been more strict than they ever have been, like they got a hidden agenda. It just unreal. And I felt, it bothered me deeply because a lot of these, I guess a lot of people have rental property as a supplemental income. To me, it's not a supplemental income, it's all my income. So I really feel it more than most. When inspection is good, because I don't like landlords either. If somebody got a roof about to cave in, a floor about to cave in, a house infested with roaches, I think they should be failed. But when the Housing Authority inspection go beyond health and safety, where we feel like they're nitpicking about things and threaten landlord with abatements, and where you're not going to get your payment because of they might fail it for things such as, okay, you got a cabinet where there's a knob missing off the cabinet. Why would you fail? That don't make sense to me. Your hood range vent, there might be a filter. It's a filter that in your hood range, and if it's missing a filter, they would fail that house over something simple as that. Doesn't affect. They should make a suggestion, but they've been real nitpicky. And it's costly. So a lot of landlords are getting deterred with the Housing Authority. Now they're looking at, if I can rent with all the red tape, if I can just go to the regular market, which is good right now because the rents are going up. So if I can go to the regular market and I have to deal with all the red tape, then they're starting to favor the regular market. Then the tenants are left out waiting 8 years to get a voucher, and there's no place for them to find. So a lot of landlords now, they starting to sell their property because the property is triple what it is. So now the pool is small and the charges are few. I'm assuming that Section 8 knows it's a problem. Have they reached out to me or any other landlord to say, well, how can we sit down? How can we work things out? They haven't. I think the wrong people there, I hate to say it, in charge is not really understanding the market, how the market is changing. They're not working with the landlord, having that conversation to see how they can make things better to entice landlords to want to accept those vouchers. But the market is going to do what it's going to do. And right now, being a Greenville native, there's an unlevel playing field. People from New York, Florida is moving here. They selling houses there and making a big $100,000 down payment. And people who live here, we can't afford that. The inflation is moving too fast. On my end, now we got repairs to the properties. Now the contractors are charging an arm and a leg. So, and then, okay, property values is going up, like I said, about insurance. So now my property done doubled. Now I got to get higher insurance costs. Taxes is going up. So all that's factored in. So it just makes it hard. I really feel for somebody that just don't have the income and they need the help with the voucher system gives them. They really need it. I see a lot of, I can say, affordable apartments are being built and everybody's being pushed in apartment. And me personally, I guess for a family have to grow up in apartment. I think the single family where you have your own yard is needed, but then when you have to grow up in an apartment and then and it gets rough in apartments, then you got restrictions with the apartments, curfews. It's just getting bad in Greenville. And I just think, you know, certain conversations is not being had. And I wish the housing authority would talk to landlords like myself. And I try to encourage other landlords to take the voucher, but most of them say they don't want to get tied with the government. The staff at the housing authority, they take, I guess the responsive tenants looking for a property, they are competing with the regular market and they need to turn in their vouchers to see if they can get, get inspection, get approved, but it's taking a lot longer for them to respond to the tenant's need because they're in a competition. Just so you know, with the housing authority, with that initial first payment to landlords, they can take up to 60 days to pay the landlord for his first payment. Landlords don't like that. And again, I think they have some staff changes and they have to maybe retrain some people, but they're having some issues at the housing authority and it's affecting landlords and the tenant. And I just wish they would have a better relationship with landlords, but they just not. And that it kind of bothers me with that.
Just a second, let me have Judge Decker answer. Yes, ma'am, go ahead.
As you can hear, there are pros and cons on both sides.
Yeah.
I am an advocate, not an advocate for either one. All I can say is as a judicial officer of the court, I remain neutral. But I can tell you, I always say as a missionary work to God, if there's a will, there should be a way. So offering people assistance is a grand thing of mine, so I don't mind at all.
There you go, thank you. Yes, ma'am.
For pointing those things out, particularly from a landlord perspective, because to your point, I had a property, I sold it for the very same reasons that you said. Things were going up and it didn't seem like there were much assistance for the landlord.
That's right.
I know there's a lot of tenant advocacy. Those things are well needed, but what advocacy are in place for the landlord? Because as the good judge said, tenants have rights, landlords have responsibility. But what's there to help advocate for the landlord, particularly on the financial side of the house, particularly as we have to raise the rent because of situations as you mentioned, but unfortunately we have to evict because we need this property to make money. But if we're handcuffed, then at some point as a landlord, we say, you know what, I'm done.
Yeah. I just want to really quickly, just for the people at home and for people in the room, today's session is about tenants and landlords. So a lot of the times that I have been involved in these housing events, they are tenant centric, which is to say we only hear the side of the tenant. I just want to point out for anyone who may be getting frustrated or not used to hearing this part of the commentary, that landlords, especially small landlords like myself, Tamiko was a small landlord, Mr. Alman is considered a small landlord. He is, well, I guess, yeah, you're under 100 units, so that wouldn't be considered institutional.
Small landlords are the kind of backbone of the people who make up the housing availability for housing choice vouchers in a lot of situations, especially if you don't want people to be in large apartment complexes that will sometimes turn into projects. So we wanted to have this conversation. Dr. Duckett and I, we talked about this event a year ago. And one of the things that she and I talked about and why this event went this direction was, I said, there's so many small landlords who just will not rent to housing choice vouchers, and I cannot convince them. And we wanted to make sure that those people had a voice to come into a situation with all of you who are responsible for, who have made it your life's work and your responsibility to get these people housed. We wanted you to have the other side and the other perspective. So I just wanted to say that because I can kind of sense it in here, it's getting a little rocky. I just wanted that to be known that that is a part of why we are here today. So with that being said, go ahead.
Yeah,
sir.
anybody work at the Housing Authority here? I'm gonna say, if nothing else comes out of this, you need to talk to us landlords, period,
Yeah.
point blank. And why you haven't done so is mind-boggling to me. Either you don't care or you don't understand, but you really need to have that conversation, because in order to be a recipient of the housing choice voucher, you have to be a resident of Greenville County. A lot of people are moving here that don't need that assistance. But the people, the natives, the people who's been here for a while, we really need it, and we're not being served correctly by the Housing Authority. I'm gonna tell you that right now. So I'm not gonna pretend, because I can't pretend, because some people waited 8 years to get this voucher and they found out they can't use it. This is heartbreaking when the time they need it most. So it's just no excuse for that. So I'm gonna let that be said.
Yes, ma'am.
My name is Iman Wabadu. I'm Program Director for GCRA, Greenville County Redevelopment Authority. I don't work for Housing Authority, but we work with them. Glad hearing from all aspects, which really helps me a lot. Starting with the 580 credit score and 5-year eviction. That somehow in my aspect kind of concerns me a little bit, because my goal is ensuring that people have access to housing, affordable housing, decent, and be able to attain that. Most of our clients, not all of them have the opportunity for that 580 score and 5-year eviction, especially when the civil eviction is never removed. And I don't know how you look at it when if you're just like, oh, it's 5 years, push it to the side. That really concerns us a little bit, because we have a lot of folks that don't have that opportunity. So we see a lot of people or families using hotels as their permanent housing. So that's what we're trying to avoid. Also like the fact that you have, yes, it's eviction, but we look at it to see if it's settlement or if it's settled or anything. So you're not looking at a sticker listing, but you're looking at a case by case. That really basically helps a lot of our clients. And then looking at another part where your question of small landlords, and which is something we're really concerned about, because we know that you don't really have the funds out there, or the banks are not giving those funds. As GCRA, one of the programs we really pushed starting last year after we did a housing study for Greenville County, listening to the State Housing Authority to give a housing needs, and realized that South Carolina is has one of the highest eviction rate in the country. So we really, yeah, exactly. Yeah. So that is really a concern for us, because maybe some of them, the eviction rent, what you have to pay is so minimal compared to other states. So something we have to look at, and that puts a lot of people in that list of eviction that really pushes housing, permanent housing away from them. So that's something we got to think about. But as a financial assistance to landlords, we do have a program we call Investor Program. We give up to $25,000 to landlords, small landlords, really pushing small landlords, which really low interest. And we work with you to see that. That way you can fix that house, ensure, and not pass the cost to the tenants, and keeping that house affordable. And so that makes, we see that we have more affordable housing for folks, and we're able to help the small landlords as well. In terms of inspection, it's very particular for us that we see that those things, we don't do the inspection for Housing Authority, but sometimes In one of the programs we have, we help folks that are either literally homeless or at least of homelessness. We will do inspection because we have inspectors that will ensure that the house is going to be safe. We're not going to cut costs because we're using federal funds to make sure that person is going into a safe and affordable housing. So we will look at public, basically any kind of public health issues that will affect that tenants. We will make sure that's done, because if something comes back, it's going to be back on us that we funded somebody to go in there and we overlooked an issue. So if it comes to there certain things that needs to be repaired, we can provide financial assistance to that landlord to fix it or to do more to that house, and people can be there. So that's kind of where I'm coming to.
One more time, ma'am.
Greenville County Redevelopment Authority.
Greenville County Redevelopment Authority. Thank you, ma'am. We appreciate that.
Thank you. I think I
Do
missed
you
the
have a question,
question.
sir?
Did she have a question? Or you
No.
made
I
a
just wanted
statement?
to make
Okay.
some statements.
Yes, and we
affirm
appreciate it.
some of the things
Thank
you're
you so
doing.
much.
Yes,
Right.
thank you. Sir, can you come up to the mic for me, please? Thank you.
Yeah,
Yes,
and I was gonna say also in response to GCRA, I do understand there's like a debate, like you say, like I was stating, pros and cons to each part. But in defense of everybody here, it's up to the individual landlord how they operate their business. So we can't just say Mr. Allman is doing anything wrong or his expectations are too high. It's just his individual preference. So I'm not
Absolutely.
on any side. I'm staying neutral, but I'm just letting you know there's pros and cons to every argument or debate.
Yeah, I guess to answer your question about the 580 score and eviction, with our company, we have to weigh the risk, but it's not like a flat out hard no, which most companies, they just say no. I'm saying, well, you pay a high security deposit, we can work with you, but it's good that you give a tenant at least some kind of chance. If I can pay a high security to compensate for that. And at the end of the day, with a landlord, all he just want to know is if there's damage, is there money to be paid for me to make the stuff you were responsible for that at the end of the day. And as long as he get his rent, is what he's concerned about. And if he know he has security, your eviction, all that stuff wouldn't matter to most small landlord company. But again, the corporations, you're gonna get a flat no. They're not gonna work with you no kind of way. Like you were saying, the small landlord is the backbone of this whole thing. And the small landlord is the one that gives the tenant that has a housing choice voucher to be able to rent a single family home in the community, instead of just piling people up in apartments on a certain part of town and put them in this one space. It needs to be spread it out. And I see back in the day what they call the ghetto. The ghetto is coming back. Right now, it looks nice, but people are gonna be piled up in those buildings. Is gonna go down and it's gonna be bad. I see that coming back. So those housing choice vouchers are very important. And to rub the landlord the wrong way where he don't want to use a program again, it hurts that relationship. And the housing authority needs to do better to mend that relationship in the future, because again, we're gonna need it. And I think people just really don't like having to grow up in an apartment. Kids grow up in an apartment, they want a house with a backyard with a fence.
And I was speaking to that as well. So you were talking about Section 8 and even a stigma on it or whatnot. It's not so much the landlord putting a stigma on it. It's more of the program putting a stigma on it, because you're not working with us to where we can allow them to come into our units. I fully believe that, yeah, they should be, you have a voucher. That doesn't mean you have to go live in this complex. No, you should be able to go to any home, but we need the housing authority to work with us so we can make that possible. I know granted, there's two sides. You have some owners that don't want to deal with it, and they may do that, but I would say majority of landlords around here in Greenville, especially small ones, they want to work with you. So please try to open that up. As far as GCRA, we have worked with y'all. Y'all's inspectors are great. Y'all focus on the important things in the home to make sure that it is clean and safe. And that's our motto. We want it to be clean, safe, and affordable. And that's what y'all focus on. And we appreciate that. Versus, I hate to say, but Greenville Housing, when they're sending their inspectors in, they're doing a inspection as if you were purchasing the home. A lot more thorough, a lot more in debt, and that's what's hurting us and stopping the landlord from wanting to accept it. Because then at that point, the landlord's like, oh, well, so if I fix all these, then I could put this up for sale. So they're hurting themselves in the foot. It's not that the landlord doesn't want to help, but they're stopping that process from happening.
Quick question. Check, yes, sir, go ahead.
Because a lot of your sentiments are my sentiments. And we are kind of in a negative cycle, right? The capital is increasing, the cost to,
Can you introduce yourself and your
My name's
role?
J.R. Stratton. I'm
Thank
so
you.
sorry. Thank you. And I'm a small real estate investor here in Greenville County as well. I primarily have duplexes, just so we know. But so we have this negative cycle, right? The rents are increasing, the cost of acquisition is going up, the money's getting more expensive, the repairs are more. A stove that was $400 2 years ago is now $600. So that security deposit you got 2 or 3 years ago doesn't do anything. So, but I have two suggestions. One, if someone were to come up with maybe, let's say, a baseline rent model, just say that a 3-bedroom apartment or a 3-bedroom house in Greenville is $1,200. Okay, $1,500. Whatever. I rent them for 1,100. So I'm not, I'm trying to do what I can. I'm trying to do. But my point being is, if there could be some kind of a baseline criteria where if a landlord was willing to subsidize at or below that level, they might get something reduced on their taxes as well. Because I have a 3-bedroom, 1-bath, gorgeous property. I would move my mother into it today, right across the street from an elementary school. I mow all my yards. I do all the landscaping. I do everything myself, everything. And I'm paying $4,000 a year on that property in taxes. I don't even break even on it until April 1st on taxes, let alone, the insurance and everything else, the maintenance and all the upkeep. So if someone were to say, Jaron, if you were to artificially drop that or leave it at, 11 or 1,200, we might give you some 10 or 15 or 20% rebate in taxes on the back end of that. That would allow me to subsidize a lower rent level to a degree. And just kind of make the quick second suggestion. A second suggestion is, and I've done this multiple times. I think I'm a forgiving landlord. If someone is late, I will work with them. When it's multiple times, I have a 3-strike eviction, a 3-strike late rule in my leases. If they're late 3 times, it's an automatic eviction. I usually try to forestall that as long as I can. I verify everyone's rent to at least 3, if not 4 times, their rent, in income, because I'm not trying to set anyone up for failure. But what I'm saying is, if we got to a point like that and someone does apply for that aid and assistance, I think would be a really good idea as well, is to have them go through like maybe a financial education course, because I think I have fairly well-meaning tenants. They make decent money because I wouldn't have letting them have the place to begin with. And I think they're just not making good long-term decisions. They're buying immediate or short-term things, and they're not looking at longer-term obligations that do trap them in a really negative debt cycle, poor credit, higher interest rates when they would go to get loans, and on and on and on. So those are just my 2 suggestions.
Right. All that, there's good ideas, but if somebody really care,
Yeah.
if somebody really
Yeah,
care, I
yeah.
mean, that works. So hopefully this video will get out. Maybe the powers that be that's at the county, at the housing authority, will come up with some kind of program to have those meaningful conversations. But
It's actually magical that you're saying this at this moment. The Greenville County Human Relations Commission has a program. It's called the Financial Empowerment Center. We offer no-cost financial counseling for an unlimited amount of sessions. We help folks build budgets. We help folks prepare their credit. We help folks negotiate with creditors, whatever you need. So if you need people to have that program, have access to that program, we would love to help. Anyone in North Carolina or South Carolina is eligible.
James? Okay. James, if I had a tenant, let's say we're at the 7th or 8th of the month, we're past the 5th, and I say, hey, listen, I'm willing to work with you as long as we can get caught up. But as a condition of us cleaning the slate, they have to enroll in your program. I would need a contact. I would make that a mandatory part of their kind of restitution as well.
Yeah, absolutely. We would love to provide that. So what we can do is part part of the final email will include information on the Financial Empowerment Center. Now, as far as verifying information with your tenants, you know, we will have to have their permission verified with you on that, right? So make that part of your.
There we go. Plug, plug, plug. That's why we're here. Financial Empowerment Center. So we're coming down to our last 5 minutes. We have lots more questions and things that I would like to discuss. Hang on just a second, but we are gonna run out of time here. So I'm actually gonna have to ask you to do final statements, closings, and then I can take maybe one more question. And as much as I would love to continue this, I keep telling Dr. Duckett, don't give me an hour because I'm gonna get the party started. You gotta give me 2, but she just won't do it. She just keeps putting me on lunch. So I'll ask, you can go ahead and say
The
whatever.
only other
you're-
thing,
and
and I'm
then
not
give your
taking away
closing.
from y'all, but Urban Upstate will also work with you. They have programs as well. They've come in and held conferences for our residents as well. They're more than willing to do that. Also in respect to that, we also work with another nonprofit called Just Say Something in Greenville. They offer all different kind of classes for our tenants as well, whether it be financial or family rearing, anything like that.
Thank you. And Dr. Duckett, if we can just get those 2, can you just make sure that somebody gets that information so we can get it on the final email that goes out to participants? And we'll go ahead and start with you for your last, just your closing comments and your statement. And then we'll take your question once we get it all closed out. We'll take one more question.
No, thank you very much for having me here today. Greatly appreciated this. If you ever do it, or when you do it again, if you want to make it longer than an hour,
That's what it's supposed to be. One
I will
piece
be
of
there.
advice.
Just biggest thing is talk with your tenants. Don't ignore them. Street goes both ways. Be there for them. Hopefully they'll be there for you.
Thank you. One piece, so I didn't ask what the final closing question was. Final closing question is one piece of advice for either a landlord or a tenant or someone who might be watching that you wish you would have known when you started on your journey.
Only thing I'm gonna say is this is this community effort from all parts, from the tenant part, from the housing authority, from the county part, and it just takes all of our input into making this thing better.
I would just say stay fair and equitable across the board. Don't mistreat, respect people, and accept, if they're trying to work it out with you, try to work it out with them. A lot of people, like you say, are seeking affordable housing and you are the key. So see if you can just reach out, help somebody along the way.
Thank you.
So yeah, as coming mostly from the tenant's perspective, the sentiment I find most common is tenants often feel kind of invaded in a way when repairs don't go right or when somebody shows up to knock on the door more often than not. And remember, it's their home, I guess, is what I would remind folks from the tenant's perspective. I would say more fights are started over things like access or how somebody's talking to somebody or something like that. And when a person or a family doesn't have anywhere safe to go, it really alters their life and their approach to everybody else. So it can be really tough. And I think the segment earlier about how to avoid litigation and so all those practical tips that you shared about how to relate to folks, I think those are hugely important. It's important for tenants to do it and important for landlords to do it. It is a landlord-tenant relationship, and relationship is key.
Thank you. Ma'am, did you want to ask your question? Very.
No, I actually wanted to make a comment.
Yes, ma'am.
My name is Daisha Alston Gordon, and I'm the executive director of the Easley Housing Authority in
thank you
Easley,
for
South
stepping up.
Um, So I had to get up here
ma'am.
and speak on behalf of the housing
you.
authorities,
Thank you.
because I've dedicated over a decade of my life to housing authorities. And just in listening to what was being said by the landlords, got to open up conversation. Public housing authority employees and executive directors, you have no idea the red tape that we have to go through. It's not that the inspectors just want to be difficult. It's that HUD won't even approve that voucher if those boxes aren't checked. So it's, you're giving us more power than we have. Like when I heard someone say, oh, the inspector's too, stringent and we can't afford those things. But if that's the only way to get it approved in the program, it kind of is what it is. So what I would encourage all landlords, and I know the executive director of the Greenville Housing Authority, I worked with her. I've also worked with the executive director of the Spartanburg Housing Authority. Very approachable women. All you need to do, call the office, schedule an appointment. They're public servants. We work for the government. We really can't tell you no, and let them know what some of your concerns are. And I promise you, they will be more than willing to work with you. And as you know, in any organization, sometimes you may just get on the phone with someone who just doesn't feel like working that day, but that shouldn't represent the whole company. So that's why I'm saying, I just wanted to get up here and encourage all of the landlords for whatever housing authority that offers Section 8 vouchers in your area, reach out to their executive directors.
Thank you.
Very personable.
Yes, ma'am. Thank you so much for standing up. I appreciate it. I wanted to ask if anyone from Housing Authority had anything to say, but I thought that might have been rude. So I decided against it. But thank you very much. Am I allowed? Can I go over? Okay, because I was told I had to stop at 1, but if I can go over, then let's keep going.
I
Go
got
ahead,
special
sir.
permission for this.
Okay.
Hi, Vicky. So my name is Jimmy. I work for Pendleton Place.
Thank you.
We work with homeless youth. I just want to take a moment to acknowledge Vicky and Reedy because they've really been the only ones, and I want to vouch for her because she's really been the only one in the community that's been willing to work with us to house homeless youth. So this is probably gonna bite me in the butt now because everybody's gonna want to work with her because we need her properties. But if anybody else is willing to be like her, please let me know. I'll be here all day.
Pendleton Place?
Yes.
Pendleton Place. All right. Mr. Jimmy, are you gonna have cards if people are interested? All right, so Mr. Jimmy will be around with some cards if you're interested in working with Pendleton Place, displaced youth housing, looking for homeless youth housing. Thank you. All right, we got one more thing, Mr. Almond.
Yeah, I like to close it up with this again. Most of my clients are single mothers. I like to close up, Daddy, you need to come home.
Uh-oh.
Because
That's too
mama
much
needs
for
you,
today.
your daughter needs you, your son needs you. You
Yeah.
need to come home.
Thank you.
Daddy needs to come home.
All right. Thank you all. And just a final thank you to our panelists for participating. Thank you to everyone who got up and asked the question. We appreciate it. You all have a good rest of your event.
What an awesome panel. Let's give them another round of applause. Awesome. Thank you so very much for your expertise. Hope you all have had a chance to learn some things. And remember, at 3 o'clock, we're going to come back and we are going to continue the conversation. If you have questions, lingering questions, you can ask them at that time. Next, our next session, you've been served. You have been served. Okay, all right.
I can actually say good afternoon now. All right, our next speaker is Mr. Mark Fessler. Mark works with South Carolina Legal Service here in Greenville. Mark Fessler graduated from Furman University with a BA in English and then attended the University of South Carolina School of Law, graduating with a jurisdiction doctorate in 2008. After passing the South Carolina bar, he began working with South Carolina Legal Service in Greenville office. In the wake of the housing crisis and the recession that exploded that year, he became focused on foreclosure law. He has co-authored an article about home affordable modification programs that was published in the South Carolina Young Lawyers Division in a periodical magazine. He was named South Carolina Legal Services New Lawyer of the Year. Yes. In 2015, he became the lead foreclosure attorney for South Carolina Legal Services. In 2018, he became the head of South Carolina Legal Services Housing Unit. He is former member of the South Carolina Bar's Consumer Law Section Council. With that being said, he has a lot to show. Let's give him a big hand.
see, is the mic on? Is that working? All right. I'm gonna have to cut that introduction down for the next time. 'Cause it rolls a little too long, but I appreciate it. And we at Legal Services have a great relationship with Human Relations Commission. And I want to thank Dr. Duckett for inviting us to present on an important topic, which kind of tails back into what my good friend, Mr. Prothero mentioned, I believe in response to the first question in the last session about one of the things he sees frequently are bad notices. And his opinion was, it doesn't create the Perry Mason moment, and so he might not like that as much. I love bad notices. As a tenants lawyer, the easier you can make the case for the judge, the better. So we're going to talk today about what notices are and how that plays into the eviction process and sort of go over there. Let's see, is there a clicker? Perfect. So an eviction process doesn't really start at the courthouse door. It starts before you get there. It starts with a proper notice, because the notice allows the landlord to terminate the lease in the first instance. And only once the lease is terminated can you then proceed to an eviction lawsuit, which is the actual legal process where you ask the court to retake possession of the property. And so we're going to talk about step one, and some things we're going to focus on are why are notices important at all? Some common questions and problems that come up that I've seen, what notice requirements there are under state law, and then notices under federal law. And federal law is going to really focus on the subsidized housing aspect. If you have a property that doesn't have a federal subsidy attached, you're pretty much just talking about the state law notices. And then we'll give some examples along the way that I've picked up over the, 12 years now that I've been doing this, to give you an idea of what some not so good notices might look like. But the purpose of notices, I think it's useful to think about, well, why are notices even given at all? Well, they're important because they trigger legal responsibilities, rights and responsibilities. They trigger the lease termination process. So if you want to non-renew a short-term lease, they trigger that. They trigger the landlord's obligation to make repairs. If a landlord doesn't have proper notice of a matter, then they're not legally obligated to make a repair. It triggers the tenant's obligation to cure a lease violation. If the tenant doesn't have notice that they're in violation of a lease, and you may think, well, they're obviously in violation. They've done something, terrible or something that anybody would know. But the law says you got to give that notice in order to trigger that, that cure period. They trigger things like returning the security deposit. And if the tenant wants to assert a particular defense called retaliation, the tenant has to give notice. If it's in the context of an eviction action, have to give notice to the landlord that they intend to pursue that. And then in the Section 8 public housing, subsidized housing kind of field, it also serves a constitutional purpose. And you may think, wow, we're talking about housing law. Where did the Constitution come from? But a Section 8 housing choice voucher, a Section 8 housing subsidy is a property interest that tenants have that is protected by the federal Constitution. And so giving proper notice serves a due process purpose. It's part of the process that that the subsidized landlord has to go through to constitutionally terminate a tenant's possession of that subsidized property. So that's why notice is important. It's not just something to just sort of be like, oh, it's no big deal. I'll just throw some words down on some paper. It's not going to matter that much. Because a bad notice can have significant consequences to a landlord. It can cost you time. If Judge Duckett says, nope, you can't have the eviction, notice is bad, you got to go back and do it all over again. It can also cost you money, not just in the terms of the filing fee that you have to pay for the eviction, but if you're trying to evict on non-payment of rent grounds, you've got to start back over. That's another month, maybe another 2 months of non-payment of rent if the notice is improper for that. Or if you're hiring an attorney, if you're using an attorney, attorneys know how to bill. We don't bill, but on the other side, $200, $300 an hour can add up pretty quickly. And in fact, I just had a case that wrapped up recently that came down to something as simple as a notice. And it was filed back in March of last year. The landlord hired an attorney, very good attorney, and they wanted to fight it. And it was, to my knowledge, it was just it was just a simple notice thing. Hey, dismiss this case. You've jumped the gun on it. Try again next time. Didn't want to do it. We filed a motion for summary judgment. The court, a year later, just last month, agreed with us, dismissed the case. So now that landlord has, it wasn't a non-payment of rent issue, of course, so, but now the tenant's still there. The landlord's paid that lawyer all that money, and, they have a little bit of egg on their face, I guess. I don't know. I say that in jest. I speak from the point of view of a tenant's attorney. But so it's going to cost some time. It's going to cost money. And also it's not going to, bad notices will not achieve the results that both parties want. So if one party wants the other party to be terminated, the lease to be terminated, you're not going to trigger that time period without the proper notice. Or if the landlord wants the particular lease violation to be cured, the cure period doesn't start until proper notice is given. So giving proper notice is important, and the consequence of not giving a proper notice can be bad. So what are the legal reasons why notices are required? And the answer to y'all is probably pretty obvious. It comes first from the lease agreement. So if the lease says you have to give a notice of a particular nature, you got to give that notice. Then you have the South Carolina Residential Landlord Tenant Act. So even if the lease says nothing about notices, state law builds in certain notices that have to be given in certain situations, and we'll cover those. And then under the federal subsidized housing programs, there are certain notices that have to be given, and also the content of those notices is pretty specific in terms of what it has to say. And so we'll talk about that. If you're dealing with something like project-based Section 8, the HUD Multifamily Occupancy Guidebook is sort of our Bible and our go-to for anything having to deal with project-based. There's also a public housing handbook that HUD puts out. And so all of this information can be publicly known, but fortunately for y'all, we're going to cover it today so you don't have to go search it down. So let's start with termination notices under the lease. This is important because of one particularly striking comment that our Court of Appeals has made in one case back in the 80s. It says that if a forfeiture provision in a lease is going to be invoked and the tenant losing that lease right depends on the giving of a notice, they're going to strictly construe that forfeiture provision, meaning they're not going to give any wiggle room. At least in this particular case, the Court of Appeals said, we're not going to give any wiggle room. And I think in this case, the issue was a non-payment of rent, and the notice was given, like the rent was paid up before the notice was actually given. And so it was a small minor variation, but the court said, we're going to apply strict construction to the lease, and we're going to require strict compliance with notice requirements that the landlord writes into the landlord's lease. So that's important. If there is a lease provision that says I have to give you a particular notice as the landlord before I can terminate this lease, the Court of Appeals has said strict construction is going to be our litmus test for judging whether the notice complies with the requirement to terminate the lease. Sometimes I've seen leases that try to duplicate what the state law says. So for example, state law has this 14-day right to cure notice, and some leases try to duplicate that, but sometimes they don't get it quite right. And so the lease may in fact, add an additional notice that the landlord may not have realized they were adding. So here's an example of one that I came across not that long ago. And it says, upon the failure of the tenant to make a payment of rent when due, or if the tenant should breach any other covenants, et cetera, et cetera, et cetera, this rental agreement shall terminate after a 14-day notice. State law does not require a 14-day notice in addition to the right to cure to terminate the lease. But just taking the language, the plain language, Mr. Prothero talked about writing things in plain language. Just looking at the plain language of this, it seems to suggest that there's an additional notice, termination notice, that the landlord has to give in addition to any cure notice. So let's say that the tenant had an unauthorized guest at one point, and the landlord sends a written notice, says you can't have an unauthorized guest, get rid of the person, you got 14 days to do it. And then 2 years go by, the tenant has another unauthorized guest. Well, the landlord's already given the 14-day right to cure that the state law required, but do they have to give another 14-day notice before terminating the lease based on the language of the lease? I think there's certainly an argument that that's the case. So, to tenants and landlords, read the lease carefully, because that's the first sort of line of analysis to determine what notices are required to terminate a lease. Then under state law, we have three general categories or types of notices. We have the non-payment of rent, which we call just 5-day notice to pay rent. Then you have notices, written notices that are required to terminate short-term leases. So these are things a month or less. And then you have the 14-day notice to to cure or terminate for just other breaches of the lease. So the 5-day notice to pay rent is written, there's a particular language that the statute itself includes. And the statute says, if you put this particular language into your lease, then you've satisfied the 5-day notice to pay rent requirement. It's a very easy requirement. And if I were a landlord's attorney, I would say this has to go in every single lease because it just makes things easier for the landlord. But the language that you give the tenant doesn't have to match this exactly, but it needs to be approximately close. It says, this is your notice. If you don't pay rent within 5 days of the due date, then the landlord can have you evicted. If you write it into the lease, or you can give it in a separate letter, as long as the language is something to this effect, that is satisfied. So it can be written into the lease. If it's written into a lease, it has to be what the law calls conspicuous. The law doesn't define what conspicuous means, but it means, set it apart from other parts of the lease. Enlarge the font size. So here's an example of one where I thought was pretty conspicuous. So it has the rent provision. If it's going to talk about rent, put it in the rent provision paragraph. Don't put it at the bottom where it's talking about something completely unrelated. It's set off, the text is all capitals. Some additional things that this lease could have done, you could have made the notice bold. You could have put it in bold font instead of just regular font, and you could have increased the font size. So instead of 12 point, you could have made it 14 point or something like that. But if it's in the lease, it has to be conspicuous. If it's not in the lease, then you have to give the tenant at least one written 5-day notice one time during the entire occupancy. And that's not the term of the lease necessarily, but just during the entire time the tenant is there. Because we see a lot of times where leases will have expired and the parties will just carry on paying rent, and then 5 months later, something happens, non-payment of rent. Well, after the end of the initial lease term, the lease will convert to a month-to-month tenancy, but that 5-day notice just has to be given one time, even if it's the beginning of the very first, day. It only has to be given one time during the occupancy. The 7, 20, and 30-day notices, these are to terminate short-term leases. So a lot of times people will rent a property and they won't necessarily agree on how long they're going to be renting it for. Or they'll agree on a year, but then you'll go well past the year. And so what does that turn into? Or you might have an agreement that says you're going to rent from week to week, a 7-day notice. And then there's finally a concept under South Carolina law that's kind of carried over from generations and generations ago, called tenancy at will. And that really wasn't removed when the Residential Landlord Tenant Act was passed, which talks about a 30-day month-to-month tenancy. So it's still part of the law. And so a tenancy at will has to get a 20-day written notice that we're not going to renew in the future. And my understanding of a tenancy at will is basically any time where you own property, you're letting somebody else reside or occupy that property with your permission, but there's no agreement. There doesn't even necessarily have to be payment of rent. This may surprise a lot of people. Payment of rent is not a mandatory term in a rental agreement in South Carolina. There was a case where an individual who was bitten by a dog wanted to sue the owner of property because the owner's children were living in the property, and the debate was whether or not the children were tenants of that. And the court said, well, and of course the owner of the property said, I wasn't charging rent. We didn't really have an agreement. It was just sort of, yeah, you can live here for a while. But the Court of Appeals said, well, there is no requirement that rent be charged to create a tenancy in South Carolina. So you can have a tenancy at will where there is just no agreement. You're just sort of occupying and you're there at the permission of the owner. And so that requires a written 20-day notice. When in doubt, give a written 30-day notice. Tenancy at will versus month to month, we're talking about a 10-day different here. That kind of gets into what lawyers like to think about, but practically speaking, 30-day written notice to vacate. Hey, we're not going to renew this lease in another 30 days. That's the best practical way to go about it. All right, I see the formatting on this slide didn't turn out as planned. But what that says there up at the top, it applies to almost all lease violations or violations of a tenant's statutory obligations under the Residential Landlord Tenant Act, other than non-payment of rent. So you set aside non-payment of rent. Almost every other lease violation or violation of the Residential Landlord Tenant Act, because even if you didn't have a lease, the Residential Landlord Tenant Act has responsibilities that the tenant has to abide by. The tenant has to keep the place safe and clean. The tenant can't use appliances and furnishings in the house unreasonably. So even if you didn't have a lease, the law sort of supplies some pre-made, ready terms there. And so the 14-day right to cure says if you violate the lease or you violate those statutory terms, the tenant must at least be given one opportunity to cure. The written notice needs to specify the act or omission. One problem that I see frequently is a 14-day notice just repeats and parrots language from the lease. It doesn't say what you did wrong. That's not specific enough, in my opinion, under this law. And then the termination notice also needs to say, not just you need to fix this, but if you don't fix this, the lease is going to end. So those are two things that the law spells out. And the law just, you might think about, well, what kind of things are required to get this 14-day notice? What kind of violations? What if it's something that can't be quote unquote remedied? It's not a hole in the wall that you can repair. The law doesn't necessarily just apply to things that can be repaired or cleaned or replaced. The law says if the issue can be remedied by repairs or otherwise, so it has this kind of catch-all, open-ended or otherwise language, which has been interpreted by some courts to include things like, noise violations past whatever the curfew hour is, or an unauthorized guest or an unauthorized pet, things like that. Things that you might not, things that might have sort of resolved themselves. And so there's not really a cure, but it's sort of more of a don't do it again kind of situation. And the law says, or courts have interpreted this statutory language to apply to those situations as well. Another thing to keep in mind is if the repair or the remedy is going to take longer than 14 days, the tenant has to at least begin the repair within the 14-day period and continue that repair in good faith, until it's completed. So it's not necessarily that the repair has to be done within the 14 days if it's a type of issue that will naturally take longer than that. So just to give you some examples of things that courts have applied this to, other than repair or replacement or cleaning. Offensive and noisy behavior. There was a case where a guy punched a hole in the wall. I believe in that case, the guy also forced a tenant neighbor who was in a wheelchair into a unit that wasn't her unit, and that was, harassment, of course. They applied it to that. Keeping an unauthorized dog or even a dangerous dog. So the case that I just resolved last month, the dispute was over whether or not the unauthorized pet that my client had was dangerous or not. And the landlord was saying, well, it's a dangerous breed, so therefore we didn't have to give notice. And I was like, no. Dangerous or not dangerous, notice is still required in either circumstance. Now, there are accommodations for actual emergencies, but just because a pit bull may be perceived as a more dangerous breed, regardless of the actual characteristics of that specific dog, doesn't mean that you get to skip the written notice requirement. So other examples, excessive use of hot water, unauthorized subletting, and then just general uncleanliness in the apartment. And courts have looked at the or otherwise language to say, yeah, all of that requires the 14-day right to cure. A lot of these cases come from decisions outside of South Carolina, but our Court of Appeals has said that because the statute derives from a uniform act, it's appropriate to look to other jurisdictions that also use the identical language or similar language from that uniform act, and we can apply those kind of cases, or we can at least argue them in our courts as an authority. Well, what happens if you have an emergency? Do you have to give the notice in the context of emergencies? Yes, almost always yes. If the breach materially affects health or safety, there is a requirement that the tenant has to comply as promptly as the conditions require. So if we have, I don't know, a gas leak that the tenant has caused, or something that's, an imminent issue, the notice doesn't have to be 14 days. You can say, look, you've got to fix this today or tomorrow. And also I'd point out that the landlord does have a right of access in the context of emergencies. So generally a landlord in most situations has to give some sort of advanced 24-hour notice, but if it's an emergency, the landlord has a right of access whether the tenant grants consent or not. So the landlord could go in and make the repair in that situation. It's not just that you notice, you have to give the notice first. But if it's something that the tenant can cure and should cure, but needs to be cured sooner than in 14 days, the notice can require that. Otherwise, the tenant still gets the 14 days, even if it's, if it's a roof leak, that would probably be considered an emergency. But is the roof an imminent threat of collapse? If not, you probably have to give the 14-day notice. Where the language about giving the tenant enough time to make the repair as promptly as conditions require, the statute is not entirely clear on whether that has to be written notice. Hey, you have a gas leak right now. You need to get back and resolve that today. If not, I'm coming over tonight to fix it. Something like that. That could probably be telephone. The statute doesn't say written notice specifically for that, but it does say that a 14-day notice, the 14 days has to be written. And then there is no notice requirement for a tenant who is conducting illegal activities or permitting illegal activities on the premises. What does that consist of? If the tenant is filing a fraudulent tax return on the premises, does that really count? I don't know. There's not really case law that kind of defines what the scope of the illegal activity is. I think a reasonable argument is that the activity needs to affect the housing situation, affect be a threat to the house, be a threat to the neighbors, affect health and safety, something to that effect. But conducting illegal activities on the premises is not necessarily, doesn't necessarily require a notice. So just a few practical tips before we move on. Put the 5-day notice language in the lease. It's very easy to do. And be specific about the type of violation that the landlord is observing or the landlord is trying to have corrected. Don't just copy and paste the language from the lease. For tenants, review the lease to see if it has that 5-day notice. If it does, then if you're late, if you're on the 6th of the month, legally speaking, the landlord could have you repaired. And then if the landlord does give a tenant a 14-day notice to cure, make sure you know what the deadline is. You don't want to think that your deadline is going to expire on Friday when it really expired on Thursday. I mean, the law is pretty black and white on a lot of things. And this is one, So this is an example of a non-specific or a 14-day notice to cure that one of my tenants received. And it does two of the things that really shouldn't be done. It just copies and pastes exactly from the lease. So it says, please accept this notice of a lease violation. The following directly violated the terms of your lease. Repair and maintenance. Tenant shall report to the landlord, blah, blah, blah. It doesn't say what the tenant did or didn't do, and then it says right of access. The tenant shall not unreasonably withhold consent, blah, blah. Who did I withhold consent from? When did I withhold consent? How can I respond to this if I don't really understand what I'm being accused of doing? And it also doesn't say, if you don't fix this, or if you do this again, the lease is going to terminate. So it has, two statutory problems. And the court in this case did find that the lease was not sufficient under state law. So let's talk about a few laws under federal housing. And so here we're not going to cover all possible types of federal housing, nothing under the low-income housing tax credit, but Section 8 public housing, those are the big ones that we see a lot. Then we have some notices that have been created and notice requirements that have been passed for federally subsidized housing in the wake of the pandemic. So you have CARES Act, and then you have non-payment of rent during a presidentially declared disaster, which is a new notice that HUD recently implemented not that long ago. So to terminate a federally subsidized lease, specifically public housing and project-based Section 8, there are very specific notice requirements. HUD puts together what's called a model lease for the project-based Section 8, and they also have a public housing lease for the public housing, or they at least approve it. And a lot of these notice requirements will be spelled out in the leases themselves If not, they're also contained in regulations, and they're also contained in the HUD's handbook 4350.3, I believe it is the multifamily occupancy guidebook. And so the exact notices requirements are available from a lot of different resources, so they really shouldn't be, there really shouldn't be mistakes there. But generally, the lease termination notices have to be specific about why the tenant is being terminated. So if the tenant has had 5 different lease violations during their occupancy, but the termination is going to be based on 2 or 3 of them, the termination notice needs to contain all of the violations that the tenant is going to be terminated on. I've seen a lot of cases where the notice to terminate the lease will contain 2 or 3 or 4 violations. And then when we get to court, the landlord wants to throw the kitchen sink, everything back to kingdom come, 10, 15 different violations. And my objection is always, whoa, no, your lease and the rules say that the eviction is only on the issues listed in the termination notice. Just because somebody had a violation a year, 2 years ago, if you didn't put it in the termination notice, it's not fair game for an eviction. So the termination notice needs to specifically list the issues and the incidents that the lease is being terminated for. General references to the lease provision are not adequate. If you're terminating based on a failure to pay rent, the actual amount of the rent needs to go in the termination notice. And there was also a case out of Connecticut, a subsidized housing case, where their Supreme Court said that if you include in that rent, so let's say the housing authority who says, well, you owe us $3,000, but 500 of that was really not rent, it was some other fee. By calling it rent, you invalidated the lease termination notice. And that was the decision of Connecticut Supreme Court in that subsidized housing case, which again, South Carolina, we're going to apply the same federal rules there, so it might come out similarly. The lease termination notices also have to describe certain tenant rights. They have to tell the tenant, you have a right to, in the public housing context, request a grievance hearing if you make the request within a certain amount of time. In the project-based Section 8 context, you have the right to talk to the landlord, request an informal meeting about that if you do so within a certain period of time. And in any event, you also have to be informed, or the landlord has to inform the tenant, that the tenant will have a right to defend him or herself in court, regardless of what happens. And so here's an example of a project-based Section 8 notice that one of my clients received not that long ago. And in my opinion, and I was going to argue before we resolved this case to the court, that this doesn't really meet the specificity requirement that the regulations contemplate. It says you are being terminated for repeated substantial lease violations and breach of the lease relating to the creation of serious interference with the rights and quiet enjoyment of other residences or management staff, residents or management staff. We don't know which, both, one or the other, I'm not sure. Profane and abusive and racial slurs directed, in that double highlight there didn't work out on the slide, but it says directed to management staff and on-site contractors working on the landlord's behalf. The language of the model lease is going to say that the termination notice needs to be specific enough to allow the tenant to prepare a defense. If somebody served me with a lawsuit that just says this, I would not be able to prepare a defense. Who was I alleged to have said something to? When was I alleged to have said it? What was I alleged to have said? Profane and abusive language, I mean, that's a conclusion based on specific words. Your opinion of what's profane or abusive may be different than somebody else's. But in order for somebody to be able to present a defense, you need to have more detail about what exactly happened. And in fact, a lot of courts across the country who are interpreting the same rules that I'm talking about have said, you need to list out, some have said you even have to include date and the person who was participating in the issue. One thing we hear a lot from landlords is, well, we can't give you the name of people who have reported things about you because that's confidential. But you have the regulation on the other side that says you have to give enough detail to allow somebody to present a defense and to formulate a defense. And how can I present a defense if I don't know who I was allegedly engaged in a dispute with? Maybe that person doesn't like me. Maybe they have a reason to manufacture and inflate and exaggerate things that happen. That's valid
that's a valid point of defense to bring up in court. And so there are some courts that said you need to include the date and the time and the participants in an incident if you're going to meet that specificity requirement. So moving on to the Federal CARES Act, the next two are really just about, well, before we move on, so incomplete notices are probably invalid. The eviction may only be brought on the issues covered in the notice. And there's also some delivery requirements. So notices for subsidized housing typically have to be both mailed and delivered before they can become effective. So the Federal CARES Act, the next two we'll talk about are just non-payment of rent notices. And the CARES Act applies to any property covered by the Violence Against Women's Act. So if it's a property covered by that act, it's also covered by CARES. It also covers Section 542 rural housing vouchers, as well as federal property or properties with a federally backed mortgage, which means a mortgage that's insured by the FHA, the VA, the USDA, Fannie Mae, or Freddie Mac. So if you're a covered property, you have to give the CARES Act notice. And what the CARES Act notice says is before you terminate a lease for non-payment of rent, so this would also include housing choice voucher properties as well. Before you terminate a lease for non-payment of rent, you have to give the tenant just a 30-day notice to vacate. It says non-payment of rent, 30-day notice to vacate. Under state law, you'd only have to give the 5-day notice to vacate. But if you're using a housing choice voucher, you also have to give a 30-day notice to vacate under the CARES Act. And there's been some question, some debate about whether the CARES Act has an expiration date or whether this part of the CARES Act has an expiration date. There's no expiration written into the statute itself. So there is a legal argument that this, unlike the eviction moratorium, which expired, over a year ago, that this doesn't expire. Now, in 10 years, is a judge still going to be listening to, oh, Judge, the CARES Act back in 2020, I don't know. But at least as of right now, I think that argument is certainly still viable. And then we have a new notice that HUD created recently, non-payment of rent notice where you have a disaster declaration. So somebody could correct me if I'm wrong, but I believe we still are under the disaster declaration that President Trump enunciated back in 2020. And what the rule says is that if the HUD secretary determines that the tenants need a notice, which the HUD secretary has, and there's funding available due to a presidentially declared disaster. So this is specifically targeted to address the emergency rental assistance funds that are out there. One of the problems was, hey, if people get evicted before they can apply to United Housing Connections and go through that process, aren't we just sort of like shooting ourselves in the foot as a society? So HUD says, all right, we'll build in some additional time here. We'll say that there has to be a 30-day notice, but it only applies if there's the disaster declaration and there's funds available. And surprise, surprise, currently there are funds available for rental assistance. Then the notice, the 30-day notice, has to contain the information that the Secretary of HUD requires it to contain, and the lease does not terminate for that 30-day period. And again, the goal was to try to, put some legs under this emergency rental assistance program, which I understand is doing pretty well, at least in Greenville, Richland, and Charleston, I've heard. And I think the rest of the state, SC State, is maybe catching up somewhat. So, I'm very thankful that that program exists. And this notice applies to the following types of housing. This was cut and pasted directly out of HUD's guidance material on this, so public housing, Section 8, and then all the other different types of HUD housing listed there. It does not apply to vouchers though. So whereas the CARES Act does apply to vouchers, this disaster declaration notice does not apply to people who are, leasing under a housing choice voucher. See how the law makes a lot of sense like that? So then some common questions that come up. All right, well, we have all these different notices. Can you put them all into one notice? The answer to that is yes, but be careful because the notice needs to not contradict itself. So you could include the 5-day notice to pay rent with the 30-day Federal CARES Act notice. That's fine. There's no law that says you can't do that. But you need to review it and make sure that that it's not contradictory, because again, a bad notice, if a judge says this notice does not convey effective notice, I don't really know what the notice requires the tenant to do. They'll show you to the door and you got to start all over again. Another question we get is an email or a text written notice This comes up a lot in clients will ask me, you know, hey, I've asked my landlord to make a repair. Okay, well, have you done it in writing? Yes. All right, well, how? I texted him. Does that work? I'm not sure. There's no appellate court decision that says whether a text or a written notice in the residential landlord context is valid. There is an interesting decision under non-payment of wages that says electronic communications can be written notice. And there are decisions from other states talking about the residential landlord tenant context that say, yes, an email is a written notice if that's the way the landlord and tenant have been communicating. I see a lot of cases where the landlord and tenant text back and forth, and that's their almost exclusive means of communication. And so the argument that a text is a valid written notice is much stronger if that's the form of communication that the parties primarily use to communicate. But the question to that is, it's unknown. If I'm advising a tenant or if I'm advising a landlord, my advice is do it in paper and email, probably, you know, more than one written notice, never hurt anybody. But that's kind of an open question. And then, you know, so if proper notice wasn't given, well, what do you do then? Well, you got to start over. Sometimes that means the lawsuit, the eviction gets dismissed and you bring it again. Sometimes that means you have to wait for another violation to occur, that violation is passed, that ship has sailed. It depends. This is an example of a 30-day notice to pay that tried to merge the 30-day notice CARES Act and the 5-day notice under state law, but did not do it successfully because it's called a 30-day notice to pay or vacate. And so it's issued on February 7th, and it says you've got to pay or get out by February 17th. It says, if you fail to pay or vacate by the above reference date, okay, well, the CARES Act says that the notice to vacate has to be 30 days. This notice says if you fail to pay or vacate within 10 days, it's a 10-day notice to vacate. It's not a 30-day notice to vacate. And that may seem technical, but again, there is legal precedent that allows tenants and tenants lawyers to argue that this is not a valid notice because it doesn't provide the requisite 30-day time period. So again, just read over the notices, think about what they say, make sure they're clear. Common problems include required information, and then lack of precision and being inconsistent in the notices is a big problem that we see. Just a few more practical tips. You know, don't mischaracterize rent. I see a lot of that. Call a spade a spade. The Residential Landlord Tenant Act defines rent to include rent plus late fees. And it specifically says it does not include other charges. So other charges should not be called rent in notices. Don't file for eviction until after the notice period. I've had a number of cases where the landlord filed to evict before the notice period expired, and you don't have a legal cause of action. You don't have, the lease hasn't terminated until that notice period has expired. So don't jump the gun on that. And it's always a good idea to use the actual language from the statute if you can. So then we'll talk briefly, and I know we're coming up on time, about the eviction process and how that actually works. But three things that we're going to cover: why the eviction's being filed, what the process looks like, and then briefly on appeals. One thing I wanted to point out, though, because I know a lot of people here, I imagine, represent businesses. There is a business representation rule. In South Carolina, it's illegal for a non-lawyer to represent a company in court. However, in magistrate court, there's a court rule 21, that says that a property manager or the owner, I guess, of property can grant somebody permission to represent them in court, but they have to have a particular certification on file. And so one of the things we do in court is we say, you know, Judge, you know, does Ms. So-and-so have authority to represent Landlord LLC? Do they have their certification on file? If they don't have it on file, the case will be continued and they'll have to have the certification prepared. So just an FYI as to non-attorney representation in magistrate court. So the reasons for eviction, for any of you who filed eviction, you know what the form looks like. There are three reasons: non-payment of rent when due or demanded, the lease term has ended, or there's a breach of the rental agreement. One thing I see in landlords filling out the application for ejectment sometimes is that they'll check end of lease term when really what they meant is non-payment of rent or breach of the lease, because end of lease term means just that. the lease was set for a certain period of time and that period of time has elapsed. It doesn't mean, hey, I've given them a notice that they've breached the lease, they didn't cure the period, and now the lease is terminated. It's going to be for the court to decide whether they breached the lease and the lease is terminated in that circumstance. So end of lease term really only should be for, we had a year lease, the year's up, end of lease term. Month to month, gave you a 30-day written notice to vacate, 30 days have gone by, end of lease term. That's really the only reason for end of lease term. Non-payment of rent, and then, breaching of the lease. And the just because, that's the end of lease term. Abandonment, this really maybe not isn't so much a grounds for eviction as it is, it gives the landlord the right to retake possession without really having to go through the court process. So the landlord cannot take possession of property absent judicial approval unless the property has been abandoned. And abandonment means an unexplained absence. So it's not like, hey, I'm going to be out of town for 15 days, plus the non-payment of rent, unexplained absence plus non-payment of rent. Or if the tenant shuts off his or her utilities and also doesn't pay rent, that equals legal abandonment. And at that point, the landlord can retake possession of the property and doesn't really need to go through the eviction process. So an eviction, it's pretty straightforward. You file the application for ejectment. After you have the right to terminate the lease, after you've given the proper notice and all that, then you file the application for ejectment. And an eviction, the argument there really is about possession of the property. It's not necessarily about how much rent is owed, although you could file a separate action to collect the amount owed on rent or other damages. But if you're just filing an eviction, the sole issue is possession. Once the landlord fills out the application, the court, like Judge Duckett, I'm sure has filled out hundreds of these, will take that and put it into a rule to vacate, and then law enforcement will usually go out. It's rare that a landlord hires his or her own process server, but law enforcement will go out and will serve the tenant, and then the tenant will have 10 days to respond. And if a landlord does not state a valid legal reason in the application, the magistrate will say, well, you can't evict on this ground. You have to come back with some other reason. But once the rule is issued, the tenant will then be served. And service is actually pretty liberal under the rules, in my opinion. They have to make 2 in-person attempts. Those attempts have to be separated by 8 hours. So you can't go at 6 o'clock, PM 2 days in a row. They have to be separated by 48 hours in time. So you could go at 11 in the morning or 6 hours after that, 2 days later. And they have to make an attempt, 2 attempts to serve the tenant in person. On both attempts, they have to post the rule at the property. And the third and final attempt, if they don't get a tenant served on those 2 attempts, is to mail it from the clerk. And the clerk has to mail that to the tenant with a certification that it's been mailed on a particular date. And then that triggers the tenant's obligation to respond. And for tenants, I can't stress this enough, respond. Oh, but my landlord said, don't worry about it. I said, we'll work something out. No, respond. If the landlord and you can work something out, wonderful. But if not, at least you have the ability to go into court, meet with the judge, meet with the landlord, and really kind of get on the same page if you're not on the same page. So respond. Some courts allow you to call and say, hey, I'm responding to this. I'd like a hearing. Some magistrate courts require you to go down in person and do it in writing. It just depends on that magistrate court's practice. The tenant also does have the legal ability to file a counterclaim. So if the tenant believes that the landlord has violated the law in some way, the tenant is allowed to counterclaim against the landlord, and then the court will hold a trial on that matter. If the tenant doesn't respond, the court's going to issue a default judgment and issue that writ of ejectment. And once the court issues that, it's really hard to unwind that clock, really hard. Not impossible, but very hard. And then at a court hearing, these are typically very informal. It's a lot of, well, tell me what's going on. Rules of evidence do apply. The magistrate court rules instruct the courts to relax those in the interest of justice. It doesn't really specify how that works. So the court has a lot of discretion to apply that as he or she sees fit. The landlord is the moving party, so the landlord does have to prove the case. The landlord can't say, I gave the notice, that's my case. All right, well, you have to prove that there was an actual violation in addition to the notice. And then the tenant, if the tenant has filed a counterclaim or has presented defenses, the tenant can present evidence on those matters as well. If the court issues the writ of ejectment, the courts usually will issue those 5 days to a week or so after the date of the hearing. Courts almost always, in my experience, rule at the hearing. Some might take it under advisement, but they usually rule at the hearing. And they'll give sort of a deadline about, all right, well, here's when you need to be out by. If you're not out, the writ of ejectment will issue, or they'll say, well, you can go pick up the writ of ejectment, but we'll serve it on such and such a date sometime later. Once the writ of ejectment is served by law enforcement, that starts a 24-hour clock, and the tenant has to be out of the property, or law enforcement can then come back and do the actual physical setup. So just some practical tips at court. Evidence has to be admissible. Things like hearsay is generally not admissible. Judges hate it when you bring your cell phone and you say, "Judge, look at my cell phone." The judge will say, "Well, I have to take that into evidence and I have to hold this for 30 days. So do you want me to do that?" Print things out, print photographs, texts, whatever. If you have audio, courts can be set up to play audio. Just contact the court and say, "Hey, I've got a video or an audio recording I need to play. How do I do that? What format do I need to bring it in?" Those kind of questions. Make every argument that you intend to make. If you lose at trial, tenant or landlord, you can't say, "Oh, wait, I forgot to add this." On appeal, you can't say, "Judge, I meant to argue this below," because the judge is only going to review what the lower court heard. And then, of course, don't disrespect the judge. There's no better way to tank a decent or even marginal case than to anger the judge. If you disagree with the judge, that's what appeal is for. It's not, "Judge, no, you need to make a different decision right now." That's what appeal is for. And then finally, appeal. Either party has the right to appeal. The requirement to appeal, you have 30 days after the date that you're notified of the judgment, which again, usually happens at trial. You have 30 days after that. The tenant is usually going to want to appeal before the actual set out happens. So the set out is often going to happen, probably always in my experience, going to happen before that 30 days runs. So the tenant's going to be appealing much sooner than 30 days. And the circuit court has the ability to redecide any issue in the case. A lot of times courts on appeal are just confined to the law. The circuit court, in reviewing an eviction ruling, can redecide facts. If the lower court decided that the tenant didn't violate something and the landlord appeals and says, no, my evidence was good enough, the circuit court could say, "Yeah, I take a different view of that." And that's permissible under our set of laws. So that just gives you an overview, and I'll be happy to take any questions anyone might have. Yes, ma'am.
My name is Jessica. I'm with the Greenville County Human Relations Commission. I wanted to cover one of the questions that was in the Zoom chat, which was where they could find generalized housing resources. I know it's kind of off topic for your panel, but it's HUD.gov. It'll also direct you to local housing, local or state housing agencies like the Greenville County Human Relations Commission. They'll help you direct to different resources. Just like if you were to call United Housing Connections or other places, they'll try and direct you to other resources. 211 is also a great resource. I actually had a question directly about abandonment. So how, as a landlord, would I have to verify that someone was absent from that apartment and hadn't returned within that 15-day period? And also, how could I prove that? So I, as a landlord, could say that I took possession of a unit after someone had been gone for 15 days. How am I able to prove that I waited 15 days?
Yeah, that's a good question. And, the rights that the law often allows you that doesn't really spell out, all right, well, how do we actually practically, go about it? You do need proof, because if the tenant shows back up and says, "Wait a minute, I didn't abandon this. I texted your brother or your, a lot of times you might have families and one person will own the property, but then somebody else will actually be the kind of point person for the operation, and so I notified Tom, but you're not Tom. I would say if there's property still in the unit, I wouldn't consider it abandoned. As a tenant's lawyer, I don't like to advise people to file evictions. If I'm a landlord's attorney, it's usually safe to go and get a judge's approval for that. But of course, tenant evictions being on the tenant's records can create problems. So I don't like to say, yeah, go sue somebody who is voluntarily abandoned. If the tenant has turned in keys, well, I mean, that wouldn't be an unexplained absence. That would be an explained absence. As you might imagine from me stuttering over the answer to your question, there's not really a good response there. If the tenant is gone for a month, hasn't paid rent, and the apartment's completely bare, that's probably the best case scenario for like, okay, this is a pretty good abandonment case. Or if, hey, Duke Energy or the utility's still on. Nope, Jane Ms. Smith called and shut them off 5 days ago. Okay, well, I'll just wait it out and, that kind of thing. But you do need evidence. You don't want to just hope. But there's not really a right answer in every situation there necessarily.
Will a certified letter mailed to that resident, requiring a signature, and you don't get that signature back within those 15 days, can that also be abandonment? Can you use that as abandonment?
That's a good idea. Yeah. I mean, even if it's not just you don't get the signature back, because that may or may not, I mean, I've sent certified letters that I don't get back within 15 days, but I will get back letters from the post office that say, no longer there, unable to forward, no forwarding address or something like that. So if you get a letter back from the post office that says, hey, the person you addressed this to is not occupying that property, with their little yellow sticker, unable to forward, I think that's really good evidence. Yeah.
I just want to piggyback off of that, Judge Duckett again. What I have been advised, well, not been advised, what I tell landlords and all is probably pretty much common sense. If you see a lot of property still left in the property or in the unit, that means they probably have not abandoned it at this time because they wouldn't leave everything behind. So if they take majority of the things and leave maybe a couch or a chair, you can assume that it's abandoned after that 15-day period. But otherwise, I would also reiterate, it's best to get the eviction filing so they can be made aware that you're seeking that. And basically, I'm sure they'll come back for something, or somebody will see the notice on the door in a conspicuous place, and then you can make a determination from that.
Yeah.
But I always say it's kind of better to go ahead and file the eviction to be on the safe side, so you won't get sued for discarding their personal belongings.
And then on the tenant side, it's always good. Make sure your landlord knows that you are leaving. Don't up and disappear. That can create problems down the road that you do not anticipate. So anything else? All right, well, thank you very much. And I'll be around if anybody has any further questions.
Thank you, Mark. That was excellent. And while we prepare for our next speaker, I wanted to remind you, as well as the virtual attendees, to remember to ask questions in the Q&A section. You can find that at the top right-hand side of your computer, your laptop, or whatever. Please make certain that you complete a survey from each of the sessions that we are having today. You can find them there. Also, please remember that the recordings, just in case I've had people to ask, recordings from this workshop will be placed on our YouTube channel. Okay, so you can find that link on our Facebook, or you can find it in the CVent document. You can go there and watch any recordings from this event. Okay, as we prepare for our next session, it is opportunities and advantages for housing choice voucher. I am so happy you are in this place because maybe you will be able to address some of the issues and questions that we had during our roundtable discussion. So, okay.
Hi, I'm Cheryl Hanshaw from the Financial Empowerment Center with the Human Relations Commission. And I'm excited to introduce Sean Williams to you, who's going to be sharing some information about the Housing Choice Voucher Program. Sean served as the CEO for the Housing Authority City of Greenville since 2020. She's had the pleasure to work with the industry of affordable housing for over 30 years, where she has worked diligently to ensure strong and sustainable communities and preserve and create quality affordable housing. In numerous housing authorities, Sean has restructured business functions and identified revenue sources to continue to create communities of opportunity of all families who deserve a decent, safe place to live. And just as a reminder, if you're here in person, hold all of your questions till the end of the session. And if you're online, please add your questions to the Q&A section. And please make sure you are filling out the evaluation form for each section, just to give us feedback as to how we can better improve things from year to year. And now please welcome me in joining Sean Williams.
Thank you, Cheryl. Thank you, Dr. Duckett and the Human Relations Commission. Okay, so nobody throw anything at me, first of all. Let's just start out with that, okay? So on behalf of the Housing Authority, City of Greenville, affectionately known as TGHA, I would like to thank all of you all for having me and participating in this session. So everything you always wanted to know about the Housing Choice Voucher Program, but were afraid to ask. Let's get started. What are Housing Choice Vouchers? The Housing Choice Voucher is a program established by the U.S. Department of Housing and Urban Development. Am I supposed to be moving this? Oh, okay. See, now we're getting fancy. Okay. By the U.S. Department of Housing and Urban Development to assist very low-income families, the elderly and disabled, to find decent, safe, and affordable housing. It's the largest program administered by the U.S. Department of Housing and Urban Development. This is an awesome opportunity for families to be able to utilize their voucher to find decent, safe, and affordable housing in any community. They can also go to another city or state. I personally would take my voucher and go to Hawaii, but. So, how do I apply? First, the wait list has to be open. That's with any housing authority. They will post that information or should post that information on their website. They will let you know if the wait list is open. If it is open, then you should go to where they're stating that you can apply. We had our wait list open last year and we accepted applications online. We also had a call center to assist those who would need assistance in applying for our program. Once we provide that information or obtain that information, we collect it. We look at the family composition, the income and assets during the application process. That's what we are asking for on our application, which is called the preliminary application. When will I receive a voucher? Okay, so since the demand for housing assistance is exceeding the limits of our resources, our financial resources, it takes quite some time. It could take years for an applicant to be called from the wait list. But when they are, be prepared. So when you receive that letter, it is imperative that a family is ready. So you need to have your income information, most recent information, documents, proof of birth certificate, social security cards, photo ID. All of that information is going to be required for our housing specialists to determine eligibility. The other thing that we would recommend all of the applicants to do is prepare to get ready. Prepare your credit check. We're going to do a criminal background check. The landlord can do a criminal background check and a credit check. We're going to verify citizenship status. We are going to verify that all the family members in the household, what their income and assets are. And by law, we must provide 75% of our vouchers to applicants not exceeding 30% of the area median income. Okay, so what happens when I do receive this voucher and I'm all excited and now I start to search? So by law, again, by HUD, we must issue a voucher for at least a minimum of 60 days. We try to do it for the whole 120 days because we know that it can be challenging for an applicant to find decent, safe, and affordable housing. With that package and that voucher comes an extensive amount of paperwork. All of that paperwork must be completed and filled out true and accurate, because the second most important document behind that voucher is what's referred to as the request for tenancy approval form. That's the form that is completed by you and the potential landlord. That lists the address, what utilities that landlord wants you to be responsible for paying, and what they'll be responsible for paying. That must be completed. It can be either returned by the landlord or the potential landlord, are the participant. If you are not, once the housing specialist receives that, they will process to determine if you are income eligible for that unit. If you are not income eligible because the rent exceeds what you're income eligible to pay, we, on behalf of the family, will reach out to that landlord to try to negotiate that rent. If we are successful, then we will process the paperwork. If we are not successful in trying to negotiate the rent, we do plead and beg on your behalf to try to do so. But that's really important that we really try to negotiate with the landlord to try to get that rent within your eligibility. Okay, so then what happens when you are eligible? The housing specialist then submits the paperwork, which starts an inspection process. The inspection, housing quality standards, as we refer to it, HUD states that the inspector must look at all of these items, 13 indicators, to determine whether the unit meets housing quality standards. Some of those standards are, again, the water supply. Make sure that there's not lead-based paint, that there are operable smoke detectors, that there are not tripping hazards, so that there's adequate water running. So all of those items must be checked in order to ensure that the unit meets housing quality standards. What happens after the inspection? Hopefully it passes, right? So if the unit passes the housing quality standards inspection, then we will obtain a copy of a lease from the landlord, because that lease must match with our housing assistance payment contract. So the dates have to match in order for us to move forward with processing the paperwork. If it wants to start the first day or the third day of the month, that's fine. But the housing assistance payment contract must meet the lease. The lease must be executed by the resident, and the housing assistance payment contract is executed between us and the landlord. Now, if the unit does not pass housing quality standards, we will try to negotiate with the landlord to see if they are willing to process that and correct the deficiencies that have been identified. And hopefully they will agree to do so. But again, the hope is that they agree to participate and move forward. What happens next? You and your family live happily ever after. That's the goal, right? However, we have a lot of rules in the Housing Choice Voucher Program, not ours. The U.S. Department of Housing and Urban Development monitors our programs very thoroughly. They want to make sure that our files are complete and accurate, that we are collecting accurate income information, asset information, family composition. They review our files. We upload all of that information to HUD for them to review and assess. So if there is a change in your income or family composition, if there is a change, if you get married, if you adopt a child, if a child leaves and goes off to college, and hopefully they will, then that must be reported to your housing specialist within 10 business days, because that could and most likely will impact what your portion of the rent is. Okay, that's me. Thank you for your participation. Are there any questions? I heard that there were a lot of questions from landlords. All right, come on.
Well, I wish we had met sooner, you know.
Well, we can go outside and meet if you want to.
Let me get right into it. The inspections, the housing quality standards. It says, you know, when I did my research, it says minimum requirements. And it seems of lately you got maximum requirements, going above the minimum. I guess y'all have your own, how you say, things y'all might have added to the standards, to the list. When we in the market where there's limited supply of housing, and we've got stricter on the how you say inspections, That's causing a real challenge for the landlord and the tenants.
Mhm.
I wish in your department that y'all had a liaison that would reach out to us concerning these issues. And I'm assuming that you know that it's an issue. I guess my question is, are you aware and what have you done to reach out to us landlords? And second question, I'm trying to get the men to come back home. So if you're a married couple, I mean, is it just housing transactions just for single? Or can you be married and still receive the voucher? Because if nothing else, at least the daddy can come home and babysit his own kids, if nothing else.
So, okay, so let me answer the second question first. Yes, a family composition, again, is a family composition. If someone's married, then absolutely, we don't discourage a family unit. We actually encourage families. But what we find a lot of times is that the voucher holder doesn't report that there's someone added to the household, because as I was stating, if there's a change in your family income or composition, you need to report that to us, because then that could impact your subsidy standard, the number of units or the voucher size that a family may be eligible for. It could impact what their portion of the rent is, because again, it's not fair to one participant to have to pay their fair share amount and another participant who may have extra income coming into the household where they are not, because they failed to report a change in their family composition. So the answer to your first question is that we did have a landlord liaison. We try to put that information on our website. We are working to modify our website, but we will reach out to you. My assistant is right back there. So thank you for actually volunteering to participate in our landlord outreach program. So we're gonna sign you up.
If you have any statistics, I don't know how many vouchers, what's the need and how many is in South Carolina?
Yeah, the need is please, baby, please, we need landlords. So we are looking for landlords to participate. I don't have the numbers. Ryan, do you have the numbers? Lorraine, do you have the numbers of like what we said, 10,000 affordable housing units are in need in the Greenville area? That's a lot of units. Just in Greenville City and Greenville County alone, yes. So there's always a need for decent, safe, and affordable housing. We are really trying to work with our landlords. We are actually starting a program that HUD approved us to participate in called the Moving to Work program. So we will be reaching out to landlords to try to engage them, but we want to hear from you. What's the barriers? What can we do to work with our landlords to try to expand our decent, safe, and affordable housing? So once again, Ms. Rice is right there. We'll take your name, number, social security card, photo ID, all of that information. Thank you.
Okay, I appreciate that.
Thank you.
Hello.
Hello.
My name is Mario Brown. I'm from Affordable Upstate. We have 1,000 affordable apartments here in the Upstate. We've worked with the Housing Authority. And a lot of the things that we're learning today seems like are kind of, what I want to understand, is it exclusive to Greenville, or are other housing authorities experiencing the same lack of participation from landlords and increased budgets with fewer opportunities? On the back of that, how do we become better partners, right? I think we're talking about the liaison and a few of those pieces, but as landlords, we feel like it's unpredictable, right? And though I may have the heart to stick in with that unpredictability, my small local counterparts don't, because it's easier than ever to rent something. Their property's worth more than it's ever been, right? Like, so how do we incentivize them to actually, through efficiency, to actually work with the housing authority and give us some of the 10,000 units we need? So kind of a twofold question. Thank you.
Okay, so let me make sure. So first of all, you know that I came and wooed and pursued you personally to participate as a landlord. So we're always, again, looking for landlords. So again, you're next on our landlord outreach. So thank you for participating and volunteering your
Just
time.
to be clear, we're from Greenville. We were always been a part of the program
Right.
well before you started. I guess my point is, How do we do more? It's about impact, not us.
So again, so we always are looking for landlords to participate. So when you're trying to list your community or your unit on our list, so our participants know to go and look at that list and update that list. So that's the main way to do it. If you are announcing that you have units available, you can do that. We can do that on our website. But it looks like I'm still missing.
You are.
Okay.
The reason why people aren't, as landlords, accepting Section 8 vouchers, which we need them to do, is because the housing authority is perceived as unpredictable in terms of the inspection. As Lawrence pointed out, is it this standard or that standard? It seems to be a lag between the day they sign the lease and my first payment. Those are the kind of some of the factors that are discouraging some of our colleagues with hearts that aren't the same.
Okay. So details like that. So again, depends on when the lease is signed and the housing assistance payment contract is signed. So that may be a difference of when a landlord is expected to receive their first payment. So that is kind of a depends.
Okay.
As far as, so what was the other question? The first question?
The other, is this exclusive to Greenville or other housing authorities struggling with the same issues of a smaller access to, less access to supply and budgets that have been increased by the government, right? We have more money, but less opportunities to deploy vouchers.
There are
right?
over 3,000 housing authorities throughout the United States. And I can assure you that most of them are experiencing the same situation. I have counterparts here, United Housing Connection. We are always looking for units. But again, when we start to do inspections, this is not a mystery. We're not trying to do a ha, got you situation when we go out and do inspections. So if you're having a challenge with the inspection, I provided you with my cell phone number, my information. Please feel free to give me a call. I'll come personally and walk through the unit with that inspector as well. But all of those 13 statements on there, those are standard. We do not exceed HUD's standard requirement of housing quality standards.
Okay. Yeah, and Sean, we've always had a great relationship. I'm really representing a lot of my colleagues that didn't want to come, didn't want to stand up, didn't have time to be here today. My friends that won't accept the voucher. So really, that's where these questions are coming from.
So again, please invite me to participate. I would love to come wherever you all are. I'll treat, pizza, wherever you are. We will come there and discuss it and try to work out the situation to explain. So if you're having a challenge, if there's a barrier, we want to work with all of our landlords to try to overcome any barriers or challenges that any landlord may be experiencing, because we ultimately know that the goal is to provide decent, safe, and affordable housing for families who need it in the Greenville area. Because if they cannot live someplace, they cannot work someplace, and that impacts all of us in Greenville. Thank you. I'll be talking to you, right?
Hi, Sean. Brian Brown, the Greenville Housing Fund. I think it might be helpful, if you could share with the group what the goal is in terms of timeline between tenant identification of a unit, RTA, and inspection, because I do hear that together that timeline is more than some landlords are willing to wait.
Yeah. So what we are trying to do is streamline the process, but I can't give it depends, because I can give it depends, because it depends on when we receive the paperwork. If the paperwork isn't filled out, then we've got to go back to the participant or the landlord. HUD requires that we have all I's dotted and T's crossed. So we want to make sure that our participants, we conduct a briefing for our families when we issue a voucher that is a 2-hour briefing to go over all the paperwork with them to make sure that they fully understand what documents are required and what's necessary. So that's the first thing that we do, is to make sure that they understand what their obligations are, and then go out and supply that information to the landlord and provide that information to the landlord. Once that's done, then we need to determine eligibility. As I stated earlier, if the rents are sky high now, and that's not just in Greenville, but that's throughout. A family receiving a voucher can only pay 30% of their adjusted gross income towards rent and utilities. So if that family who wants to go to a decent, safe community, a place to live, and that rent is $3,000, they're not going to be able to afford it. We can't afford it for them, but they fill out the request for tenancy approval anyways, come back, and then we have to try to negotiate that down. And some landlords are not going to be willing to negotiate that far down. But if we can, then we process that family's paperwork. Again, then it goes, we outsource our inspections. So then it goes to the inspection department. They then schedule the inspection. I'm getting information back that landlords don't respond, that they don't call back, that sometimes that's a delay. So again, that delays the process because we have to do that inspection. So as we become a moving to work agency, we're looking to see if maybe we can do an upfront inspection or work with some of our landlords who are already participating on the program to try to cut down some of that time. So those are some of the processes we want to put in place. But if until that landlord responds, then we can't do anything. We can't schedule the inspection. Once we schedule the inspection, we ask the landlord to be there. They have to get the work done. I mean, I've had some participants who've come back and said the landlord didn't show up or the landlord wasn't ready. The landlord stated that they weren't ready. That's time. Make sure that your lease is ready, that once that unit passes housing quality standards, that you can get that to us because we process that. Now, one of the things I can say is once that's executed, the lease, we match the housing assistance payment contract. We will retroactively pay that landlord that day. So it's not like we're saying, okay, you have to wait to the first of the following month. We will retroactively pay. We've got to get that information in our system. We need to make sure that we have a TIN or a social security number, that we have your information in the system. And so we can go ahead and cut a check or do an ACH deposit. So, wherever we can reduce the time, we are willing to do that. And that's why we really want to hear from the landlords. I want to hear from our landlords of process that we can do to reduce the time frame. But those are the steps that it takes. And anybody, put your hands up, who's worked with the government knows, thank you, that there's a process. There's a process. But we work as quickly as possible to try to address it and get your payment out as quickly as possible.
Sean, very quickly, this young man wanted to ask if other housing agencies were having the same issues with their housing for property. We have Greer.
Oh, Easy and Greer, come on up. Come on up, join me. It's enough space up here.
Hi, I'm Janice Fowler, Executive Director at Greer Housing Authority.
Hi, Janice.
Nice to meet
Nice
you.
to
We
see
met once on a
you.
Zoom call.
I know,
think.
right?
Yes. In answer to your question, yes, we have the same issues in Greer. We are always looking for landlords. We're always looking for decent, safe, and sanitary housing. And we welcome all landlords to come and talk to us. We are much smaller than Greenville, but we have the same process. So we have to go through all the same steps that she just named. So we go through all the same steps. We have a smaller staff. Ms. Knox here, I don't know if anybody's worked with Ms. Knox or not, but she's our main person at Greer. But we would love for any landlords in here who has property in the city of Greer, because our jurisdiction is the city of Greer. So, but we do have the same issues, same challenges, and our process is pretty much the same. Did you want to add anything, Jane? But yeah, it's the times that we're living in. We actually fall up under the same fair market rents as Greenville. So that sort of, the rents are climbing. And we know that landlords have that opportunity. I've heard it here today. They have the opportunity to make more money in the open market, to sell their properties. We've had several landlords to leave our program just because of that. And so because of that, and there's not a line of them standing to replace those that have left. So there's a need. And I think, as Sean has said, it's nationwide. So yeah, we do have those issues. Were there other questions? Okay.
That makes sense. It seems like it's gonna be a solution that we've got to generate in the community.
That's a community.
A lot of different approaches from the housing authority, landlord, tenant. We're gonna
Yes.
have to come up with this solution ourselves.
Yeah.
because Everyone's struggling with it.
Yeah.
Right, yeah.
I think one of the things you said earlier, it is a partnership, and I find that landlords who have more of a passion
Mhm.
for what we do, affordable housing, they're the ones that are gonna hang in there with us. You know, we appreciate the landlords that have spoke here today. We appreciate your passion for wanting to provide that fair housing. So I think those are the ones that are gonna stick around. And again, just like Sean, if you have any questions, we're here to answer questions in Greer. So just give us a call.
Thank you, Sharon. Appreciate that. Oh, I have a
Yeah.
hand back there, and then my landlord liaison person is right here again.
So I am Denise Harris, and I work for Homes of Hope. And so we are a developer of safe and affordable homes. And so we have a variety of property management companies that work for us. I deal a lot with your staff at the Housing Authority, and I will commend your ladies in their response time and helping us get things resolved. I've had a great interaction. What I've learned is when you develop relationships with the staff, it's easier. But one concern I do have with inspections, and again, you know, Yvonne them know that I'm the one that I speak my truth. With the inspections, I understand codes and violations and guidelines, and I'm not here to dispute any of it. But I am still here to say there are two sides to it. And so I'm not talking about the initial inspections when we are getting someone approved for the houses that are a concern for me. I'm talking about the annual inspections where a housing client, and we don't call them tenant, we call them housing clients because we serve them. And without them, we don't have jobs. And so we got to remember that they are our number one priorities. However, we have a lot of housing clients that will tear the houses up. And I mean, these are things above normal wear and tear. And we have to repair it, or we immediately go into abatement. The housing client feels like they're not expected to reimburse us for anything. And that's my concern when we try to talk with the inspectors. Like, you know, I have a property that I have to replace carpet, and the young lady has only been there 2 years. So the inspector comes in and tells me to replace the carpet that she's torn up. And if I don't get it replaced within a timely manner, I'm now in abatement. Or if I make these repairs and I send it to the inspection company, I'm still in abatement because the inspection company has not updated that we've made these repairs. But there has to be some help from you guys to help us hold these housing clients accountable, because I tell you they tear my property up. There's no consequence to them. And so those are some of the things that I would love to see us all come together and figure out what's a great working relationship to get some of these situations, because that's what makes us as landlords not want to deal with it. Because again, the cost of things are rising, they're not going down. And so you go and you tear up my carpet, and then I go and pay another $3,000 to have it replaced. And nobody wants to talk about, how did you tear up carpet in 2 years? You know, and so I would love for us to work together to see how we can find a happy place where all parties are being respected and taken into consideration.
Thank you for that information. So let me respond to that. I don't understand that either, because we terminate an average of 30 participants a month for violation of the program. Now, I'm not going to say that in front of legal aid because I don't want to get started with it. But we do a violation of if you are destroying the property, you cannot continue to participate in this program. We have put some of our families, because again, we don't want them to experience homelessness. So we will put them on a repayment agreement with the landlord. You cannot go anywhere in the United States of America and tear up a unit and it's okay, at least here in Greenville. That's just unacceptable to do that. So we have tried to hold our participants accountable for their actions. So we will be reaching out to you as well. Pictures, photos, videos, any of that information that you have, because we will call them in for an informal briefing, an informal hearing as quickly as possible. Once we get that information from that landlord to say, this is unacceptable. You cannot go anywhere, tear up some landlord's unit and expect to go to another landlord. We have landlords that, okay, so you're now moving from unit A to B. Did we get a letter from the landlord stating that the participant was in good standing? Some landlords, yep, just to get them out of their unit, then to go to another landlord and act out in bad behavior. That's unacceptable. Or the landlord doesn't respond to the housing specialist at all regarding a letter of good standing. So it is really, I agree. We work together to ensure that the program is working for everyone. Again, especially the families who need and deserve decent, safe, affordable housing. So we will work to address that. It is not our goal to terminate a participant from the program. However, if they are violating the program in more than general wear and tear, it is unacceptable.
Okay, because we have, like, again, there's a lady who left us with a $7,800 balance.
So then we need to talk offline.
Okay.
To talk
No,
further.
this is not, now I will say, this is not your housing.
Oh, well,
authority. Okay, but at the end of the day, Sean, there is consistency in working with housing authorities that seem to work more on behalf of the housing client and not hold them accountable. Because again, I have a lady with a $7,800 balance. First of all, she wouldn't even allow us possession of our unit. We could not even go in to do a 24-hour notice inspection. Because she wouldn't let us in and she would change the locks. And so we would change the locks and she'd change the locks again. But we're notifying the housing authority of the issue.
But it's not the housing authority, City of Greenville.
But again, it's still a consistent concern. So I'm asking, how do we handle it?
So we're my counterparts here. So if they are here in this room, this is the opportunity to discuss that with that ED or CEO, because here in the Housing Authority City of Greenville, we are not tolerating a family who has a voucher to destroy a landlord's property. That is unacceptable.
We are seeing a difference in your leadership and David's, where things are not, but we've had that experience here in Greenville as well.
Right.
And so again, I've noticed a difference since you've taken over and David. But we still have to talk about the elephants in the room. We want to keep skating around.
Don't want to skate. I'm willing to talk about elephants. Yes.
Okay, well, hey, Sean, how are you? However, speaking from a perspective of someone who utilized a property management organization to rent out my own personal home, it was destroyed by the people that lived there, and they were not on, they didn't receive any kind of public housing assistance, HCV, anything. And I was charging max rent, but they still destroyed my home. So it's not a matter of Greenville Housing Authority, Greer Housing Authority, or any other housing authority. When you're in this business, that's just a risk that you take, period. It's not, Sean really can't, we can't do anything about that because I couldn't do it when I was a landlord. It's just that individual that moved into my home, that's just who they were.
Will tear up houses. So I am not saying it's conducive to one demographic. That is not what I'm saying. But what I am saying is when you are under a federally funded agency and you continue to cross these lines and we're not getting some of the cooperation we need, that's a problem. But then when you also want to know why more and more landlords won't step up and, you know, take vouchers, all I'm trying to get you to understand is some of the why.
We hear you.
And, you know,
I
and
hear
so
you.
there have been a few times that we have talked about within my agency, do we continue to accept Section 8? And we are a ministry-based organization. And so we try to do everything we can to help. But when the tough conversations now we have to have of whether or not we want to continue to absorb these costs, all I'm saying is these are concerns. What can we do to fix it? And what can we do to be proud to be landlords, to help house as many people as we can, as well as talk to other landlords about the importance of signing on, because a lot of people are losing homes as a result of it, and a lot of landlords are shying away. So I'm not, again, these are just concerns that we have to.
I hear you. I do hear you. So let's, again, next week, get together to talk about and address your concerns. Hey, Deja, because I do feel that we can address these issues. A landlord has the right to go in a unit, giving proper notice to make sure that a unit is not being destroyed. If they want us to do a special inspection, we can do that to make sure that a unit is not being destroyed. So we do have tools and resources to be able to do the job, but we have to know about it. So if this is my first time hearing about it, let's meet, let me have an opportunity to address it. Then if we still have a problem or a challenge, then shame on me. But at least let us have the opportunity to address the challenges that your organization has been having with housing choice voucher users. Okay?
Hello.
Hello.
I just wanted to say to this young woman, or as a tenant that rents, I think that I feel what you're saying, and these are things that I've seen living in an apartment complex. And I feel like if you're getting a Section 8 voucher, if you're living based on subsidized housing, that when you see these type of things, there should be classes that the tenant has to take. And I think Mr. JR mentioned something like that. If you see this is repetitive, if you do an inspection and the place is tore down, hey, you need to take these housekeeping classes or whatever that looks like. I think that that may be a way to alleviate some of these things and issues that that landlords see, to make, and then hold the tenant responsible, you know.
Right.
So yeah.
Right. And thank you. So we do, again, a 2-hour briefing. Now we are talking about having other trainings, you know, to talk about housekeeping and what that looks like. Everybody's definition of housekeeping is different. There's some subjectivity there. So, you know, we're really trying to make sure that a family is aware that going in, putting 1,000 stickers on a wall is unacceptable. Tearing, I had 2 sons, they never tore the chandelier out the wall in the dining room. That's unacceptable behavior. We will not tolerate that type of behavior. So we, again, on behalf of the Housing Authority City of Greenville, will not accept a participant who is destroying a landlord's unit without further action.
Okay, this is about emergency
Housing voucher?
Housing vouchers. As you know, Greenville's growing, a lot of landlords are selling. Even though I guess, like I say, Housing Authority ain't my best friend right now, but I don't want to be deterred from taking a voucher.
Thank you.
When I see grandmother and grandpa come and they've been in a place for 15 and 20 years and they haven't to move, it just kind of does something to me. So how can I pass information or assist for his emergency voucher when it comes to situations like that? Or is there anything that the housing can do? Again, when somebody elderly, been in place for 20 years, now they have to move because he's selling. To try to speed this, because they're in a situation.
Yeah, so that's kind of one of those, if they're not on our wait list, we can't do anything if they qualify. So there's criterias for the emergency housing voucher program that eligible family has to meet in order to be determined eligible. So my best suggestion is to call United Way at 211, or I want to say, is Lorraine here? United Housing Connection, and find out what resources are available to families. United Way at 211 is the best resource because they will determine and assess what that family's needs are and try to make the accurate, appropriate referrals for that family.
Okay, and if we put them on a wait list, is it like a lottery system that could be next year, next 10 years?
So if the wait list is closed, we can't open it up just for like a family and put them on. We have to go through steps. HUD requires that we give proper notice, post it in the newspaper, make announcements, open, be prepared to accept it for families who may need assistance applying. So there's a process in order for us to open up our wait list. And it is our goal to be able to serve a number of families within a year, 2 years. It does not do a family any good to be experiencing homelessness and sitting on a wait list for 5 and 7 years. So that is not our goal at the Housing Authority City of Greenville to do that. So when we open the wait list, we're trying to look at the number, the capacity that we can try to take to ensure that families are issued those vouchers at least within 2-year time frame. But if they're not on our list, then we can't serve them. So that's what I'm saying. If they're not on our list, the best thing that we can recommend are other resources, and that would be the United Way at 211. No, I do not. I'm just going to say that we opened it last year and we accepted applications. Rochelle, do you recall how many? Over 8,000 or 10,000 people applied? Yeah.
Hi.
Hi.
Victor with BMI Southern States. I'm a property manager and I manage A-class and B-class properties. So I'm here to get information. How do I take, or how do we incentivize those homeowners and investors that I represent into getting involved in your program? Because all I'm getting back is the horrors of the housing authority.
Right.
So how do I get information to them, incentivize them to get and join this program, which is a good cause.
Right.
And I love the cause behind it. But how do I incentivize them to get into the program?
So again, we are looking at ways. So everybody's motivated or incentivized by different things. Some landlords, oh, I want 2 months rent security deposit. You know, I want an application fee of $500. So I need landlords to tell me, what is it going to take to attract you to participate in the program?
Yes.
What do we need to do? Do we need, how can we vet our eligible families better? Do we need to create a security deposit fee or work with some of our partners who have that? What is it that the landlord is asking for? You can answer that, or they can answer that question, because I'm here to get that answer. How do we recruit landlords to participate in our program? What is that going to take? What does that look like for landlords to do that? Okay. Okay. Okay.
Yes.
Yes. Well, wait, because are you doing a move out inspection? Why, where does it say that you, I mean, because you can give them notice and go and walk through. You don't have to wait for them to move out. Then you can do a preliminary walkthrough and at least have some idea of what's going on. I mean, you know, if they owe you rent before, I mean, you don't have to go to the unit and see if they owe you rent.
This is good.
Looked great. So Good answer, but I did not say that we need to have the letter the next day.
But they said they need that in order to get their voucher.
Exactly. They need that letter of good standing in order to get their voucher. We didn't say that the letter of good standing had to be the next day, but we are saying, once they turn over the keys to you, do the move out inspection, walk through, take photos, do a video, show us. Then that way you can attach that information to the letter of good standing or not and say, I am absolutely not standing. And here, Sean, this is why.
But the compliance department, I don't know who was in the photo, I would say countless people falls on their ear.
Okay, then I'm going to make sure you have my email address. Okay.
Listen, everyone, let me ask you something. Those of you who have questions, make certain you either walk up to the microphone or have a mic because the people online can't hear you.
And I'm sorry, the mic's not working right now anymore, so thank you. I'm just playing.
Are you trying to tell us something?
Do you understand the words coming out of my mouth? No, look, I'm here all night, folks, whatever you need. No, but I am truly willing and really eager to talk to landlords and to talk to our participants to discuss it. How do we come together to ensure that our families, again, who work at Walmart, who work at Panera Bread, who work at Starbucks, can have a decent, safe place to live close to where they work, so we can provide them with decent, safe, and affordable housing. So I am here. I will provide you with my information. I am sincerely asking landlords to participate in our landlord outreach, our landlord roundtable conversations, so we can find out what's the need, what tools and resources will help to attract landlords to participate. Now, if you're in Greer, okay, we can do Easley, we can do some of the other communities, but we really sincerely would love to have you participate. And I do want to hear what you have to say.
Okay, I just want to make an observation and a comment. First of all, it's just not Housing Choice voucher participants that tear up your home.
Right.
I currently have both. And just through observation, we have to look at the individual. We're talking about accountability, but accountability in most cases, it's not just, it's learned. And I give you an example. When I was a kid, my grandmother made us, it took an hour and a half to hang a curtain. We had to dust twice a week, maintaining our home. And trust me, I come from a very poor situation, but she made what we had into a home. Some of our participants were not raised that way. So you can't hold them accountable if that's all they know. So what this has just been going through my head a lot now, because I'm dealing with the same issues. And I was talking with my board about, first of all, we need to identify what is legal that we can submit, include into the lease, and what is not. Do some type of orientation on, look, if you break that blind, you gonna pay for it.
Right.
Because your dog, you can leave your dog in the house and he will look out that window and tear a blind up, but they just need to know. You cannot hold them accountable if they don't know, but it is something that need to be done, because I too had to spend about $2,000 this week for carpet, and the glass on the stove from what they used to call a Rick Racks. The ball hit the glass on the stove. It was the kids. So, but that's just my observation, and I'm willing to work with anybody on, just identifying what is legal, what can we do, what can we not do, and make sure that we both are held accountable.
Hi, I'm a resident and advisory board president. I'm also attendant, and I'm also with the commission of the city of Greenville Commissioner. So I'm speaking for all. Okay, I'm speaking for all. Okay, I understand the what the landlords are saying about the tenants tearing up everything. But what about when the tenants have something that need to be fixed and they don't fix it for days, weeks, months? And you keep addressing it to the landlords. Then they may send somebody out there and they don't do it exact right, and it tear up again. And then you just keep on and on. I have a tenant where I'm at that we dealing with that now. And landlord have doing it, everything. So not saying that y'all are wrong, or not saying that we are wrong, but then sometime when they don't fix it, they gonna come back and say, you gonna pay for that because it fell off again, or something like that. That's not right either. So the only thing I could tell somebody to do is take pictures of it after they fixed it, or sometime when you move in, it might not be something right. You know, apartments and stuff settle. When you fix stuff, they settle down at a certain year or whatever, and stuff start cracking up or whatever. How can you charge the tenant? And you know, so y'all have to understand us as tenants that we not always tearing up nothing. Something wasn't put together right. So you know what? So what you do about that? And I'm speaking as a tenant. I had an incident in my apartment where they came and tried to fix it. They the one said it was just a little cabinet, and it's supposed to be nailed to the wall, plus the little caulking that go around it. They was having an inspection. They came in and caulked it. And guess what? When I touched it again after that, they didn't even fix it. They just fixed it and made it look like it was fixed. Okay, so now who paid for that? Okay, but what if you can't just move out of there? Because some people on a low income, we can't move out like that. Right. We can't just get up and move like everybody. Everybody don't have money. So, but still, it should be something done about that too. They shouldn't just move me out and then turn around and move somebody else in. They're gonna do them the same way. That shouldn't happen like that either. They should be held accountable to fix that for the next person. Well, I'm learning in about 14 days notice.
I think we have more time. With that started.
From Pendleton Place. I don't really have a horse in this race because we do rapid rehousing, but if I can provide some feedback for you guys on things, the way we do things. So as a case manager, I have a caseload of 10 people. I'm available 24/7 to my tenants and to property managers. And as Vicky said, a lot of it is about communicating. So having a mediator between HUD and tenants and property managers, that's a possibility for you guys. I don't know why HUD doesn't do that, but we do that. Because I understand with your case managers, the load is like
430 average case.
right. So they don't really do case management. So maybe that's a solution for you guys.
What's the solution? So what am so I need to hire more people? Okay, yes. I'll tell HUD to send more money right now. Sure, okay, I can do that. Yes, I'll get on that right now.
So
Secretary Fudge, send more money, please.
It's not a perfect solution, but I'm just offering some kind of ideas and maybe you can work off of that.
Again, we try to visit those ideas. You know, our budget is set by the U.S. Department of Housing and Urban Development. I know our housing specialists are overwhelmed when you're talking about you have 10 caseloads and you're doing 24. They have over 400 caseloads trying to keep families housed.
Yep.
So
Well, I get it. I get it. HUD has their own rules.
yes,
So it's
a
about,
lot
like,
of them.
It's about trying to figure out, how to work around those rules and being creative.
Not work around. Nope, nope, nope. Work
Be
within
creative,
them.
To be creative about solutions.
No, work within the rules. Stay compliant.
And then the other one is the orientation that you guys have.
The
I know-
briefing?
Yeah, I know I've had clients come to these meetings
Mhm.
and I talked to them afterwards. I was like, hey, how did it go?
Mhm.
I don't know. I didn't understand anything that they said. They gave me a bunch of paperwork. I filled it out and that was it. So
So landlords are welcome to sit in on the briefing as well to see how it goes. So we welcome you.
Okay.
Thank you.
Thank you very much, Sean. Sean, I give you permission to take tomorrow off. Just tell your commissioners I did that. Okay, all right, we've come to the end of our sessions. I hope that you all have learned a lot. I need these chairs, these stools over here, yeah. And the individuals who will, yeah, I think I need 4, I believe. Chantel. Yeah. Is it one more person? Oh, James. Yeah. You? Yeah, just talking. Just talking. Yeah, just talking. Okay, all right. So you just. All right. Okay, so what we're going to do now is talk about what we've learned. We're going to talk about takeaways. We don't have, I wouldn't want to have you here all day. Could I have your attention, please? We're almost at the end. May I have your attention, please? I would hate to have you here all day and you don't have any takeaways, anything that you've learned that you're going to take back to your organizations. So we have this panel discussion. Please, may I have all the little chatters, if you all would just walk outside for a minute, because we're almost done. Okay. We won't keep you here long. Yeah. Okay, so let's go ahead and begin our takeaways. Oh, also, is Ashley on? Okay. Also, Ashley, our HUD director, promised to come back on and be here for us, and maybe you have questions that you would like to ask her as well. So I'm going to let the panel take it away. And let's just talk about what we've learned, things that we still have questions about. This is the time, this is the hour that we'd like to devote to that. Okay, go ahead.
Hello.
Oh, could you turn his mic on? Could you turn his mic on?
Hello. My name is Toby Sizemore, and I'm a board member for the Human Relations Commission, along with Chantel. Let me start off by commending Dr. Duckett on putting together an awesome event today, as well as the rest of the Human Relations Commission team. Great job, y'all. And for me, being a real estate investor, I'll say that I am leaving more knowledgeable than I was when I got here today. So thank you to all the speakers as well for sharing your expertise and knowledge today. Thank you. So James and Chantel, there were a few things that resonated with me today. First, starting off with Ms. Lowe. She talked about the fact that over 50% of fair housing complaints are disability related. And that was surprising to me and definitely gave me a different level of awareness and perspective. So that'll definitely stick with me. Adam, he talked to us about the history of fair housing. as well as redlining. So that also is something that I thought was very powerful. It made me think about the long-term impact on home ownership rates and the gap that we see there. And then as a byproduct, the impact that that has on the wealth gap that we see in America. So that was definitely food for thought. The gentleman from Colombia, I forget his name, Don. So he gave us some very practical tips for managing those landlord-tenant relationships. The big takeaway: never have a bad day. So I'm done with bad days. And then the last takeaway from him: if I ever need a ride to the grocery store, I know that he is not the person to ask. Okay, what about you, Shanto?
So again, to Dr. Duckett and the staff of Greenville County Human Relations Commission, congratulations on a wonderful event. And everyone who participated, thank you for coming out and participating. It was eye-opening for me. Just in comparison to events past, I think we did something special here. And I think we started a conversation that hasn't necessarily had a platform in Greenville County, at least not one that was dual-sided, right? So we got everybody in the room, all the stakeholders at the table. I don't know how easy that was for her to do, but Dr. Duckett somehow charmed everybody into getting set up for this. So thank you for that. One of the biggest takeaways for me, having come from Human Relations Commission and now being a private landlord myself, is how adversarial that relationship is between landlords, tenants, housing authority, affordable housing spaces in general. I am surprised by how adversarial it is, and I don't really know why. But there was a certain amount of tension in this room today that does not serve the greater good. Right. So landlords get a bad rap for only caring about money, and housing authority gets a bad rap for only caring about tenants. And I think neither one of those things are true. I think landlords don't get into landlording just for money, because anybody who is a landlord in this room knows that there's not a ton of money in it when you first get started. And in some cases, there's no money in it for years and years and years. You're just attempting to give people a place to live, especially if it's your hometown and you're investing in a community that you believe in, that you love. Maybe you're renting out your grandmother's house and you just want to keep your grandmother's house in the family, but it's too small for your 4 kids and your new husband and those kind of things. And so the relationship is very, very adversarial, which was really interesting to me. And I hope that somewhere along the line, especially with Sean, I appreciate her very, very much, that somewhere along the line, there are some conversations that these conversations continue, that they don't just stop in this room. Dawn was my favorite today, because Dawn reminded us that just being a good person gets you really, really far in life and can really, really help. And I think sometimes in our current political, social world environment, just in general, we forget that just maybe not addressing and assigning your singular issue, whatever's going on in your life, to every other person you encounter can be helpful. Sometimes, we know it gets hard. We're all living through this together. So just being nice, right? Just being kind, just being respectful. I think Dawn was right on with that. And I think that was the kind of reminder that we needed. Toby was great. I did last year for this same event, I did The Sum of Us, which was a little bit of history on redlining. And so The Sum of Us is a great book. I can't off the top of my head remember who wrote it, unfortunately. It was a great book about how wealth equality is not a zero-sum game. By someone else having something, it doesn't mean you get nothing. That's not what is happening in America. That's not. And for whatever reason, this whole conversation kind of devolves into that. It's us against them. It's landlords against tenants. It's housing authority against the landlords. It's not a zero-sum game. The better the housing authority performs, the better landlords perform. The better landlords perform, the better the tenant relationship and tenant experience is. The better the tenant experience is, the easier it is for landlords. And it just keeps going that way. And I'm just reminded of that last year in this. I can't get over just kind of how adversarial this kind of got today. I love it. I think the communication and the conversation is important. So I don't remember where I was going with that, but the history of redlining and the housing and the fair housing history is something that I think every landlord needs to know. You need to know what legacy you're stepping into, and you are stepping in. If you look like me, if you don't look like me, you are stepping into a history and a legacy, and you should know it. And maybe that will make you more compassionate to how you're treating and handling your tenants. If you understand wealth inequality, if you understand redlining in neighborhoods, if you understand why ghettos exist, maybe learn it. If you're a landlord and you're just doing it for the money, maybe learn housing history, maybe read a book, maybe watch a YouTube video, maybe learn the history of your city or your state, especially if you're from South Carolina, maybe understand where the families of your tenants come from. And you might be really, really surprised, and it may make you much more empathetic to where they are right now. Yeah, so there's that. I really loved our panel that I moderated. I think that panel set us up for a good afternoon, and I appreciate all the panelists who contributed to that. And yeah, I think that's all I got. It was a great event. I appreciate everybody for coming out. I unfortunately missed yours because I ran out after panel to make a couple phone calls. So I missed a couple people, but I'm going to rewatch those. And I encourage everyone at home, if you couldn't come, couldn't get off work to watch the whole event, go back and watch the recording. I think there was something in every single one of these pieces that was really, really important, and you might miss something if you don't.
Yes, so as a primarily financial counselor, I typically deal with tenants much more than I would landlords or individuals in the position to have access to the asset, right? And so today is really given an opportunity to see what the asset holders are experiencing and what the perspective is from, you know, the other side of that mirror, right? What really stood out particularly outside of the presentations themselves is how averse to risk a lot of property owners are, even though investments do come with risk, right? And so part of the federal subsidies are like a federal backing to mitigate and guarantee that you're not going to experience quite as much risk. So the conversation between tenants and landlords and individuals in HUD themselves, highly productive. We have to figure out how to mobilize legislators to increase the efficacy of HUD, to increase the funding to get more counselors to them. We've got to figure out how to get people who own the properties to be involved in the process of HUD as a means of guaranteeing equality across the board. We have to get the tenants involved. We have to get the landlords involved. You know, the history of redlining in the first presentation really stood out particularly for the rest of the day, because that was the foundation of everything we're dealing with. The systematic inequalities that have gone back for so many generations are what we're trying to fix. And today has been an opportunity to bridge that gap. It's been an opportunity to, you know, approach that edge, right? You approach these edges of comfort as you develop and you start feeling uncomfortable. And that means you're experiencing growth. And that tension was growth today. And so what we have to figure out is how to let that tension heal and how to build that as we go and how to maintain this dialogue and this communication. Because if we fail to maintain it across each other, then the fallout as our society is going to be so just incredibly massive. And so we can move the legislation on this, we can move the legislators, or the legislators can move this. And so the main takeaway from this is that there are processes in place and there are systems that are present, and it is hugely up to us to ensure that they develop and grow and that we develop sustainable systems that, you know, that don't cause like rent control measures to come in, that don't, you know, that we include these measures to help us all move forward as opposed to creating blocks to progress.
So Dr. Duckett, with that, do we open the floor for more questions or comments, or if you have takeaways that you would like to share with us? Any questions online?
Everybody's tired. We had a long day. It was a good one though.
Well, we're ending early, so all right, going once, going twice.
come up here.
Yeah, I wouldn't land on one thing because there have been so many different things. I think as an owner, one thing I was surprised by was that the tenant that shared her experience, the condition of that landlord, the people are that way. I don't see our organization that way. I don't see myself that way, but I do need to listen to your truth because there are people that way, right? And I think behind that, the friction that we all feel in the room between tenant, landlord, and the housing authority, that's normal. That's okay. Friction's good, right? But this group represents the backstop for the community, right? And to your point, if we don't figure it out and if we can't handle that friction in those conversations, what do we do? That's all of it, right? So I'd say that's it.
Jamil, United Housing Connections. I wanted to say, just coming into this, I didn't know what to expect. I just knew, looking at the titles for panels, that this would be things that are very pertinent to what I do. We represent the most vulnerable. Quite a few of the case managers that I work with are here. Jimmy, Vanessa, Jean Vernon was here. What I got from this is we need a lot more help from the top when it comes to HUD. What we do is like walking a tightrope with a sprained ankle and a 90-pound barbell. It's rough. Greenville, it's one of the biggest growing cities in the country. Everybody wants to be here. The vast majority of the clients that we serve cannot make it. They do not have the means to do so. They need assistance, and we don't have enough of it. We're trying to do the most good with the least. That's really the reality situation. That's what our clients face. With Housing First, essentially, realistically, we're handcuffed. Our hands are tied. We tried to do the most with the least. It's a very tricky state of affairs. I promise I can say with a lot of confidence that within the next 5 years, the cost of living is not going to go down. Homelessness, it's not going away anytime soon. And we need a lot more for this community.
Okay, after meditating on of housing in general, what I've concluded is it's all about family. The society is based on a 2-household income. You need 2 incomes, not 1. And the only way that we're gonna, be able to battle with today's society and affordability is that we got to mend our relationships. The fathers gonna have to come back home. Mothers and fathers and grandmothers will have to work together. I see a lot of grandmothers are taking care of grandkids as if they are the parent. And it should be the other way around. So in our community, I just know it's a lot of, there's a lot of, therapy needs to be going on, for that. Because without that, no matter how much money we try to get help, if we are not working together, it's just not gonna work in my opinion. So again, families we just need to get together and have a tough conversation in the churches and at home and just in general, because we will need each other.
Sir, I'm gonna give you a takeaways for the day. I can walk around with the mic now. Make you say something.
Yes, my name is Angela Cakes from United Ministries. My takeaway is about the 14 days and also the home inspections, which I conduct the home inspection for all United Ministries houses.
Hey, my name is Jeffrey Kitchen. I'm with United Ministries. I've been with United Ministries for 3 years. I've just been promoted to the housing coordinator. I think what I'm taking away today is there's a huge group of people caring about this issue, working, and I think we can really come up with some solutions.
Hello, my name is Jamaica Edwards. I'm one of the commissioners with the Greenville County Human Relations Commission. And I have a lot of takeaways, both as a commissioner. My full-time job is the crisis program director at the Julie Valentine Center. So sometimes there's some lapse in housing with sexual assault and child abuse victims, but also as a person who wants to I want to invest in the future. So had a lot of takeaways on a lot of different levels, but Commissioner Tamika and I were just talking about the ways that us as commissioners can help facilitate some future conversations. It was very clear that some additional communication can happen and can be beneficial in our community. And as Mr. Kitchens, although he's already left, said, there were a lot of people in this room with a lot of passion for housing, a lot of passion for the people in this community. And that is really kind of the foundation of us getting some good work done. So I'm really glad to be here. Thank you, Dr. D, and the whole Greenville County Human Relations Commission for putting this on. And thank you for coming out and participating.
Hello, my name is Tamika Rogers. I'm also a commissioner with the Human Relations Commission Board. Very simple, just to paraphrase, for lack of knowledge, my people will perish. So for today, a lot of good and great knowledge has been given. Now the question is, what do we do with it? The other thing that was said today was about relationships. There's so many relationships that we have to work on. Relationship between the tenant and the landlord and the Human Relations Commission. There's so many relationships that has to be worked on within our community. So we ask ourselves, what can we do? How can we contribute? Just stepping up, speaking up, just like the gentleman did earlier, speaking up on behalf of both sides. And finally, my third takeaway is the word accountability. How do we hold each other accountable to move forward, not to stay stuck, but to move forward? So I love the fact that there are many people here on the side of the tenant, but I also appreciate that there are individuals here that was speaking on behalf of the landlord. Because to your point earlier, this isn't a business that you go in and just make money hand over fist. This is a business that you go in because you have a passion to help those in the community. So we want to make sure that they are seen as well, just like our tenants want to be seen as well. No one should be living in a condition where they're being held accountable for something that wasn't repaired correctly. Likewise, no one should be put in a position where you have to pay thousands and thousands and thousands of dollars on repairs because someone didn't know any better on how to take care of a property. So we just have to work together. So I think those were my biggest takeaways from today. Thank you.
Just to add to that, anybody looking to get in real estate investing because it's passive income, they are lying to you. It is not passive. I just want to throw that out there. Would you like to give your takeaway, ma'am? Does she have a choice? I'm just kidding. Would you like to give your takeaway?
Did she have a choice?
Okay.
I would just like to say to Dr. Duckett, what a great day. Each speaker I learned something from and have little notes. So I'm taking away points overall. Met some very nice people here today. And I guess the main thing is that just knowing that there's a need, but there's also people who are willing to fulfill that need, have a passion for helping. So we know that there's a need, but we also know that there is a desire to help. So just sort of bridging everything together is probably my takeaway today. So.
Yeah, you too, honey. What are we? Just your takeaway for today.
Oh, takeaway. I don't even know where to begin. Honestly, I wish I was here at 9 o'clock from the beginning. Obviously I came in at noon, but I wish I was here earlier. I enjoyed honestly just meeting all the different sides of it. Obviously other property managers, but then even just every avenue that y'all are in this, it brought a whole nother light to it. And I truly appreciate it. I definitely want to be involved more with this. Thank you.
It's okay. There you go, Mr. Mark.
Thank you. Dr. Duckett, it was a great experience to be part of. I'm glad we're back in person and not exclusively online, although thanks to all you who attended online. I think one of the takeaways that I heard, especially listening from the landlord's point of view, is a lot of reasonable points of view were expressed. And I think whatever piece of the puzzle, I'm not using the word whatever side you're on because I don't like that concept, whatever piece of the puzzle, the housing puzzle you represent, there are reasonable expectations and there are reasonable people all around. And, you know, I think we can put our heads together and come up with solutions to some of the problems that have been brought here because the goal is worth it and the goal is important.
Well, first of all, I want to say thank you for inviting me because I too have learned a lot attending here. I think the most important takeaway for me was tearing down the silos. There are a lot of different organizations here that, you know, there are churches, there are all different sorts, housing authorities, regular property managers. And if we all just open up those lines of communication, I think that we have the answer to all of our issues. We just have to communicate it to each other. So my biggest takeaway is whatever I can do to, you know, share the struggles, the difficulties that, you know, housing authorities have, I'm going to do that. And I'm also going to listen, you know, from the other side of the table. So I think that was the most important thing for me.
Dominique Dawkins, Spartanburg County Community Development. Thank you, Dr. Duckett, Martin, and your team for putting on this amazing training. This is my first training being able to participate, so I'm grateful to you all, your team, and all of the presenters today. Just two takeaways. The first being, I appreciated, I think it was Adam in the first presentation. Yes. I appreciated that that his presentation, specifically his just kind of going into the proving discrimination when it comes to Fair Housing, the Fair Housing Act, specifically disparate impact and treatment. Yes. I appreciated his examples of that. I just feel like me learning more of what that is helps me to be better at my job, recognizing clients that do come in or tenants that do come in about, we're still doing the rental assistance program. So we're kind of seeing a little bit of everything. So if I see a situation like that, being able to recognize it and follow the proper protocols and making sure that the tenant is aware of what their rights are. The second takeaway I had, I will tip my hat off to Judge Duckett in your presentation on the panel about it's your property, but their home. I love that. I came in thinking that this would be, I guess the conversation would be steered a little bit more towards tenants. I will be honest, and being able to now walk away fully immersed, knowing that the conversation is more than just tenant rights, which is a huge component, very important for tenants to know their rights, but also understanding the struggles on the landlord side, as well as it being a lot more complex, a lot more gray when you start involving housing authority, the county, the city. We are your next door neighbors, Spartanburg County, and we are seeing the same thing. And I'm very new to my job, but being very new in my small department, we hear the same things. We're experiencing these same conversations. So it's very important. And I appreciate being able to take away some of what I learned today to have the conversation with my cohorts and peers. So thank you.
Hi, I'm Vanessa Johnson with Project Care. Dr. Duckett, thank you so much. As always, I enjoy fair housing. It is so important My takeaway today is that I am so glad that everybody came together and we are striving to work on rebuilding these relationships to help serve the population of people that we have.
So much. Excellent. I want to thank Martin for the invite, Dr. Duckett and the Human Relations Commission for inviting me to be a panelist today. I truly enjoyed it. It was my first time, but my time was well spent and I truly enjoyed yours. I just want to say the pros and cons, that's what I stated on the panel. That's everyday life. You're going to have people for and against in almost any subject that you bring about, but it's indicative that communication is key. So with communication, effective communication being the key, it also lends out to the response. So we need to have a response to some of these things that went on today, and hopefully next time we'll move forward.
Hi, my name is Sylvia Palmer, past president of the Nicholtown Neighborhood Association. You probably heard of me. I'm everywhere and I speak out about all that I see that's not going right. But the thing about the need for affordable housing, I know, but I don't know a lot of people who do know. We're talking about two different categories. What's affordable for our people who are workforce people is a whole different thing from someone who sold $1 million house in California and came here and they're able to buy a house for $200,000. To them, that's affordable. And we do a lot in Nicholtown to try to make a difference in that gap. And learning today a little bit more about what Human Relations does. I know they're good people. I've sent people to them for help. They are a godsend to Greenville. Thank you, team, for what you do. And the key is for us to go back and tell as many people as we know about what we've learned here. And this is my second venture with Human Relations and Fair Housing. And each time I've come or been a part of it, I've learned something totally different. Like today, I learned that I qualify for about 3 things on the disability list. And I said, okay, I already got my placard. So if somebody stops me and say, I don't see your physical disability, sugar, it's up here. You gotta love Miss Sylvia. That's all I gotta say. But I'm Inez Morris and I'm with the West Greenville Neighborhood Association, and I'm actually not in fair housing, but I came, or housing period, but I came today because my neighborhood is important to me. The people in my neighborhood are important to me. And so I came to learn, because I'm always getting questions about fair housing, about clients, about tenants, about rights, you know, and they were talking about cleaning, you know, some people just need to know how to clean their houses. I'm like you, I'm from the old school. You clean your house, you had the wooden floors, but you mop them floors every Saturday. Well, we did it every Saturday, okay? And you made your bed up, you kept your house clean. And I'm a renter, but I also have been on the other side of being a landlord. And I understand both sides of it. I understand what Denise was saying. You know, you can't tear up somebody's house and $2,000 repair and then expect to continue to live there. And so knowing your rights as a tenant and knowing your rights as a landlord is so important. And so my takeaways is just to be able to take this information and go back to my neighborhood and be able to say to people who call me, well, my landlord didn't do this, or my landlord didn't do that, or, you know, or I didn't get this. Well, you have rights, but your landlord has rights too. And let's be fair across the board. You know, I felt the young man's passion about being a landlord and having, you know, housing market is tough right now. It's hard to find a place to rent that you can afford 30% of your income or 60 to 80% AMI. You're still talking $1,100, $1,200, $1,300 a month. So, you know, we just take this information back and go to our neighborhoods, go to our people and talk about what we've learned today. I hate I missed the first part, but I had another meeting this morning. So Yvonne, thank you for the invite. I'll go back and listen to the first part, but this has been great of what I heard.
You thought you were gonna hide from me.
I'll make this quick. I came here, same thing. I just came here to learn about stuff. I think complex problems require really creative solutions. I think this is a great space that you guys have created to start that. And I hope you guys continue that conversation to figure this all out.
I have the most important question that's going to be asked today for you, Dr. Duckett. When's part 2? You don't got to answer right now. We'll give you 14 days.
All right, I think I got everybody, Dr. Duckett. That means it's your turn.
Okay, that makes me feel wonderful, great. My takeaway is that you have takeaways. And my advice to your takeaways is to become a doer. You know, the Bible tells us to not just be hearers, but doers of the word. So yes, please take this information back to your communities, back to your organizations and apply them. Greenville County Human Relations, we practice fair housing every day. We just celebrate this big event here because it's Fair Housing Month. But we have issues every day where we provide assistance and we provide advice to both landlord and tenants. But you're right, this year we wanted to highlight the landlords. We always hear from the tenants. They always come and tell us what the landlords are not doing and da 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 da. And we know that there's always two sides to a story. But one day I was talking to Chantel, I said, we need to bring these landlords together because they have issues. I mean, they have challenges, they have roadblocks. Let's hear them. And so, yes, I hope that we can continue that conversation with the landlords and all the other powers that be, because it's going to take a village to bring this together. I'd like to remind you guys to please complete the surveys, all of them. This is the only way we're going to have another event like this. We have to have the surveys to see how well or not well we have done for today. We had between 40 to 50 viewers on our virtual screen, and I'm happy for that. I know you guys are still there. Thank you again for joining us. Again, we will post. We will post this event on our YouTube video channel, and you can find that link in the CVent application. Also, we encourage you to follow us on Facebook. We post a number of information, videos, other things that you may be interested in on our Facebook. So please find our Facebook, like it, and share it. We would love for you to do that, okay? Let's see. I think that's all the things that I had. Are there any other questions or any other comments that you'd like to make? This event has been somewhat massive for us because we decided to do the dual or the hybrid. And for those of you who don't know, it's a lot of work, I'm telling you. So I'd like to take this time to thank my staff. They have been awesome. Please help me give them a round of applause. Please help me give them a round of applause. Thank you so very much, staff. They pitched in, they did whatever they needed to do. And I'd like to recognize Martin. He is the coordinator for the Fair Housing Program. Thank you, Martin. He has done a fantastic job. That's why we have been so blessed with receiving that grant each and every year. So continue to be as good as you think you are, Martin. Okay, if all hearts and minds are cleared. Okay, please make certain before you leave, we have another little gift for you. Please indulge, take it with you. And if there's anything that we can do for you at any time, please let us know. We're going to continue doing workshops. We want to meet with you to see how we can collaborate with you, to partner with you. And so we're looking forward to that. Again, we thank you and have a great evening. Thank you so much.